Okay, good morning, everybody. For those online, it's 8 o'clock, 7:59. Again, I don't have 15 minutes. Well, actually, we're going to give Jeff Buman from SWAP the majority of the time. So we've still got a couple people that are out in the hallway. We'll start in about 2 minutes. So those online, we'll give you just a couple more minutes because we want to start right at 8:15 with Professor Mangrum. I know you hate this. May 29th, or 28th. I can't even get my dates right. The end of May. Okay, that's the only announcement I have. I'm going to turn the time over to Jeff. He's our executive director of SWAP, and he's going to share a couple of things, and then I'll come back up and introduce Professor Mangrum.
Good morning. Yeah, this morning I just wanted to cover a few bills lightly that Tyson covered yesterday. I think it was Tyson covered them. I'm not sure who did, but the things that are important going forward. One is House Bill 354, the data bill, and this particularly applies to the county and city attorneys. This bill looks a little draconian, and it is to a certain extent, but from the perspective of the legislature, they want to know how to make good policy legitimately. And to do that, they want data, which is a legitimate goal. The problem is they don't know what data they need or would help them. So they did not give us adequate time to help them develop that. The county attorneys and a bunch of city attorneys and I, during the session, tried to develop a list of data points that we thought would help drive policy. And some of those data points did get into the bill. Others got into the bill but got mishmashed so they no longer make sense. And many of the data points didn't get in at all. So we may go back and revisit House Bill 354. But the intent for line prosecutors and staff is that your software system, whatever one you're on, hopefully with a few tweaks, will require no additional work. That was our goal as we were creating our data points. Again, the legislature didn't exactly adopt what we recommended, but the idea is that it will require no more work if we can get our data systems to adequately track those items. So the second one I want to talk about is one that Jeff Gray was instrumental in Senate Joint Resolution 8. This is the Federal Rule of Evidence 413. Ryan's not here today, is he, Jeff? McBride? Is he here? Ryan McBride, is he here? Yeah, so Ryan McBride, a prosecutor at Utah County, the kind of story behind this, he was talking to Senator Brammer, who's also out of Utah County, and said, hey, it'd be great to have this rule in the state system. And Senator Brammer said, well, let's run a bill. So he did. And that is a very effective way to work the legislature. For someone who's in someone's district to say to their senator or representative, we got a problem, we need to fix it. They love to run bills for people in their districts. As I think someone mentioned yesterday, I don't know if it was Tyson or Jeff, but that made it all the way through, to our surprise, because we thought the defense bar would really come unglued on that one. But we got it all the way through. Everything was perfect, and it just got hung up at the very, very end on the Senate reading calendar, in part because the legislature has so many bills, it's utterly impossible to get them all through in one session. Unfortunately, we tried very hard to get that one prioritized at the last couple hours, but it didn't make it. But when that comes out again next session, having you help will be critical. I think the defense bar will be more mobilized and will probably oppose it, but we had really great support and we'd love to see it again. There's nothing more effective than to have constituents that want to contact their individual legislators, in other words, you, and say, vote for this bill, it's a good thing. The third thing I wanted to talk about, the third bill, was Senate Bill 318, the prosecutor conduct amendments. Now, when that bill came out, it caused a great deal of consternation, as you can imagine. The first bill draft was absolutely awful. It was draconian. It was going to be the big brother overseeing prosecutors. Now, I will say that what ended up passing, I hope you don't get too offended by this, was basically what the county and city attorneys who were at the legislature thought would be a good idea, regardless of whether the legislature passed anything. As we are able to police ourselves as prosecutors, we look better to the public and we look better to the legislature. So we think we have created a system which is loosely based on what the Department of Justice does. I mean, we didn't make this up. We basically modeled on the Department of Justice's Office of something, I don't know what it is. And we took that model and tweaked it a little bit, and we actually increased the standards to make it a little harder for people to complain about us. And we've made it, I think, as good as we could probably get during a legislative session. So we're hopeful that once that gets implemented, it'll actually help prosecutors in our public perception, that there is an entity out there policing us and ensuring that we do good things. And one of our big goals was to remove the word misconduct, and actually it is removed. It ended up still in the title of the bill, but in the actual bill language and the title of the commission, there's no mention of the word misconduct. Finally, HB 562, pretrial detention. As happens in the legislature, sometimes at the very last minute, a bill gets dropped on us. And that bill gets pushed through very, very quickly. And that's what happened with this one. The last Friday of the session, this got dropped on us on a Friday night. It was a long bill, and the hearing on it, if I recall right, was Monday morning. So we started negotiating that night. Ryan Robinson did a lot of great work on this bill. They had meetings Friday night, Saturday night, Sunday night. By the time we got to Monday's hearing, we thought we'd negotiated it to the point where we were going to be okay with it. So we did not object during the committee hearing. But it turns out we hadn't gotten everything we wanted. So it went through the committee hearing without us objecting. And then we thought, well, it'll go to another committee, so we'll be okay. Well, there's a rule in the legislature that as long as it goes through one committee, it doesn't necessarily have to have a second committee hearing. It's rarely used, but it is used. And this time it was used. And so that bill got through with things that we don't like. So what I'm asking is, we've made huge strides in pretrial detention. The data shows that prosecutors are much more able to pretrial detain our most dangerous offenders. We have really good data now, or pretty good data, that we are detaining the right people now. And we don't want to back off from that. So I would like feedback over the next year. If we're really having problems detaining the most dangerous offenders because of the changes to pretrial detention, SWAP would like to know so we can go back and tweak it again. All right, I think it was Tyson yesterday made a big plug for SWAP, and let me just briefly talk about that. Every year, the legislature seems to run and pass bills that seem to harm public safety. And that's true. It definitely happens a lot. Sometimes for reasons that aren't necessarily nefarious, but it does happen. And part of it is because there are so many bills that we cannot, even with me and Ryan Robinson and Megan Mills, Jeff Gray was up there, we had tons of people up there, but there are so many bills, we can't do everything. You could help us extremely, help us to an extreme amount, improve that. Let me just put one plug in. If you would run for election to be a representative or a senator in your district, that would be the best thing that could ever happen for prosecutors. We have defense attorneys up there that are in the legislature as senators and representatives. We have 0 prosecutors right now. We have 2 police officers. Those 2 police officers are some of our most effective advocates for public safety up there. 1 prosecutor in the legislature would make a huge difference. Now, I believe unless you're in the Attorney General's office, I believe everybody else is able to run for election. And if you have the slightest interest, I think it would be an amazing thing to do. So, Tim Taylor, if you would run for Senate or House and get elected, it would be an amazing thing for not just prosecutors, but public safety. The amount of misinformation that is put out at the legislature is phenomenal. They don't know really what helps and harms public safety. I mean, there are many bills that harm defendants and prosecutors, and many times the legislature doesn't understand. So my plug is, please, someone run. The pay is amazing. You get paid so much, I promise. The second thing is, this year, we have money in SWAP's budget to pay if you are able to come and help with the legislature on a regular basis. So we received money from the legislature because of our advocacy 2 years ago that we can pay part-time a prosecutor or 2 to come up. So this year, we were able to hire Ryan Robinson and Megan Mills to come up 20 plus hours a week and help with the legislature. If you can work it out with your office, we have money to pay you to come up to the legislature and help us. 20 hours a week is kind of the minimum that we would need. But for instance, Utah County was able to accommodate us this year with Megan, and West Valley did it with Ryan. If you can work it out with your office, please approach us, and we'd love to pay to have you come up and help us. It is a very interesting experience, especially if you don't have to put in the 70 or 80 hours a week that I do. If you're just up there for 20 or 30, it's kind of fun. It's a very interesting job. So again, run for the Senate or the House, and if you're interested in working up there next session, please come and see me. Any questions for me? Great, thank you.
Okay, it's my pleasure to introduce Professor Richard Mangrum. He's a professor of law at Creighton University School of Law. Professor Mangrum graduated magna cum laude from Harvard University in 1972 with a Bachelor of Arts degree. He obtained his JD at the University of Utah S.J. Quinney College of Law in 1975, his Bachelor of Civil Laws at Oxford University in 1978, and his Doctor of Judicial Science at Harvard University in 1983. He has been at Creighton University School of Law since 1979 and is the Yosem Endowed Professor, or has been the Yosem Endowed Professor of Ethics since 2000. Many of you have the quintessential treatise on evidence, Mangrum and Benson on your bookshelf, whether you realize that this is the author or not. We are really privileged and honored to have him here. He presented for the Utah Bar last year, I think it was late last year, a couple months ago, however long ago it was, and he was so generous, he provided his email address and his cell phone number. Said, if you have any questions, contact me. And I thought, we have been talking for years about getting him out here, and I just, out of the blue, emailed him, and he emailed right back and graciously agreed to come. He's got some ties here, he's got some students in the audience, and so please join me in giving him a round of applause. Welcome to come and speak to us for the next 4 hours on evidence and ethics.
Yeah, I'm happy to be here. And Utah, my family's and my historical roots are here, and that's why I have a Utah treatise. I just got a notice that they asked me if I want to go to a dinner for, this is my 50th year active member of the Utah Bar, so I've been here for a while. I started out in civil litigation practice in Salt Lake and then decided I wanted to teach, so that's a different story. And I do have some students here. And I also tell that one of the points, and I'll actually address this in the slides. It's not in the slides, but I will put them in there. Utah and Nebraska were similar in that they didn't develop these laws, 413, 414, 415, that dealt with prior sexual offenses, and both in civil and criminal cases. And I lose track of the time. But I drafted ones for Nebraska. I went to a legislative session to try to get it passed, and I had an army of criminal defense attorneys there opposing me, and I explained it to them. So we do have that now in Nebraska. And I have actually talked to the people here in Utah. People have called me up about this. To me, it's an easy, it should be an easy fix. It makes sense. There's lots of reasons why it makes sense. I don't know if you even know the numbers, but it deals with prior sexual evidence in civil and criminal cases. And I will actually reference that a little bit today. I didn't know you were going to mention that. Okay, so here's what we're doing. The people asked me and gave me a list of things to cover, and the list is on the board. But it doesn't matter to me I'll cover these materials, but if you have questions, I'm getting some feedback, aren't I? Yeah. If you have questions outside this area, it doesn't matter to me what areas we cover. I prepared materials consistent with what I've been asked to do. I handed out a little 2-page character evidence thing that will help you walk through analytically a little bit about character evidence as we go through character evidence. And I'll answer any questions. You can stop me at any point in this presentation and ask me questions about either the slides or factual issues not covered by what we're talking about. And if it's interactive, it'll actually be better. It'll be more interesting to you and me. So don't hesitate to stop me. And even if it's outside in a tangential area that you're concerned about, then we'll stop. Okay, so the first thing I was asked to do is talk a little bit about confrontation. And confrontation is, for you all prosecutors, a pretty important thing. You go through confrontation before you go through hearsay analysis. And it's changed and is changing. This is something that has changed and is changing as we speak, kind of. So this is an area, and I'll give you a couple of cases that you need to know. In fact, I would copy 2 cases and have it in my office if I were a prosecutor on confrontation. And so we'll go through it. So I want to walk through, and you can stop me along the way if you want to, if there's something I'm not covering. So the first thing I'm going to address are confrontation, especially I'm going to talk about a fairly new case, Arizona versus Smith, which is a game changer, really. It's a very important case. And changes a lot. So it changes practice and science practice and things. So you could kind of see it coming, but it does change a lot. So the first point is confrontation. So in criminal cases, obviously, you have two questions, hearsay and confrontation. Confrontation is the first. Now, for many years, we had Ohio versus Roberts, and really what Ohio versus Roberts did was track the hearsay rules, the exceptions. And they really said, as long as you're within a well-established hearsay exception and you have circumstantial guarantees of trustworthiness statement, forget about confrontation. And that went along for a long time. And then came along, that's the Ohio versus Roberts case, and then this came along, Crawford versus Washington. This is an analytical change. It's a paradigm change. And it is it's Justice Scalia. Justice Scalia has changed the Supreme Court a little bit in the sense that this is the first case, really, that was used to develop the idea then of originalism. Right, so the Constitution ought to be interpreted consistent with the historical, the intent behind the words themselves. This case it was a confrontation case, but it was also the case under which the concept of historicism or the originalist intent took over the Supreme Court, and many of the justices are spokespersons of that and have changed a number of things, same-sex marriage and marriage and all the different things with regard to rape law. All that comes out of the same analysis. So what the Supreme Court said in Crawford versus Washington is we were doing it wrong. And so they introduced a concept, but they did not explain the concept. The concept was, if it's the out-of-court statement is testimonial, so there's the key word. If it's testimonial, then it's confrontation. You have to, you can't come in if the out-of-court statement is testimonial in context, unless you have special circumstances. Okay, so this is the Crawford case doesn't answer what it means to be testimonial. Following confrontation, we had a bunch of, and I'm going to I won't finish all the slides that I have for you today if I go too much there. So stop me if I'm not getting it, if I'm missing something for you. So originally, when they were trying to figure out what testimonial meant, we had cases like Hammond versus Indiana, which are, it kind of first stopped through. Here's the point of cases like Hammond. If you have, basically, if you have exigent circumstances, you get a 911 call, people are they're dying. You know, people are in an emergency situation, and they're giving you information. And they ask you, even, does he have a gun? What's his name? Do you know the background? Now, all those statements can be used for evidentiary purposes. And the only question is are they confrontation? If that witness doesn't come in court, can you use them? And what the court said in cases like Hammond, as long as you have a non-testimonial purpose that is primary, in this case, the emergency call, and they're trying to fix problems, then you're good. There's no confrontation problem. You're in within excited utterance, and you don't have a confrontation because it's not for testimony, it's for fixing the problem as it comes up right now. That's the Hammond case. So if the primary purpose is exigent circumstances, there's no issue. Then we have a bunch of other cases like Davis versus Washington. In these cases, it's a blend between exigent circumstances and the person's still on the, they haven't caught the guy yet, and they're still asking him questions, but it's not the same thing as an emergency call. They have the person. So they started working towards what has become, let me just skip these and get to the real, I'll come back to these. This is the most important case. All right. There's two cases you really need now. This is one of them. And how many people know this case? Well, do you have it? You all know Ohio versus Clark? If you do criminal work, you got to know this case. Okay, this is the case. You can forget about all the other confrontation cases until we get to Arizona versus Smith. This case interprets all the other cases, and for the first time, by the way, and the only time, really, you had a majority of the Supreme Court on the same context on the issue of confrontation and testimonial. It's the only case. All the other cases were 5-4, 3-3-3. So this case is the case. This is the paradigm case. And if I were doing criminal work, I would have that case. Is it too close?
No, it's too far down. If we move it up a little bit further so you can get the report.
That better? Okay. So the facts of the case are important, and the analysis is also very important. And 6, no dissent, 6 majority, 3 concurring opinions. So this case is your case if you deal with confrontation until you get to expert testimony, and then it's Arizona versus Smith. Okay, so in this case, this little kid's going to school, preschool. And he's coming to preschool and he's all beat up and he's got bruises and things. And so they're asking the kid, how'd you get injured? And he doesn't talk. The first couple of times he's a 4-year-old kid, he's not talking. He just, get out of my face. And then he comes back and he has what it looks like whip marks on his body. And so they ask him, what's going on? And he says, who injured you? How'd you get it? He said, Dee Dee did it. Is Dee Dee big or little? Dee Dee's big. Now, Dee Dee was the nickname for Darius Clark. Darius was a real cool. I can't tell about this case because it's too emotional to me. Darius Clark was a pimp, and one of his prostitutes, they said, we're not making enough money in Ohio. I'm not making these facts up. These are real facts of the case. We're not making enough money in Ohio. I'm going to send you to Washington, D.C. They got a whole bunch of politicians and things there, and they'll pay a lot for sex. And so send her to D.C. And I'll take care of the kids. There's a 4-year-old, and there was a 1-year-old, 1.5-year-old. And this guy's beating up the 4-year-old. And over a period of time, bruises, cigarette marks, whips, marks. So Dee Dee did it. Now, so it's really important on the context too, because in Ohio, as most jurisdictions, the preschool people have a mandatory reporting. And this is actually part of the case, a discussion of the case. So school teachers have to report if they suspect abuse. Physicians oftentimes have to. I have a son who's a radiologist. He has to report what he perceives to be abuse. And trying to get this perfect so I don't get a feedback on it. And so the question is, are they like police officers? Are the child care people like police officers? And is this testimonial because they're potentially maybe trying to prosecute the guy? And so here's what the facts of the case, how they develop out. So when they find out Dee Dee did it, now they suspect abuse, so they take control of the child and they go investigate the home. When they go to the home, there's an 18-month-old little girl. I'm supposed to be a law professor and do this without crying. 18-month-old little girl whose pigtails were ripped out of her head. And she was beaten up worse than the 4-year-old, right? So there are the facts of the case, right? Those facts are important, and to keep in mind the facts because it plays out as you get into the analysis. Okay, so what the court said now for the first time, there's a 2-part test. I mean, you own this test, you own the confrontation clause. Not a very complicated test. You own the test, you can own the confrontation clause. And that is the first test. The person asking the question. Who is asking the question is important. It's relevant. It's not outcome determined, but it's relevant. In this case, one of the things they were talking about, like a police officer, a school teacher is, or a preschool teacher is kind of like, is under the umbrella of the statute requiring reporting. And so they're kind of the first wave, potentially, of prosecution. And they said, what is the primary purpose? It's a factual question. What is the primary purpose? Not secondary purpose. And can there be multiple purpose? What is the primary purpose of the question? Who did it? And so this is a factual issue. And of course, the answer to what the court said is, if a preschool person is looking at this and they're trying to figure out who did it, they're doing it in part to save the kid, make sure that he didn't fall down or whatever the case may be. So if the primary purpose was to take care of the child, no problem, right? And then also related to that, the primary purpose here is to take control of the child, not to prosecute, but they have the responsibility if the child's being injured, they want to take care of the child and take him in custody so that he won't be beat up. Also bound up in this particular thing, their questions led to the investigation of the home where they found the little girl. Now, he was incompetent by age to testify in the case by Indiana statute. So the only way you're going to get, and that's the only evidence they had of the identity of the child abuse. So what the court did when they went through that analysis, they said two questions. What's the primary purpose of the question that's being asked by the initial person, the preschool teacher or daycare center guy? And what's the primary purpose of the person answering the question? So two questions. And of the small child, if they're primarily trying to prosecute, it's testimonial. Does the 4-year-old know anything about prosecution? No. Is he testifying to prosecute? No. He's testifying, he's not even testifying to get the guy off him. He's just answering questions because the nursery teacher's kind of bugging him. All right, so what the court said is, because the question asked it, now, if it's a police officer, so that's ratcheted up one time. If you have a factual police officer asking questions, we're still into potentially the primary purpose is, like Michigan versus Bryant, the primary purpose is to go get the guy. They're still looking for him. They haven't caught him yet. And there's some danger out there. So it's a factual question. You can't phony this up, but it's a factual question. Why are you asking the question and why are they answering? Now on a 911 call, that's the prototypical one, the 911 call is to handle emergency. So 911 calls are they're potentially present sense suppression and more likely excited utterance, and maybe both. And that's their primary purpose, is to fix the problem. They know, and there can be a secondary purpose, actually discussing the case. They know, like if you take a child, for example, to I don't know what your entities are around here, but most cities and places have we call it Project Harmony in Omaha, where kids are abused, they're taken there and they're interviewed and they work through the problems trying to take care of them and see whether or not they have to be pulled from the home and what kind of assistance they have to receive. Okay, that is if they're asking the question there, and if the question is primarily to fix the problem, then we're in Ohio versus Clark, non-confrontational, right? As long as the question's being asked and the person answering the question are trying to fix a problem, it's not a confrontational problem. If they're trying to prosecute, if they're using the evidence to prosecute, now we take one step forward. These are like, the classic is the battery affidavit, right? Emergency's over, they take them down to the police station, sit down, I want to take your statement. Now we're in confrontation because the primary purpose there is to prosecute, right? So this case is the case. You can almost forget about all the other cases, both because they're piecemeal, but also because this one's the only one that has 6 justices on the same page explaining what is testimonial. So if I prosecute, I own this case. I have a copy of that case in my office because that is the case. Now, here's so legal opinion joined by Chief Justice Roberts, Kennedy, Breyer, Sotomayor, and Kagan. There are 2 concurring opinions. Scalia wrote a concurring opinion joined by Ginsburg. You can imagine Ginsburg and Scalia being on the same page. And Thomas wrote a concurring opinion. Thomas has been consistent. By the way, Thomas is a personal friend of mine. His wife was one of my students, and I've loved him for a long time. He takes a lot of heat. He's a very good guy. Anyway, he is an originalist now. He was kind of a clone of Scalia. These two are the people who worked through originalism. And he says what this was historically, what this is, the battery affidavit. So if it's, his focus is on all his opinions, is that if you're taking statements, the police are taking statements like at the police station for the purpose of prosecution, that's confrontation. You can't get that in, right? And so he stayed on theme with that. Still, all these people, no dissents. So this case is the case that you want to know for confrontation. Now, the other case that you need to know, and that's in the light of the end, the question is whether in light of all the circumstances viewed objectively, the primary purpose of the conversation was to create an out-of-court substitute for trial testimony. If that's the case, that's the battery affidavit. If that's the case, confrontation. Otherwise, it's not. We have also recognized the Confrontation Clause did not prohibit the introduction of out-of-court statements that would have been admissible in a criminal case at the time of the founding. Okay, so there's a little footnote exception to this. Even if it's testimonial analytically, according to originalism, there are a couple circumstances where the exceptions are historically passed even apart from confrontation. And those are primarily dying declarations and forfeiture by wrongdoing. So even if it's testimonial, you still may be past that by getting, those are rare cases, so it's not very important to talk about them. Okay. This is the second case, Smith versus Arizona. This is a very big case. This case, I don't know if you've been living with this case, but this case is a huge change. So over a period of time when they worked through, there were a bunch of Supreme Court cases on confrontation, and along comes Williams versus Illinois. And in Williams, what happened was, so people do the forensic testing and stuff. In the case of Williams, it was, it's a rape case. And so they take the body sources from Illinois and they mail it to Florida. Florida had a lab called Cellmark, and they process the stuff and say, okay, here's the DNA profile for the sample. They send that DNA profile back to Illinois, they put it in their system, they get a hit, and they know who it belongs to. And so they used Rule 703. Now, under 703, experts can rely upon inadmissible evidence as long as they're reasonably relied upon by experts in the field. There's the model. And what they said was, the people up in Illinois working through this, they get all the information, they can rely on someone else's work and come up with an opinion with regard to identity, and it's all covered by 703. That was Williams versus Illinois. Now, the Williams versus Illinois, there was some dissent, there was some kicking and screaming about this case, saying it wasn't very coherent. It wasn't a coherent case. It was a practical case, trying to fix a practical problem. And that was the law until last year. Smith versus Arizona, 2024 case. Overruled, didn't distinguish, overruled Williams. This is really important. Whenever you do expert testimony with regard to put your case together, you got to make sure you keep samples of whatever you have so that if the person becomes unavailable, you can retest it. That's how you fix this problem. But the person who does the testing has to testify. The person who does the testing has to testify with regard to the source of the information that came in. So in this case, state what appeared to be drugs and drug-related items. The analyst, Rast, typed notes about the testing materials indicating that the substances were meth and marijuana and signed a report. So we have a lab tech's report, which is what the issue is. Rast was later suspended on a substitute member, and a substitute member of the lab testified of the drug test using Rast's lab work and notes. And when an expert conveys an absent analyst's statements, see, lab report, you're going to try to, I'm using this lab report to come up with identity, in support of his opinion, and the statements provide the support only if true, then the statements come into evidence for truth. Now, they didn't finally answer saying, well, we don't know under the facts whether this was actually testimonial, but it was testimonial under their old model. So they're doing the lab testing for purposes of prosecution. And if they're doing that, then it's testimonial. So if you have an expert, this is the case on confrontation. It's only a year old, Smith versus Arizona. It may change the practices that you have to pay attention to. You cannot use a secondary test analysis to give the identity of what it was. Yes?
If we were to video an autopsy, could an independent expert come in and review?
Oh, that's a great question. Okay, so and part of this is if you have a videotape, now we have potentially original writing and everything else. But when you're doing the videotaping, you have firsthand knowledge of the people who are working through the problem. And so potentially, as you go through the autopsy, you would have some hearsay problems and things, but because they can't be cross-examined. But if you can see it, and you see the lab firsthand knowledge of what you're seeing, it would be like retesting, then you're okay. But if they do something outside the videotape, so if they go to a lab and test it, I mean, like that, then it doesn't work. But if the videotape represents what is being done, so the people who are part of that videotape have firsthand knowledge of that, then they're okay. But as soon as there's a test outside that, it's not okay. So the most important point is your lab techs have to testify. That's the bottom line as to their results that they found when they went through the problem. If a forensic testing expert conveys an out-of-court statement in support of his opinion, and the statement supports that opinion only if true, then the statement has been offered, the truth of the matter asserted is required for the admission of the statement to be barred by the Confrontation Clause, explicitly overruling Williams versus Illinois. Not subtly, they said we got it wrong with Williams versus Illinois. So you cannot use 703 as a bypass to Confrontation Clause. I have a bunch of notes on this, but you got what you need to know. Let me stop and see if there may be some questions on it. It actually dovetails the earlier Confrontation Clause. Williams versus Illinois was aberrational, and it didn't make sense analytically. So they're right. If they're going to use testimonial, this case is analytically correct. Williams was not correct. It was just a practical fix to finish the problem. So part of the problem that you have to have, I had, I've been teaching a long time, 45 years, and I have students all over the place, so I get lots of questions. And I helped someone in Colorado Springs do a murder prosecution. They actually got a conviction. The murderer was 40 years old, right? Where are the lab techs 40 years later? So there are ways to do that, and especially if you preserve the samples of the evidence and someone else can pull out the stuff and retest it, then you're okay. But chain of custody, authentication, really it was a fun thing to help him work with him on it. He got a conviction on it, but it's not easy when you're dealing with people who are no longer around. And that's why we had the Williams case, is to fix those type of problems. This is your case. So if you have two confrontation cases you want to own, one is Ohio versus Clark, and this is the second one. Yes?
So sometimes there's not enough evidence, and our state crime lab will reach out to us to consume the evidence. They say, if you test this, this is the only time we're going to be able to test it. There will be no samples remaining.
Then that you better make sure that lab tech stays around.
If that lab tech dies, is it just, are there
You
no
can't.
options left?
You can't use that evidence because he's unavailable, and it was testimonial, right? So it's a big case. Yes.
I'd be curious. I was at a CLE with one of the U.S. solicitors, Japanese Solicitor General, who was suggesting that maybe you have a second analyst testify from the sort of the raw data that's spit out by a machine. That's less likely.
Okay. Now, say if they have the raw data, they're good. If it's a machine, they're good too, because the machine itself, if they have first-hand knowledge of the machine is not a hearsay statement, because it's not. A hearsay has to be an out-of-court statement by a person, right? So if it's a machine, then you don't have a confrontation problem. The question was if you had a machine doing the analysis rather than a person. All right, do we have a hearsay problem? If the machine is doing the analysis, there's no hearsay problem. Because the machine it's like a radar gun. When you see a radar gun going 75 miles an hour, you don't bring the radar gun into the court and say, I want to cross-examine the radar gun. Because the radar gun is not a person. Hearsay requires that there be a person first step, an out-of-court statement by a person. So if it's a machine, there's no confrontation problem. There's no hearsay problem. There's only authentication
You
problem.
might have an authentication problem that got you to the machine, but
Yeah.
the machine results.
If the information from the machine is there, and also if there's a second lab tech there that has first-hand knowledge, or they're sitting by, which is kind of a recording thing, then you're okay too. Someone has to have first-hand knowledge of the process. Or in the case of machine, there's not even a hearsay problem. Right? So these two cases, if you understand these two cases, then you have confrontation. These are two, and you can skip all the other analysis. I'm gonna go skip that one because otherwise we'll get stuck too long on that. Okay. The second area that I was asked to address is 801 D1 A, B, and C, and primarily the consistent statements. And this is it's a very useful area, and it's a kind of, for Utah, you've had a couple brand new, in fact, one last week, a case last week, decided on this. And so, and when they asked me, they said, well, mention the Green case, talk about the Green case. No, I'm going to talk about the Green case. I'm going to talk about the Green case in two contexts. This is the first one. All right, so the first point, you have a boon as prosecutors that most people do not have with 801 D1A. All right, so in most jurisdictions, under the federal rules, if you're going to use an inconsistent statement, an out-of-court inconsistent statement, it has to be under oath in a prior proceeding if you're going to use it to prove the truth of the matter asserted. Utah didn't adopt that. So, Utah oftentimes adopts the position I subject in my treatise. This is one time where they said, no, we're not doing the way that everyone else does. So I'll give you the classic example, then I'll walk it through. So in most jurisdictions, my daughter, who was a prosecutor in Omaha for a while, one of the really difficult areas to prosecute is domestic violence, as you all well know. And the victims very seldom will want to testify. They want to recant, they want to, or they just don't want to testify. And so in Nebraska, when that happens in the circumstances like that, and then they say, don't call me. If you call me, I'm going to either say I don't remember or I'm not going to give it to you. And you can't call that witness. It would be unethical to call that witness when you know in advance that they're going to change their story. All right, that's what in most jurisdictions that's called the artifice rule, because in most jurisdictions the out-of-court statement would be offered potentially for impeachment purposes only, a non-hearsay purpose, but you can't argue in closing the truthfulness of that out-of-court statement. That's how it is in 90% of the places. So in domestic violence, if the victim says, you know, he beat me up, but then later says I'm not going to testify, you can still call that victim, and then they say it didn't happen, or I've forgotten, or whatever the case may be. You can still get in that prior statement to prove the truth of the matter. You can use that prior statement to prove the domestic violence. You can't do that very often. This is a very rare state, by the way, on that issue. So you guys have it easy. You have it easy, and it's probably how it ought to be done sociologically because of the circumstances of domestic violence. But most states can't do that. So in Utah, if you have an out-of-court statement that's made, doesn't have to be under oath, doesn't have to be in a prior proceeding, which is what's required under the federal rules, they come in court, so you have an in-court declarant, and whatever they say, they can say it happened, they can say I don't remember. Doesn't matter what they say, as long as what you're going to now use something different. The statement, we're going to get the out-of-court statement in because it's inconsistent with whatever they say in court. Now, in Utah, you can take that to closing argument. You have a prima facie case. Most jurisdictions, you cannot. So there's a big difference. In fact, it was one of the few times that the state Supreme Court kind of spanked me in my treatise, State versus Beal. You'll see my name and my treatise referenced there. This is the case that made it clear. So that's a 2021 case. The court ruled that under the Utah's version of 607 and 801 D1A, it is appropriate for a party to call a witness who has made an out-of-court statement that will help the prima facie case, even knowing, you can't do this anyplace else, there are very few places else, even though the witness will repudiate the out-of-court statement. The court in Beal authorized this very tactic. I put this quote in there because it's so unusual. Nothing in the rules prohibits the state from calling a witness the state knows. They're telling you, I'm not going to say that's happened. Even if you know, there's nothing unethical about you calling them. Even though knows or suspects will give unhelpful testimony if the state plans to impeach the witness with the witness's helpful prior inconsistent statement. That's an unusual rule. So if you want to know that, I would wrap my arms around Beal too. Maybe y'all know this. Maybe this is so common to you, you don't even realize this is exceptional. This is an exceptional rule. 90% of jurisdictions do not have this rule. Inconsistent statements come in for a limited purpose, non-hearsay purpose, impeachment. In most jurisdictions, they cannot come in to prove the truth of the matter asserted. Big difference. All right? One, you can't go to the jury. One, you can go to the jury with an out-of-court statement. Right? So this comes in as substantive evidence in Utah. Inconsistent statements, they don't have to be under oath. They don't have to be in a prior proceeding. They do have to be under oath in a prior proceeding in almost all other jurisdictions. So there's the inconsistent statement. Yes, go ahead, Wes.
What about, here in Utah, we've been running into in our office, a lot of defense attorneys having other attorneys represent the wife of the victim in the case, and invoking the spousal privilege in the Utah Constitution, Article 1, Section 12, which says the spouse shall be compelled to testify against another.
Yeah, spousal disqualification. Yeah, and okay, so let me give you a two-part answer. In most jurisdictions, both privileges, both spousal disqualification and both spousal confidentiality are not applicable if the crime's against the family. So in this particular case, if it's domestic violence, they wouldn't have a privilege because, yeah, well, that's the rule. They may not apply that, but that's the rule. So that husband and wife privilege and confidentiality in almost all jurisdictions doesn't apply if it's a crime against the marriage. Either the spouse or the children. It doesn't have to be just the spouse, it could be the children. So you don't have a privilege for that, even if they want to invoke it. The traditional rule, that doesn't apply if it's a crime against the marriage. Okay, so prior inconsistent statements are much easier in Utah than almost any other, and including the federal court, you couldn't do this. So much easier in Utah than most jurisdictions because of cases like Beal and the way that's returned. Okay, that's inconsistent statements. So inconsistent statements are non-hearsay if you have in court, subject to cross-examination, the person who made the statement. And by the way, you know, there is a case, U.S. versus Owens, that's probably another case you want to put in your pocket for this very purpose. In the Owens case, Owens is not Owens is a pretrial identification case. But Owens makes an important point. So this is another case I would have if I were a prosecutor. So in Owens, this guy gets beat up and by this defendant and has some brain damage as a consequences. He goes to the hospital, and while in the hospital, they have basically show up with the guy they think was doing, that's the guy who beat me up. And then by the time they go to trial, his memory, his brain has diminished, so he can't remember who did it. And so this comes under 801D1C. They still call him as a witness, but he can't remember. And then they call the police officer who says what he gave testimony about. That's 801D1C. Now, the reason why that case is important is because what the court says, even though the witness cannot remember what they said before, he's still in court subject to cross-examination. And if he's in court subject to cross-examination, then you have the predicates of 801D1, A, B, and C. So under 801D1, those things, there was a fight when the rules were being adopted originally between scholars, law professor people, about how the definition of hearsay. And so there were two, and some states have adopted the other side. Kansas, for example, has what is called a declarant-oriented definition of hearsay. Under the declarant-oriented definition of hearsay, if you have in court, subject to cross-examination, the person who made the prior statement, you don't have hearsay, right? Because you have the person, you can confront the person who made the statement. So just across the board, it's not hearsay. Now, the federal rules adopted what we live with in most jurisdictions, the federal court, assertion-oriented definition of hearsay. So it doesn't matter for whether it's conceptually hearsay, who's in the court. It could be the person who made the out-of-court statement. The question is, are you offering the out-of-court statement to prove the truth of the matter asserted? If it is, it's hearsay, even if you have the same witness. Now, the Owens case becomes important for the prior consistent statements and the inconsistent statement for this reason. Because when they say, I don't remember, or they just not going to give information about it to understand it, they are available for cross-examination. That's the point of Owens. Once they're available to be crossed, even if they can't remember what was said, you can get in one of these statements, right? So that's a pretty important rule. The Owens case helps bridge the gap with regard to that. So in Utah, prior consistent statements come in, inconsistent and then pretrial identification. Now, there's a couple of cases, the Nunes case. Utah courts, prior consistent statements may be admitted as evidence of truth of what is contained in the statement to rehabilitate a witness testimony, but such statements are admissible only if they were made prior to the motive to fabricate. Now, this is an important point. With prior consistent statement, there's a timing. All right, so other ones you don't have a timing. This one you have a timing. You look at when the statement was made, and if there's a motive to fabricate then you can't get in the prior consistent statement. It's not reliable, right? If the motive to fabricate comes up later, then the prior consistent statement comes in. So it's a timing. Whenever you have a consistent statement, there's a timing requirement. Yes?
Does the motive to fabricate have to arise in trial or just?
No, normally it's before trial. Okay. It'll happen. So, you know, the classic motive, so let's say, for example, you have a conspiracy, and there's 5 people, and everyone, you got all 5, and you try to get one of them to turn state's witness and give testimony. Now they're giving you testimony. This is prior to trial. This is almost always prior to trial. So they give you testimony about, yeah, I was there, but I didn't do anything. Okay, so now you want to come in court and can you get that statement in? No, right? Because by that time, you're working a deal. There's your motive to fabricate. Once you get arrested and you start talking to the police, then you can't get that prior consistent statement in because you've been bought. You know, the argument is the witness has been bought by the circumstances. So this is timing problem. Now there's a U.S. Supreme Court case and there's a state Supreme Court case on this very issue, but Bujan is the state Supreme Court case on this timing issue. Now here's the case that I was asked to talk about, State versus Green. Very interesting case. I don't know if how many people know this case? This is an important case. It actually it's important in several respects. It's a fairly new case, but it's important in several respects. It's a 2023 case. It's a classic. If you want to look at prior consistent statements, this is your case for Utah. All right. So what happens in the Green guy is a professional football player quality at Utah State. And he actually got drafted in the first round of the NFL for a whole bunch of money. Can you imagine how much money professional athletes are getting now? All that NIL money. We pulled some kid out of this area, was playing at Utah State, came back and played at Creighton. He was great. Ashworth from Lone Peak High School. He was a boon to us for a while. Cool kid. So anyway, this guy gets drafted in the first round of the NFL. That's the context. And that becomes important to the case. And the draft and all the highlight of him, newspaper articles come out about this guy's worth a lot of money, basically. And that potentially, that's the trigger. That's the motive to fabricate trigger once that newspaper article comes out. Okay, so as it turns out, this is a prosecution of a bunch of women. And prosecution of Green for raping a bunch of women. And the factual circumstances of the case are very similar, and they become relevant as we go through here. So his name is Tory Jordan Green, was charged with raping 7 separate women while a student at Utah State. All 7 prosecutions were joined in one prosecution. That by itself is very interesting because it was a defense choice, and that became part of the case too, because now you got all this evidence, other act evidence coming in at the same time. Now we have a 404 and B2, which is where we're about to go to, all happening at the same time. And it's very curious that the defense attorney wanted to try these cases together, and the prosecution should be saying, thank you. So anyway, they were all prosecuted together. Defense argued that each accuser was motivated both by money and attention to accuse a famous football player. So they have to know by money and attention that this guy's a fake, And so, and that was tied in part to the newspaper articles celebrating his prowess and also the money he's about to make. After each had read 2 Tribune newspaper articles publicizing that Green had signed a contract to play in the NFL. Additionally, the defense argued that newspaper article provided the victim with the ability to fabricate or copy stories. So, and that also becomes important. So in other words, in the newspaper article, they had the victims were given kind of similar stories. And the idea was that, they were copycatting each other to make the point. And a lot of that information about what some people were alleging was put in the newspaper article. So the date of the newspaper publication provided the timeline, right? So after that, consistent statements, there's a motive to fabricate, improper influence. After that, the statements can't come in. Statements made prior to that come in. That's the point of this case. Okay. So the date of the newspaper, upholding the admission of the multiple prior accusations of in-court witnesses, they have to be in court or we're not even under 801D1A. So each of these people come in and testify. And part of what they testify, they had kind of he had a pattern. He'd get on social media, invite them over, and if we got some, invite them over and then sexually assault them, and even the response is pretty particular. So they would say, no, I don't want to have sex, and he would start to fondle them and doing stuff and say things each time. Each witness is saying the same thing. You want it, and the pattern was pretty clear. And all 7 in testifying. The court explained these accusatory statements made by 4 alleged victims, one in a poem, which becomes important later on, each had made 1 or 2 years before the Tribune article had been published. So part of the argument from the defense standpoint is, once everyone knows I'm an NFL player and I'm making millions of dollars, all the people start showing up saying, hey, he forced me to have sex, he's got to give me money. That's the argument. That's the case theory of the defense, is this was all prompted by the money. So anything prior to those newspaper articles, they don't have the motive, those come in. Anything after the newspaper articles, they don't come in. And that's exactly what the court held in this particular case. Not all the statements came in. But along the same timeline, the trial court had erred in omitting several of the prior consistent statements that were made shortly after. So what they said was, once that article was out, now you have a motive to fabricate. You can't get those statements in. So you have to pick a point, the timeline point, and then anything before comes in, anything after doesn't come in. The court also knows, as a matter of first impression, the prior consistent statement were not hearsay, even if they did not rebut every possible motive to fabricate. State versus Green. So that's a very important case, by the way. If you're prosecution, I'd have that case too. It actually is useful for 2 reasons. One is this, and one is 404, prior bad act stuff. All right, so they were admissible to rebut Dee's case theory of financial motivation, his notoriety, and the allegation that they were all copycatted from looking at the newspaper article and testifying consistent with what everyone said. That they all met on Tinder, some social media, and the person came over to meet him, and they got sexually assaulted the very first date at his apartment, each victim protesting and defendant responding the same way, I know you want it. So there's a whole bunch of particulars that were consistent with it, kind of a signature type crime for the 404B part of it. Now, that case is an important case. That's another one that's really important. This case was just decided, Repshire, I think last week or April 10th. So here's what's today? This is an 8 days old case. This is a brand new case. Similar situation. This is a sexual assault of a minor case brought against a school teacher for sexually assaulting a high school student. I think this was down in Vernal. Defense on cross challenged the truthfulness of the account and suggested that she had fabricated the story years later to get at the teacher for high school pettiness. Fairly young high school teacher that was having sex with one of the students. And the court admitted a contemporary Facebook group chat about the interaction. So as she's having sex with like Monica Lewinsky, she's having sex with Clinton, and she talks to, there's a Monica Lewinsky. The Clinton case actually has a very similar fact pattern to this. So if you remember Clinton being prosecuted for having sex with this Monica Lewinsky, there was a telephone call between Monica and Linda Tripp way back in the beginning that said, pretty famous, so that's kind of a classic. This case is very much like that case. And so the conversation in that case was, the cases are so real, you think I make these facts up. These are real facts. And so Monica Lewinsky says to her friend, hey, I got something I want to talk to you about, but just between us girls. You can't tell anybody. Okay, what is it? I'm having sex with the president. No way, really? Right? There's the conversation. So there's this conversation, well, I got to tell someone, I'm having sex with the president. Then she gets a bunch of details about what's going on. And she even says, look, this may come up later. Maybe she preserved some evidence. So that's why Linda Tripp actually is the one who talked to her. I don't know if you remember this back, but she had some sperm on a blue dress and the DNA samples that would show that they were having sex. That became part of the case later on. So the Clinton case actually is a prior consistent statement where she gets in the prior statements with Linda Tripp. She told Linda Tripp, Linda was taping it illegally, but she said, don't tell anybody, this is just between us, this is confidential. So sister to sister confidentiality rule, no privilege. Anyway, that in this case, this Repshur case are similar. So in the Repshur case, this girl is talking to one of her friends in a group chat. Look, I'm having sex with this school teacher, and no way, and and get all the information. And one of the victims, she put it in her. She wrote a poem. One of the Green victims. So in the Repshur case, cites Green and works through them. So this case, like I said, this is an 8-day-old case, State versus Repshur, and Green are like this. So if you're dealing with prior consistent statements, you have two cases, fairly new, two cases, and they're analytically exactly right, and all you have to look at those to see. So in the case of the Repshur case, they have the Facebook quotes back and forth talking about what they were doing sexually. This was done before the prosecution has been brought or anything else afterwards. Anyone handle these cases, by the way? Anybody here? So you know about what I'm talking. Did I get it right? Okay. All right, so here are two cases, pretty new in Utah, that help frame the prior consistent statement. And if you see those two cases, then you understand. The Green case, I think, is especially useful because it's notoriety, but also because of the timeline becomes exactly what happened in that case. So there were reports both before and after the newspaper article came out. Once the newspaper article comes out, their prior consistent statements, but they were made after the motive to fabricate, so they can't come in, right? The only ones that come in are the ones that were made before the motive to fabricate. I think I'm supposed to take a break sometime. I'm trying to follow your system here. Okay, 9:45, right? Someone's going to have to make sure to keep me on task or I'll never do it. Okay, so these two cases under 801D1A, in this case, 801A, I've already explained, inconsistent. B, consistent statements. These cases are very useful cases to walk through each one of those cases. Now you have pretty clear authority on what you need for prior consistent statements. This one in Utah has caused a lot of litigation, not just pretrial identification, but eyewitness identification generally. Very hot button issue. So the last of the three, so when they were looking at this, when they first adopted the federal rules, they were looking at these pretrial, these three are concessions. So they're sort of fight between assertion-oriented definition of hearsay and declarant-oriented definition of hearsay. And they said, okay, we can't get this resolved, so let's make a concession. We'll go with assertion, but we're going to have three non-hearsay category by example. So these three, we want to come in. Inconsistent statement under oath prior proceeding, prior consistent statements made prior to motive to fabricate, and this one is pretrial identification. The pretrial identification doesn't matter when they were made. So in the pretrial identification, you do have a constitutional overlap with undue suggestiveness, early identification, but the hearsay thing is pretty easy. And that is you have in court, subject to cross-examination, the person who made the out-of-court statement. U.S. versus Owens is the case I told you that. And by the way, in the manuscript where I have in highlights, I should have told you this before, maybe it's not very important to you, but 921, 254, in my treatise, and maybe you don't know I have a treatise, but there's a treatise, Mangrum, Benson, Utah Evidence. I update that every year. That's the page, that's the footnote. So these slides are coming out of that treatise. And those pages will change. Every year I read every case that's decided by your Court of Appeals and your Supreme Court and update the treatise. I also update the treatise if people ask me good questions that I can't answer, and I'll get some stuff, I'll answer it and put it in the next treatise. And by the way, you can call me. I'm available most of the time. I'm a real boring guy. I go to work maybe 6:30 in the morning, and I stay there till about 8. And I have students in my class, a whole bunch. But 402-960-5186, 402-960-5186, that's my cell phone. I talk to attorneys every day and judges. 402-960-5186. Or just mangrammccreighton.edu. Anyway, pretrial identification testimony is one of the controversial ones that we have a little bit because it's an overlay with due process. So one of the first questions on that pretrial identification is whether or not the identification is unduly suggestive. The original identification is unduly suggestive. If it's unduly suggestive, then the prior identification will be kept out by due process. But subject to due process, then you have the classic thing is the lineup, now the folder array lineup. As long as it's not unduly suggestive, someone goes through and makes identification, and now we come in court later on, even if they can't remember. We had, and I only give you true story facts, but we had one of my students that I loved a lot. There was a woman, law review editor-in-chief. She stayed late and was leaving law school late, and she got out to her car. She got kidnapped, and taken to some apartments and raped at knife point. And Nebraska did not initially adopt this non-hearsay category. And so then she goes from that to the police. She survives. She goes back to the police, and she goes through the mugshot book with known sexual offenders. He said, there's the guy. Are you sure? Yeah. I'll never forget the guy. That's the guy. And they said, oh, that's interesting because that guy's wanted in 3 states. I'm not making this up, for rape and murder, right? And you're lucky most of the time he murders his victims. And so there's your first identification. And then about 2 weeks later, she's driving to law school. He drives by in a car. They can't find him. You know, they're looking for him. They can't find him. Second identification. So she identifies him and the car and the license plate. And then they arrest him. Now they bring him down to a lineup. The lineup has to be unduly suggestive, you know. So third time. So she's identified him 3 times. Now in Nebraska, you can't get that evidence in, but every other place, now you can. I actually told the unicameral this rule doesn't make any sense, and they changed it. But all 3 of those things, you have to call the victim. She doesn't call their hearsay. You have to call the victim to testify. If the testify says, I don't remember anymore, it still comes in. right? So they come in under 801 D1C. Right? As long as you have in court subject to cross-examination the person who made the prior identification testimony, and you can establish that, whether they remember or not. That's the Owens case. I don't remember. Whether they remember or not, and whether or not they can be an effective cross-examination because they don't remember, doesn't matter. You have in court subject to cross-examination the person who made the identification, and the out-of-court statements come in, and there's no timeline like the consistent statements. They just come in to prove the truth of the matter asserted. Right? So that's an important hearsay exception. And then, you know, whenever you do identification, you got to put an asterisk by it and worry about due process, because the pre-identifications cannot be unduly suggestive, or the testimony won't come in. And on a separate thing, the Clopton case came out of Utah. Very good case out of Utah. The Clopton case dealing with the reliability of eyewitness testimony and expert testimony. As a consequence of that, Utah adopted 617. So sometimes you have experts come in and give testimony about the reliability or unreliability of eyewitness testimony. And so that's a separate question as to whether or not how much weight you can give to eyewitness testimony. And Utah adopted 617 in response to the Clopton case. And that has become a statutory issue in Utah more than any other state. All right, so that's my first assignment, is to go through those. All right, I still have a half an hour before on my schedule, I'm supposed to take a break. Good. Okay, so now, second subject you asked me to talk about would be character evidence, 404. Well, all the 404 rules. At the very beginning, they mentioned the 413. Under the federal rules and most jurisdictions, they have rules that Utah, I've always been surprised that Utah doesn't have these rules. But they weren't adopted originally, that's why historically they don't have them. But so the 413, 414, 415, Utah never adopted. Utah later adopted and put in under 404C, the child molestation case. That's a form of the 414 rules. Okay, so character generally. Utah's Supreme Court has kind of bounced around in this area. They have never really landed where they feel comfortable in identifying. The biggest problem is the 404B2, which we'll talk quite a bit about today. Okay, so here's a general rule. I tell my students, you can't use bad guys evidence in there. So you bring someone in to try and you want to tell the jury, that guy's a bad guy, right? So you got to send that guy away because he's a bad guy. That's 404. And 404, the primary rule under 404A1 is that evidence, which is character evidence, is inadmissible to prove conforming behavior. You cannot use propensity evidence. That's the general rule. You can't just say, this guy's a bad guy, put him away. That's what's excluded by 404A1. Now, the criminal defendant, not the prosecution, and not even a civil defendant, the criminal defendant can roll the dice. Bad choice most of the time. All right, the criminal defendant, and if they do, you ought to be cheering because that's a bad choice most of the time for criminal defendants. So the criminal defendants can do two things. They could put their own character at issue, and they could put the victim's character at issue, unless it's a sexual assault type case. Okay, so under 404A2A, they put their own character at issue. Under 404A2B, they can put the victim's character at issue subject to Rule 412. Homicide case, state can offer victims peaceful character on direct. We'll get to that in a minute. All right, so then under 404A3, witnesses' characters are, if it goes with credibility, you go to a separate set of rules, 607 and 609. And if it is excluded, all the litigation's under 404B2, and that is for a narrow purpose. And that's also the Green case. Now, Utah adopted this rule 404C, which is somewhat functionally the same as the rules under the 414 rule under the federal rules of most states. So you can get in is an exception. You can get in the fact that the person is a pedophile in under 404AC. Okay, here's the rule. Conforming behavior or propensity is not admissible to prove conforming behavior. Here are the exceptions. The criminal defendant may choose to put character at issue if they open the door. Now I'm going to give you a broad overview, and then I'll go through some of the specifics here. And I'll give you there's a case in Nebraska I'd like to use because it's so perfect for this analysis. It's a case called Faust, F-A-U-S-T. And the criminal defendant in that particular case called me up shortly after the opinion was decided. And he says, "You told me not to do this, didn't you?" And I says, "Yeah." "But I did anyway." And I says, "Yeah." And I says, "You were stupid. It didn't make any sense." All right, so I'll give you the factual thing to make the point here. Okay, so in this particular case, there was a woman who she wasn't happy because her husband was having an affair. Most women are not happy when their husbands have affairs. And not only was she not happy, but she was very aggressive. She shot a gun at her husband. She tried to drive him in front of people. She threw an iron at his head at a family party. She did a bunch of aggressive acts towards him because of she was not happy with him. She eventually trailed the girlfriend out into the country one night and stopped her, killed her, knifed her to death, and then set the car on fire. And there was a farmer close by. The wife says, "Hey, something's going on out there. Go out and investigate." And I'm not going to go out in the middle of the night. And so go out there and just check it out. So he goes out there and he sees this woman who's not quite dead. She's moaning. She's all bloody in the car. She tries to pull him out. He tries to pull her out. And she's still there. Shannon Bloom's still there. Kimberly Faust was there. Shannon Bloom's the one that's dying. Anyway, kills the farmer too. It's like double homicide. Now, in that particular case, the defendant made a bad choice. And the bad choice was to use 404A1, to put their own character at issue. And so she called 5 witnesses. And I'll just talk about one but to make it easier. But she called her minister, her priest, and said, now whenever they do this, by the way, whenever they use 404A1, the criminal defendant does, they have to go through 405A, which is important. 405A is only reputation, opinion, no specifics. So what 405A does is this. They say, "Do you know this person?" "Yeah, I've known her since she was christened." "What kind of person?" "Sweet, kind, non-aggressive," right? All reputation, opinion, testimony. "I have firsthand knowledge, my opinion. I know my congregation, and she's known as being very kind, non-aggressive type person." That's what a criminal defendant can do. They can call that witness to say, this characteristic, violence, is not consistent with what I know about this woman. Right? That's the 404A1 exception for the criminal defendant. Here's why it's a bad idea. Most prosecutors should be really happy. They have a hard time sitting on their chair if they do that. Because 2 things can happen. The first one is called the Michelson cross-examination. Very important U.S. Supreme Court case. So the Michelson cross is legitimate. It has to be done in good faith. You have to have good faith to be able to do this. But the Michelson cross is, you say she's nonviolent. Were you aware she shot at her husband? She threw a knife at him. She tried to drive him over at a family picnic. Each one of those questions. No, I think the husband just made all that up. And she goes through bam, bam, bam on cross-examination, talk about all these violent acts against her by the wife against the husband. Michelson cross, that's appropriate. If it asked in good faith. You have to have good faith for those questions. That's a Michelson cross. Michelson cross comes up here, and it also comes up under 608A. So we'll talk about that for character witnesses as well. That's a Michelson cross. Michelson cross, if you have good faith, you can ask questions. If they say they're non-aggressive, bam, 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 ask them question on cross-examination, and then you're done. You can't introduce. Now, in that particular case, the Faust case got reversed for this reason. This is prosecutorial mistake. Don't do this. So the prosecutors were kind of annoyed because the minister was saying no, and that I think this was all made up, and the husband just did all this and everything else. And they had proof that every one of those acts occurred. So in rebuttal, they introduced the evidence that that every violent act that they suggested on the Michelson Cross actually was true. You cannot do that, by the way. That case got reversed for that reason. So don't be greedy. If you do one of this, if someone puts their character at issue and you cross-examine on specifics, which is what this is, you're done. You cannot prove the specifics. You have to have good faith for the specifics, but you cannot prove the specifics. And in rebuttal, they called witness to prove every one of those aggressive acts. You cannot do that. That's a violation of the character evidence rules. So the Michelson Cross allows you to cross, and second point, you can can call now for the first time, they've opened the door, you can call a character witness that is the mirror image of the first one. I know the woman, yes. What kind of woman is she? Angry woman. Reputation, opinion, testimony only, no specifics. Right, so that's the form. And this becomes relevant. The only time specifics come in with prior bad acts is under 404B2. We'll spend a lot of time on that. So what this rule allows is the criminal defendant can put his or her character at issue, and they can put the victim's character at issue unless the victim is a victim of a sexual crime. And then you have to go to a different set of rules. So they can make a choice with regard to themselves and the victim. A criminal defendant, not the state, criminal defendant can do that. If they do that, they open the door for two reasons for you. One, Michelson Cross. Two, for the first time now, you can call a rebuttal witness, and the rebuttal witness will give you a opinion, reputation, testimony, violent woman. No specifics. Right? Everyone see the pattern? Maybe you all know this is easy for you. But that's an important pattern to see involved. Okay, that's the 404 use. Okay, now, the 412 limitation is the criminal defendant cannot put, if it's a sexual assault type case, being sexual crime, they cannot put the victim's character at issue. And that's the rape shield law. That was actually one of the first amendments. One of the very first amendments to the federal rules of evidence was the 412 rape shield law for policy reasons. 412 trumps the 442B with regard to the victim if the victim's one of sexual assaults. All right, now, if they put their character at issue or the victim's character at issue, they can only go through, by the way, and this is where a lot of people don't know when they foul this up, they have to go through 405A. 405A doesn't allow specifics. All it allows is reputation, opinion, testimony. So if you take advantage of, if the criminal defendant and of himself or the victim, they have to go through 405A, which has to be, all the testimony has to be reputation and opinion, no specifics. And that's the form of 405A. You can cross on specifics. You cannot give the opinion. The reputation opinion has to be in generalities. That's the 405A rule. The Michelson Cross, it doesn't really matter very much, but this is, if you want, I would actually, if you involved in this case, I would actually have this as a case too. Put this in my case file. I tell my students oftentimes, if you're a trial attorney, you want to have a little folder. And in the folder, you want to have some cases on issues that you think are going to come up. And if they come up, not only do you make the argument, here I have a case right on it, you can show them the case. And this may sound a little bit okay. A lot of judges have my treatise on their desks. And if you cite to the treatise and you cite to an area of the treatise and give them an example, that's also similar to that. Because if the judge has something in writing, they want to have something other than you to illustrate the point that you want to make. This is a case I would have, the Michelson Cross, because it comes up under both 404 and also 608, I would have this case. Because this allows you to cross-examine a opinion or reputation witness, whether it's under Article 4 or Article 6. You do it under Article 6 for credibility. You do it under Article 4 for propensity. Either one, this case says if they open that door, then they have to live with it. They have to live with the Michelson Cross. That's the cost of doing the open the door up. Okay, now, and I've given you a little handout that kind of walks us through. This is a common law doctrine of specific contradiction. People kind of worry about this, get confused about it. I told you about where that case got reversed. On doctrine of specific contradiction does not allow you to prove the truthfulness of the Michelson cross, either under 608 or 404. You cannot prove the truthfulness of the Michelson cross unless they're the ones who brought it up. In their own case, they're to open the door on their own case and made them more righteous than they actually were. So a drug case, this is part of the facts of it. So a drug case, they say, you do drugs? No, I've never dealt drugs. Okay, now that's character evidence, but in their own character evidence, it's actually inappropriate character evidence because it's specifics. And that's the actual facts of the case. And then under the doctrine of specific contradiction, they open the door. Once they open the door, you can attack on specifics because they're the ones who said, I've never done it. So this is what's called, is a common law doctrine, the doctrine of specific contradiction. The doctrine of specific contradiction trumps the collateral evidence rule, which is also something that most people don't understand. So there are two common law doctrines that if you're a prosecutor, you've got to own those. You got to understand those. And the collateral evidence rule just simply says, the Michelson cross, you're done. You can't introduce extrinsic evidence to support the basis of the Michelson cross, unless they're the ones who brought it up originally. If they bring up something originally, then you can match that as they get in there. In this case, this is the Walder case. This is the doctrine of specific contradiction case. Most people don't know this rule, but if you're a prosecutor, you should know the rule. And maybe you already know the rule. Maybe this is kind of boring to you all. Walder versus U.S., 1954. Now, Mr. Walder, before we go any further, I want you to tell the court and the jury whether or not referring to informants in this case, but whether you have ever sold narcotics to anyone. Ever sold narcotics to anyone. Character evidence, specifics. Can't ask that question. That would have been, they could have objected to that question. And they don't object, maybe purposely. Open the door to invited air. Once they've said, I've never sold any narcotics to anyone else, now specifics, doctrine of specific contradiction, not only can you show this guy is a druggie, but also you can show specifics because they're the one who opened the door. I've never, this is invited air. Once they say it on direct, not on cross, you can't ask on cross, have you ever sold drugs before? You can't invite the air on cross. It's got to come up on their side. So if they make themselves better than they ought to be, better than they actually are, then they've waived the doctrine of collateral evidence. So this is called the doctrine of specific contradiction. This is the case also I probably, if you don't understand what I'm telling you, look, I'm a law professor. These are a little particular. To me, if you're an attorney, if you're a prosecutor, you got to own these rules, even though they're a little bit obscure, because they do come up and they are real. And if you don't see them, then you don't understand them. So the Walder case, I would copy that case too. This is a common law trump of the collateral evidence rule, doctrine of specific contradiction. On cross-examination, response to question by government counsel making reference to direct testimony, petitioner reiterated assertion he's never purchased, sold, or possessed any narcotics. Over the defendant's objection, the government then questioned him about heroin capsules unlawfully seized from his home in his presence back in February, and goes into some details. And they're impeaching their testimony. And what they said was, this is where the doctrine of specific contradiction comes out of. So it's a common law doctrine. It's a U.S. Supreme Court case identified, Walder versus U.S. That's the doctrine of specific contradiction. Okay, and self-defense has become confusing, and actually the Utah Supreme Court changed their prior rulings based on my treatise, my suggestion of the treatise, and cited the treatise to make the change, to explain it. So 404A1 and 2 permits the criminal defendant to put either his or the victim's character in. If admitted, the evidence should be limited to opinion or reputation testimony. Okay, I'm getting close to this. Specifics arise, if anything, on Michelson Cross. The defendant claiming self-defense does not put the defendant's or victim's character at issue under 405B. So why is that important? Under 405B, there are circumstances where 405B applies. What 405B says, if character is one of the elements of the case, primarily in civil cases, Like, for example, in a family dispute in best interest of the child, the issue is character. You know, where should you put the kid? Right? So if character is one of the issues in the case, then 405B it comes in. Why is that important? Because then you can use opinions, reputation, specifics. Right? Negligent entrustment case, right? Then the whole case is, should they give him the keys to the truck driver if he's a drunk driver? Right? So now his character is one of the elements of the case. If the character is one of the elements of the case, you go through 405B. 405B allows you to use opinions, reputation, and specifics. And you could do it on direct. You don't have to wait for the other side to do anything because it's character at issue. This can come up in criminal cases, doesn't often come up in criminal cases in the context of extortion and other cases like that. You can also put the victim's character at issue. That's 44A to B. And they come in for that narrow purpose. All right, so prior specific acts are not permissible to show conforming behavior, the general prohibiting character evidence. Here are the exceptions, 404B2. And I'm finishing actually a few minutes early, but because we're about to launch into the more difficult material that's all interwoven, let's take our, what do we have? Let's see what it says. Okay, let's take a break, 10-minute break right now, and then when we come back, we'll go through prior bad acts. So I don't want to start that and then jump into it. So we'll take a break now for 10 minutes, and then we'll do prior bad acts.
Thank you for being here, Professor.
There we go. Thanks, Bill. Okay, if we could have everybody take their seats again, and we will get started.
This is the 404B2. This is where all the fights are, and this is where all the cases are appealed. Prior bad acts for a narrow purpose. So under 404B2, propensity evidence, which is excluded under 404B1, you can't get in bad acts evidence. 404B2 is where all the cases are and all the fights are. And the Utah Supreme Court has been bouncing back and forth. They've been kind of schizophrenic on this a little bit. And so it becomes confusing. There's more of a coherency thread than it appears based on their rulings. And this is true for a lot of jurisdictions. Utah, for whatever reason, have become at different times kind of mesmerized by a case or a rule, and then they stay with it for a while, and then they say, well, we were thinking, let's get off that. And, okay, so 404B2 is where a lot of you spend a lot of time. So a lot of times when you have a case and you trying to show that this person's this person's connected to the crime circumstantially, and you can't get in the fact he's a bad person. And so you have to work through 404B2. Under the federal rules, you have to give mandatory pretrial notice. That's amendment to the federal rules. Utah, they have to give you notice before you have to give it to them. You know, and I'm not a prosecutor, so I'm just take it for whatever it's worth. If I'm a prosecutor, I give them pretrial notice through a motion in limine in advance, whether I'm required to or not, because it's the right thing to do, and it gives everyone a chance to look at it, and it looks like that you're ready to go. So you prepare your 404, your motion in limine on your narrow purpose and get ready for it and file the notice motion in limine, even though you're not required to. But there's no advantage of really bushwhacking people in trial in the middle of the thing and having a bunch of fights over all this stuff. Get it resolved early on. It will help you also to frame your case, to know what you're doing with the case. It also will help you in case they may open the door. Oftentimes, criminal defendants open the door in this area. And that's what the Green case is in part about. All right, so on request, in Nebraska, in Utah, you have to request it. How often do they normally request that? Just a matter of common thing. So to me, it would be the good people are going to be asking anyway, and the weak people you don't want to beat up on anyway. I would just file. If I'm ready, I'd file my motion in limine when I'm ready, whether they ask or not, and go through this analysis. It will help you frame your case and decide what you're doing, and also will help you pay attention to when they may open the door otherwise. This case, which the Utah Supreme Court adopted, is a very important case, Huddleston. You all ought to know Huddleston. Why is it important? Because what it does, it explains that 104B, the 404 issue about the prior bad acts, whether the prior bad acts occurred, is subject to a conditional relevancy standard. What does that mean? It's important to know the difference between 104A and 104B. 104A is where the court makes a preponderance finding that, whatever the predicate acts are, the foundation. So the classic 104A is things like privilege or like Daubert. A Daubert motion is a 104A motion. And under 104A, the court makes by kind of a preponderance finding whether or not it's sufficiently reliable to get in. So whether the prior bad acts ever occurred. So under both the federal rules and under the Utah rules, the Huddleston case is the federal case, and the Lucero is the Utah case. So in State versus Lucero, the Utah Supreme Court rejected both a clear and convincing standard, which, by the way, is a standard Nebraska has. So if you're going to try to get in prior bad acts in Nebraska, you have to establish them by clear and convincing evidence. Or a preponderance, more likely than not. For both Utah and under the federal rules, you go all the way down to conditional relevancy, a jury issue. That's the standard. How confident do you have to be that the prior bad acts actually ever occurred? Condition relevancy threshold, jury issue, enough to give it to the jury. That's what Lucero said, and that's what Huddleston said. Both those cases are exactly the same. In fact, Lucero adopted Huddleston. And that's a huge advantage for the prosecutors, because then all you have to establish is that a reasonable juror could find the prior bad acts occurred to at least have an argument why they should come in. The on request requirement, I suggested already it should be a motion in limine, I think. Here's the Utah Supreme Court. This is ones they started, they stopped, they started, they stopped. But I think all these cases are useful, even though they're not the standard. Shickles, for a while, was the standard. And Shickles had, everyone wants a checklist. My students always want a checklist, right? And Shickles gave you a checklist. And so people say, that's pretty cool, we have a checklist, so we just have to answer those questions with regard to whether or not they fit, whether or not it's going to be admissible under 404B. And I'll go to Shickles in a minute. DePorto basically said they're presumptively admissible. That's been adopted. Lucero says 403 controls and the Schickle factors. The Labrum case, which is a case that in an area where most of you would probably have used, is what's called the doctrine of chances. The doctrine of chances was the standard in Utah for a while. That's been rejected in the Green case, actually. The Green case overruled that thing. And then Cutler says it should be 403, not Shickles. And then Litzen, under 404C, the accused propensity as a business could be argued in closing, which is a separate question we'll get to. And then in Green, they abandoned the doctrine of chances. Okay, so now, I'm still going to go through these cases for a couple reasons. They're all looking at the same thing, right? They're all looking at the same thing. And that is, we're not offering this evidence to show that he's a bad person generally. We're offering it for a narrow purpose. Now, you've got to articulate what that narrow purpose is. You can't just fake it. You've got to explain why it's relevant. If it's relevant for a narrow purpose, then you got past the line. Now you have to do is show 104B condition relevancy. That's it. Okay, now, under Shickles, they developed this list. This list is no longer controlling, but it's still something to work with. Not because you want to cite Shickles, because Shickles has been overruled, but because the Shickles factors make sense to help you walk through under what circumstances the prior bad act may have relevancy. So number one, the strength of the evidence to the commission of prior crime. Even though it's only a conditional relevancy standard, if you have good evidence that it happened, it makes the judge's heart a little bit softer. So the fact that you have a conviction, a prior conviction, that weighs in favor of admissibility, because one of the questions is, are we going to smear this guy with hearsay statements that are questionable, or do we know for sure he did it? So one of the factors is, how confident are you of the prior bad acts occurred? Number two, the similarities between the crimes. So the more they look like signature crime. In the Green case, which we'll go to in just a moment, in the Green case, he had a very specific pattern. Right? He did the same thing over and over again, kind of boring. Right? He had a pattern, and that's the signature crime. The more it looks like a signature crime, the more you know it's that person, because he did the same thing over and over and over again. So to the extent that you have a whole bunch of similarities, especially if they're kind of unusual similarities, then increase the likelihood they're going to come in. Number three, the time interval that's left between the crimes. We all know under things like 609, if a conviction is more than 10 years, then, it's harder to get that evidence in on a credibility issue. So sometimes with the idea that people repent, they get over it, and so the longer we go, the weaker the similarity becomes. The need for the evidence, how important is it to your case? The efficacy of alternative proof. Do we already have this established through other things? By the way, if you do, then why play around with 404B2 and create an issue for appeal? And then the last one, the degree which the evidence probably will rouse the jury to mastering hostility, the 403 aspect of it. Okay. Clark. Applying the Schickel factors in aggravated murder case and also applying the doctrine of chances. Now, even though the doctrine of chances was overruled in Green, I don't know if you all know that, but it was, and the Schickel's factors have been overruled more than once, you still can look at those for a target, what you're looking for, kind of a benchmark of what you should be thinking about. Not because they're controlling, but because they're relevant and they make sense intuitively when you're trying to prove what's going on. And in the Verdi case, where they went to doctrine of chances, you can get to the same result as the doctrine of chances just by going through 404B2. But there was a law review article written some time ago about the doctrine of chances, and people got kind of mesmerized by it because everyone's trying to figure out an easy fix to get around 404B2. And so in this particular case, the Verdi announced that when the evidence is offered in contemplation of doctrine of chances, 4 alternative requirements should be replaced as Schickel's factors. Now, even though the doctrine of chances has been overruled, and even though Schickel's factors have been overruled, they just push it back to 404B2. The rationale behind the doctrine of chances still makes sense. And the checklist in the Schickel's case, they're not controlling, they just give persuasive authority that makes sense. First, the issue for which the uncharged misconduct is offered must be in bona fide dispute. Second, there must be some significant similarity between the charged and uncharged incidents to suggest an increased likelihood of coincidence. Third, each accusation must be independent of the others. And fourth, the defendant must have been accused of the crime suffered an unusual loss more frequently than the typical person endures in such loss accidentally. There is a couple of cases where they actually did the statistical analysis, which made it doctrine of chances. So in Verdi, they went through and said the reasoning starts with the low baseline. Verdi has been overruled, but I'm using this still to argue the probative value of 404B evidence. The reasoning starts with the low baseline probability that a man would take a horse by mistake or that an innocent person would be falsely accused of sexual assault. In that particular case, they actually had the statistical numbers. The second step in the analysis considers the effect of those already low probabilities of additional similar occurrences. As the number of improbable occurrences increases, the probability of the coincidences decreases, and the likelihood the defendant committed one or more of the acts increases. An innocent man may be falsely accused or suffer an unfortunate accident, but when several independent accusations arise or multiple similar actions occur, to objective and probability the accused innocently suffered such an unfortunate coincidence decreases. At some point, the fortuitous coincidence becomes too abnormal, bizarre, implausible, unusual, or objectively improbable to believe. Now, that analysis has been overruled. It hasn't said it's not relevant, it's just simply that's not the standard any longer after Green. The reasoning still is the standard, not the case, but the concept that the evidence that you have is useful and relevant, and it's more relevant the more distinctive it becomes, and then you work through some other things. So there were a bunch of cases like Lamu that worked through the doctrine of chances and applied that, or the Schickel's factors. There's a bunch of this. This is one of my favorite cases because it kind of plays on the doctrine of chances, State versus Murphy. Admitting under the doctrine of chances the testimony of 4 different women over 3 states over the span of 16 years. So they came up with these statistics. These would be statistics, they would be hearsay, but they could fit within, they could be resort to sources whose accuracy can't reasonably be questioned under 803, 18, or 17. There's a 1 in 10,000 chance of a person being arrested for rape or attempted rape in Utah. Most people are not arrested for rape. The probability of being accused of or arrested for rape or attempted rape was 1 in 4 million. There was once, for twice, there was, for thrice it's 8 billion, and 4 times 16 trillion, 5 times was 1 in 32 quadrillion, right? So all they're doing is playing on the doctrine of chances. They're talking about probability. People ask me if I bought, lottery tickets and things come up, and I said, no, I have just as good a chance of winning the lottery you do, and without buying a ticket, right? And they say, well, that doesn't make any sense. Well, yeah, it does make a sense if you do the numbers, right? And when you get down to 32 quadrillion, someone's going to win, But 32 quadrillion, you'd have to go to some other planets. But the whole point of this Murphy case is other acts repeat themselves, and they're unusual enough. It's not going to happen very often. This state versus Heath, I think, is one of the clearer case that makes the point. So this chiropractor is charged with sexual assault, and he's doing his chiropractor rubbing, but he ends up going to the wrong places, and so they're rubbing the genitals of the women patients during treatment under the doctrine of chance and say, "Oh, sorry," and he does this a number of different patients. Right? So then they say, for the average person, the mistaken touching of another's genitals would be once in a lifetime event. Back to the numbers. Look, if he's doing this more than once, not a mistake. This would also come under 404B2, absence of mistake. So this is not a mistake. Okay, here's the case you need to know. This is just, a couple years old. Green. We're back to Green again, the prior consistent statement. Despite our efforts to clarify the doctrine, 404B2, we seem to have generated more confusion than light by using the doctrine of chances. This leads us to conclude that while the doctrine may have been analytically helpful in some cases, it has been confusing and difficult to apply in others. And because we are not convinced that further attempts at elucidating the doctrine will yield greater clarity, we conclude that more good than harm will become from abandoning the doctrine of chances. I don't know if you all have used doctrine of chances and known that it's been repudiated, but it has been repudiated. So the Green case gives you two things. It gives you good stuff on 803 prior consistent statements. It also gives you, it doesn't mean, by the way, that you can't use the same analysis, but you use it in terms of the list. So 404B2 has non-exhaustive list. Absence of mistake is one of them. So you go down, what you do with this character evidence, you walk down the list, find something and find maybe more than one if possible as your category, and then explain how each one of those would bear on it. And the probability analysis is relevant, but it's no longer the standard. Green said, let's not play around with doctrines. Let's not play around with Schickle factors. Let's go back to 403 and 404B2. And 404B2 gives you a list that says such as, so in other words, it's not an exhaustive list, but you have to explain why the prior bad act makes sense. In Green it says, in sum, the rules of evidence provide the evidence of prior crimes, uncharged misconduct, or bad act is admissible if it's relevant to a proper non-character purpose and does not pose a danger for unfair prejudice that substantially outweighs its probative value. By the way, that's the 403, always is the kick out. Yeah, it may be relevant, but it's prejudicial. And of course, and I'm sure you all are well versed in this, but it's prejudicial, it's unfairly prejudicial. Because every evidence that's relevant is prejudicial because it helps build your case. It has to be unfairly prejudicial. And if it's unfairly prejudicial because it's a guess rather than analytically coherent. So if you're going to make it analytically coherent, you have to go through 404B2. You have to work from the examples they provide, and then you can make the arguments why this is relevant for a narrow purpose. Finally, of course, to approve the analysis, the Utah Appellate Court have returned back to this. So another purpose. Your Honor, we're not offering to show he's a bad person, general propensity. We're offering it for narrow purposes. And these are relevant for this, this, this. You have to identify it, articulate it, and give examples of it. And most of the time, you can give examples by way of case law. So case law there's a whole bunch of case law on each of these subparagraphs. In my treatise, and someone asked about this, so I do have a treatise. It's too expensive to buy, but it is online, Westlaw. So if you go to Westlaw, if you have access to Westlaw, you just go to secondary sources. I think it's probably the first thing listed under Utah for secondary sources, Mangrum and Benson on Utah evidence. And that has thousands of cases in it that you need. And every time a case is decided, I look at it, if it's relevant, it's in the treatise for the next year. I update that every year. And so in this area, under 404B2, a whole bunch of cases. And this is because it's so important to you all. This is a rule, this is one of the rules the prosecutors really have to own because it comes up. How many people have tried a 404B2 case? Everybody here asked, it comes up almost always. All right, so this is a rule you have to own. You work from these subparagraphs and also add to it, if it doesn't analytically fit under that subparagraph, quote, such as. So this is analogous to one of the other ones. So you have to have a case theory that makes sense. And then when you do this, by the way, one of the things we'll do, I have to quit at, see, what time do I have to quit? I have to quit at 11:25 because for the last hour we're going to do closing arguments and ethics associated with it. Here's one of the things that you cannot do. All right, and this, I'm going to give you a bunch of cases on this. You can't introduce something for a narrow purpose and then argue in closing something else. Right? You can't say, you can't misuse the evidence. That's one of the classic ways of getting a case reversed. So whatever purposes you identify when you offer it in evidence, narrow purpose, the other side is entitled to a limiting instruction, but even if they don't get a limiting instruction, in your closing arguments, don't argue a closing argument different than what you've offered in evidence, because that would be prosecutorial misconduct. So make sure you match the arguments you made with the arguments for which you're going to introduce it. Now, in the case of things like 404C, that's why in cases like 404C, and by the way, that's one reason why 413, 414, 415 under the federal rules, which have been around for decades, should be adopted in Utah, because there you don't have to play around with 404B analysis. You say he's a rapist, he's a pedophile, right? And if you establish that, you're going to go right to the character evidence trait. You don't have to play around with the narrow purpose. And in the case, especially in 404C, makes the most sense, because the DSM-4 or 5, whatever version you talk about, pedophile is a diagnosed, it is a problem, it's a psychological problem with a certain group of people, and it's a repetitive problem. It doesn't happen just once, it's over and over and over again. And so 404C makes sense because according to the science, pedophiles are repeat offenders, and the jury should know that, right? Because now you have, let's say you have a priest versus, or a Mormon bishop, versus a victim, you're talking about credibility. And if they find out that this has happened a whole bunch of times, changes the calculus quite a bit. Right? So this is really important evidence, and 404C makes sense. To me, I think I mentioned that I had Nebraska adopt 413 through 415, and actually the child one as well, under duress. It was very heated conversation in the unicameral. Okay, so the most important point of all this, work from 404B, the actual words, and if the words don't fit your paradigm, use the words such as. These are illustrative. Here's my narrow purpose. And then you got to make sense. And now the prior bad acts you have to establish by condition relevancy, a reasonable juror could find that these prior acts occurred. And if they occurred, they would be relevant for this narrow purpose. And in closing, the narrow purpose can be used to argue separately. In the Green case, for example, when they suggested copycat stuff and all this stuff, and for purposes to rebut fabrication, which is the same thing in this case I just told you about, with a school teacher up in Vernal. They're saying this was for these reasons. Well, when you have multiple people doing it, it doesn't apply to all of them. Therefore, now we can show to rebut recent fabrication or improper influence or mistake. Okay, so work from 404B2. Don't work from Shickles. Don't work from Green or from Doctrine and Chances. Work for these words. Look at Shickles and look at Doctrine and Chances that will help you understand how to filter them back into these words, like absence of mistake or identity in that particular case. 404B, Rule 4B, narrow purpose that has been upheld is showing similarities of counts of rape to rebut a fabrication defense. The court then elaborated on how the evidence was probative with regard, this is the Sims case, the most recent case here. The court then elaborated on how the evidence was probative with regard to consent, particularly given Simpson's allegation that Susan fabricated her non-consent and the very fact that was prior consensual sex the night before. After noting the lack of other alternative evidence that existed with regard to the consent or fabrication, the court explained that this is part of the Rule 403 analysis. As a result, we see no basis for concluding that this court abuses discretion by considering these factors in the manner that it did. This is the Simpson case, the third case. This is decided just last month, March 2005. Those three cases together really help you, I think, in this particular area in walking through. In this case, fabrication defense, they all made it up to get money from Green. Motive is, so now we go down the list. Motive as a Rule 404B2. Cody. This is an unusual type case, but it can be used. In the Cody case, they allowed the drug addiction, cocaine addiction, to prove motive for bank robbery and the need for cash to support addiction. Kozlik. Bank overdrafts, foreclosure to prove mens rea. Compare Mitchell. You can't just use poverty. You have to show a lot. And by the way, there's a rich body of 404B cases all around the country. Right? So you don't have to limit yourself to Utah, because we're doing this everywhere, both state and federal. So oftentimes you'll find some cases very similar to what you're talking about. They're only persuasive authority, but they are authority. And they help illustrate in more particular some other cases. Pullman. Defendant in Pullman was convicted for sodomy and aggravated sexual assault of a child. One issue on appeal was the misdemeanor prior bad acts of the accused to show motive. The prior bad acts involved his repeated unsuccessful attempts to have anal sex with his wife. The court then divorced, but then considered remarrying as a condition for their. I can't make these facts up. I mean, it's just as a condition for marriage, the wife warned against ever attempting anal sex. Don't even think about it. Don't try. Don't ask. And they used that evidence to show what the motivation, why he had sodomy with a 12-year-old child. Pullman desired to engage in anal sex with someone, and when his wife rebuffed him and turned his attention to the victim whom he'd already sexually victimized. The Pullman case. Battered child syndrome. Whenever you get to children, it becomes more complicated. Court developed a special rule with regard to the issue of intent in cases involving the battered child syndrome. If the state seeks to establish battered child syndrome to disprove claims that the child's prior injuries were accidental, the state must offer expert testimony expressing an opinion that the child's prior injuries were intentionally inflicted rather than the result of accident or mistake. I mentioned to you, I have 5 children. One of my children is a neuroradiologist. He's a radiologist. He actually is called quite often because radiologists, just in response to this type of thing, I'll tell you why he's called. So I'll give you another tidbit that will be useful to you if you don't know. You ever seen evidence-based medicine? You ever heard that term? How many people have heard the term evidence-based medicine? Okay. All right, if you haven't heard it, just look in your computer, just click on evidence-based medicine. And or EBM most of the time, evidence-based medicine. And what you're likely to see is a pyramid, right? Anyone doing it? You see a pyramid? You see it? Is there evidence-based medicine? Is there a pyramid? Anyone sees it? Raise your hand if you see a pyramid. Oh, come on. Someone's going to see it. Okay, you see it? All right, so the evidence-based medicine pyramid ties into this, by the way. All right, so back in 1992, in medicine, we used to do experiential learning with regard to medicine. About 1992, they switched over to what is called evidence-based medicine. And that's the same time Daubert was adopted. You all ought to know the evidence-based medicine pyramid, by the way. It comes up in lots and lots of different cases. All right, so what that really is this. There's a pyramid, and on the bottom part of the pyramid are what are called case studies or incidental things. And then as it goes up, these are how reliable the sources. And as you go up the evidence-based pyramid you get to the top systematic reviews. These are kind of like the industry status thing. Okay, so with regard to things like the battered child syndrome, they've gone up. So you have a lot of, you could get this in, by the way, through 803.18. So you can, through an expert on the stand, you need an expert to get 803.18. You can also sometimes get in 803.17. So the part of the question is, what the heck is a battered child syndrome, and what are the characteristics and everything else? Well, they have, and they developed eventually in things like the DSM-4, DSM-5. That's a 803.17 source, by the way. So if you're working from the DSM, the diagnostic manual, that's not a learned treatise. That's a standard. That's a 803.17 standard. That actually can be introduced into evidence. So when you have something like the battered spouse or battered child syndrome that you're looking at, you can go to the source, like the DSM-4. You can actually introduce the source under 803.17 to establish part of what this is all about. Because they showed a prototype, and they could do it with regard to battered spouse syndrome and everything else. People act in a patterned way when they're getting beat up. And our psychiatrists and psychologists have written all kinds of studies on that. And they're just not anecdotal. The prior bad acts would be anecdotal on the bottom level. But it happens often enough that it moves up the chart until you get to the top, where it's kind of consensus stuff. The closer you can get to the top of the evidence-based medicine pyramid, then the more reliable the evidence is on the very point you're trying to establish. So if you're trying to establish a battered child syndrome, that's a real syndrome that exists in lots of literature, in lots of studies, including the DSM, the diagnostic manual. So if you're working through stuff like that, it's relevant. A battered child, to disprove claims that child's prior injuries were accidental. So what my son does is this. He's shown me a bunch of cases. We're trying to work on a book together. He's brilliant. He's really good. He's going to up my game quite a bit. But he's actually called, he'll see a child with broken ribs. And then he could pull up, right now, I could call him right now and give him a fact scenario. He could pull up within a minute on his phone. Research with regard to the subject matter that we're talking about. And what they do is they have a statistical analysis of the likelihood of a accidental break of a rib of a child in those circumstances, and they could tell you very rare. So almost always when you have a small child with a broken rib, it's almost always intentional, right? And they can show you by numbers, right? Those are all part of the evidence-based medicine system. He's called sometimes to give that information. He said, I don't know about this person at all. All I can tell you about, the likelihood of that rib being broken from like falling on the ground or something like that, are like 1 in a billion, not many, right? So that's all tied into this. So when you're looking into things like the battered child syndrome, you're looking at patterns, not individuals, and you're looking at consistent patterns that we've studied over a period of time. That information can come in to help identify the prototypical behavior of the victim and or the assailant, because a lot of times like a battered spouse syndrome or a child, they've lied, they said it didn't happen, and now you're saying, well, geez, you said 2 or 3 things, the same things. Well, that's all part of the pattern, right? That is the battered child syndrome, is that it's a prototype. Okay, so that's what this is all about. So sometimes that comes in short of getting a 704B, absence of mistake. The evidence showing multiple factually common instances of purposely touching his daughter's breast while licking his neck. I mean, I read these facts and sometimes I'm saying, really? Did I misread that? Demonstrates that his charged conduct was not a mistake. Yeah, that doesn't look like a mistake. Dominguez, I love this case. I used to coach a bunch of soccer and we were invited by the U.S. government, the only team to be invited since 1959 to go play the Cuban national youth teams. And we got over there, we realized they have nothing, right? And but they have a whole bunch of good baseball players and soccer players. And so in this case, U.S. versus Dominguez, The most, when I was over there 20 years ago, the most anyone made legally a month was $24 a month. Even surgeons, $24 a month. You can see not very much water between Cuba and the United States. If you're a surgeon, you get over to the United States. If you're a baseball player, you're almost willing to swim at this point in time. Because baseball players, these guys, Betancourt and Beltran from Cuba, good baseball players. So the question is whether or not he actually intentionally smuggled these people in. Puig is another one in the same category. To whether or not he had intent, whether he was involved in this chain of bringing in professional athletes. Intent to force sex, the Gasper case, 2018. The accused admitted to having sex with the victim, but argued that it was consensual. Surprise, that doesn't happen very much as a defense. The court admitted prior similar acts of rape where consent was previously argued. Here, the similarities between the two incidences suggest a lack of consent, which is also a very similar argument that was argued in Green. In both instances, the victims reported being touched by Gasper under the pretense of a professional massage, being given unsealed alcoholic drinks by Gasper, feeling sick, abnormally tired after consuming their drinks, and waking up to find they had been or were being sexually assaulted. The two incidents represent a pattern of behavior that's so distinct, it's like the doctrine of chance argument, it goes to intent. Therefore, admissible to show intent to consent without, there's a whole bunch of sex cases on this. That's one reason why we need 413, 414, 415. State of mind. If the state of mind of the accused or the victim is relevant, which is obviously in the case like Green where they says, yeah, it was consensual sex, then other acts would be admissible under 404B2 to show state of mind. So in Barney, the court upheld the admission of other acts evidence in a domestic violence and kidnapping case as relevant to the state of mind of the victim because the vehicular assault, strangulation, protective order, and moving vehicle incidents were relevant to show the victim's state of mind, why she did not flee when she had the chance or report the incident immediately after. So she's beaten up a whole bunch, and then he wants to have sex, and she lets him, and the argument was voluntary, and the argument is, yeah, if I didn't say yes, I'm going to get beat up. That's what these cases are about, the Barney case. Bates explained the evidence was admissible because Alyssa described the state of mind of the victim to explain why she was afraid of the defendant. Adesta did not report the incident sooner. The Harter case, holding the victim's state of mind, her fear of defendant was a proper non-character purpose. The Beverly case, consent refuted in domestic violence rape case. First, there was ample grounds for the court's determination. Testimony at trial showed the SB did not physically resist Mr. Beverly's sexual advances. SB testified after verbally refusing, she eventually did whatever Beverly asked her to do. She took off her clothes, she touched him, and did not physically resist sexual intercourse. The question for the jury, therefore, whether the sexual encounter was consensual. In other words, what was SB thinking during the incident? At trial, the state sought to admit Beverly's history of domestic violence, claiming that history was necessary to explain why she didn't fight. Because SB's mental state was a central issue in the case, it's not only plausible the state to show domestic violence, to show that, but it makes the perfect sense. Second, the fact the jury could use domestic violence evidence for an improper character did not preclude the evidence. Even if they can convict him because of prior bad acts, doesn't mean it's wrong to get it in. You get it in for a narrow purpose and argue that narrow purpose in closing. Don't misuse it, otherwise you could get reversed. Opportunity, Corona. The defense girlfriend made contradictory statements related to the identity of the shooter, including her own in-court testimony that she acquired the gun from someone other than the defendant, and that she, not the defendant, here's the woman taking a hit for the guy, brought the gun to the scene and did the shooting. In rebuttal of his testimony, the court admitted identity or opportunity testimony that the accused had used that gun identified by ballistics in a prior shooting within weeks of the shooting. The evidence contradicted the witness's testimony that she, not Corona, possessed the gun weeks prior to the altercation with the victim. So the defense's case theory set up this evidence. This is an interesting case. Court reversed convictions for aggravated kidnapping because the court improperly excluded character evidence of an alleged victim and an potential accomplice under 403. This is dealing with whether or not the person, the defense theory, the prosecutor's theory of the case was that defendant held Hawkins at gunpoint and required him to get money from the ATM. Defendant defended that the person named Shields was a multi-state theft ring in a ring with him, and that defendant claimed the money he obtained from Hawkins was money the victim owed him from fencing property. The trial court excluded the evidence, and the court reversed. I'll skip some of these. We won't finish. Relevant to establish factual link in crimes. Sometimes evidence is really bound up. If it's bound up, it's not 404B2 evidence. It's kind of connected with it. Defendants may open the door to a 404B2 question by denying any connection to the crime. In Clark, a murder case, the police found the Beretta handgun. The expert testimony established was a murder weapon. Defendant denied ownership. To rebut this denial, the Court of Appeals affirmed the admission of evidence indicating the defendant had used the same murder weapon in a prior shooting. So it's a prior bad act, but he had access to it. He actually used that gun some other place, relevant to whether it was his gun. The Court of Appeals explained that whether the admissibility of the prior was considered under either Shickles or doctrine chances is still relevant because it shows the prior acts have been properly admitted for narrow purpose of linking the defendant factually to the crime. Balfour. In upholding the admissibility of 404B evidence, the Court of Appeals noted that the trial court had scrupulously enumerated these similarities, and which is what you want to do, by the way. So you want to, in order to help the judge, you want to have in your motion in limine a whole bunch of examples. I would have factual examples and case law, because there's a whole bunch of case law here. So help the judge by giving them factual reasons why it's relevant and some case law that supported that. The victims were all younger. Each victim had only a slight casual acquaintance with the defendant, no prior romantic. Each of the victims was lured to the defendant's office under promises of stardom. This is a case where, look, I'll make you famous, take your picture, come here, take your clothes off, I'll take some pictures and all this stuff. All four of the assaults occurred in settings where the defendant was isolated with the victim. In each instance, the victim verbally or physically resisted the assault and became aware of what was happening. In this case, under the doctrine chances, the court explained that as unusual and abnormal as it might be, the victim would falsely accuse the defendant of sexual abuse. It strains credulity to suggest that three other women would similarly accuse the defendant. Same thing. This is also back to the green. Inextricably bound up or race judicata evidence. If it can be inextricably bound up, then it's not prior bad acts. Then you don't even have to go through 404B2. So, for example, if you see a car driving down the interstate and it has a license plate dangling, the police can stop there because they have a probable cause there's something wrong. They stop, and then they find drugs once they stop. Now, those things are all bound up. They're all part of the same narrative story. So if they're part of the same narrative story, it's not 404B evidence. This is contextual evidence that are inextricably bound up. You don't have to go through 404B2 because it's not separate. It's part of the narrative. So if the events are part of the narrative, they're part of the story, they're not 404B2. Gorman. In action for being a felon in possession of firearm, evidence of the car smelled of marijuana will lead to the rugs and the floorboards, which led to the seizure, all inextricably bound up. So if they're factually part of the narrative, even though there are a number of different factual acts in there, then it's not 404B evidence. State versus Jones. The state's contention that Jones knew of his father's incapacity before pressuring his father to sign the loan and financial control documents proving the mens rea for acts relevant to exploitation of vulnerable adult, and consequently the evidence of prior acts were inextricably intertwined. I would circle those words, and I would, in my case, see whether or not they apply to the facts that you have. If they're bound up in the narrative, then you don't have to go through 404B2. They're not part of they're not other acts. They are the act. They're part of the narrative of the act. The crime, that is, both chart and the prior act are considered part of the single criminal episode, then 404B does not apply. State versus Lim, the court reversed a conviction based upon improperly joining 3 cases. By the way, in the Green case, that was one of the issues because there was all these different prosecutions joined. The defense actually either suggested that or agreed to it. But when you're trying to join cases, one of the critical issues is, if they were tried separately, could you get, in each instances, can you get the prior bad acts in separately? If you can, then joining them is no problem. If you cannot, then you got a problem joining the cases together. Accused was a nurse who committed sexual assault under strikingly similar conditions. Various women were hospitalized, serious medical condition, went on medication. Nurse either inserted a finger into the vagina or fondled the breast, going back and forth over the nipples, all in the guise of medical treatment and checking a catheter. Let me see if I can find a catheter. And he's, sexually assaulting the woman. The question is whether there is a 404B reason to admit. They reversed this, saying that there was not. Bedell, this is an important case. The court in a pretrial ruling excluded 9 separate complaints against a pain management physician for acts of sexual impropriety while providing medical service unless the defendant opened the door of such evidence. During the trial, the parties had an unrecorded bench conference. By the way, are your bench conferences always recorded? They should be, right? Presumably over whether the defendant had opened the door. So they have a ruling, and then they have a bench conference, and then the evidence comes in after that. Thereafter, both parties referenced the prior complaints of sexual misconduct. The Court of Appeals reversed because they didn't have it on the record, and then the Supreme Court reversed the Court of Appeals. But it's an important lesson. Put it on the record, right? If you have a sidebar conference, especially if you change the pretrial ruling. If you go to a pretrial ruling and the judge tells you how to do it, that's how you do it. You can't, if you think something has changed, Your Honor, time out, may we approach for purpose of discussing something, then you have a sidebar, put it on record and talk about it outside the presence of jury and go back and revisit the 404B hearing if you think they've done something to open the door. The State versus Bedell, the Utah Supreme Court reversed it by saying they had opened the door anyway. The most important thing for me for the Bedell case is making sure it's on the record. 404C, the child molestation case. This is, so when they amended the federal rules, so the 3 important amendments to the federal rules were 412, which was the first by several decades. So they had the Rape Shield Law 412, and then later in a companion, they adopted 413, 414, 415. 413 was basically saying 413 trumped the 404 evidence against the accused in a sexual assault case in saying you can get in prior bad acts and you can argue it in closing to show propensity. And then 414 was the child, and 415 extended us to civil cases. Now, Utah eventually got the 414 in some form under 404C. They've never gone to the adult sexual assault. Most jurisdictions, by the way, have 413, and which allows, that takes this whole 404B analysis out. One reason why it makes sense to me, aside from everything else, a lot of, especially sexual assault cases, a lot of that stuff comes in anyway, but then you're playing tiptoes and closing arguments about what you're using it for and whether you've misused it. And a lot of the 404B2 cases are sexual assault type cases. So it's a lot cleaner, it's a lot more coherent to not misrepresent what you're doing. You're doing this to show the person's a rapist, and the person's a child molester. Those are diagnosable diseases under the DSM-5 and 4. And so why not go straight at it? That's why the 413, 414, 415 made sense. Utah has a version of that under 404C without one in 413. The Rape Shield Law. I've had a couple questions about the Rape Shield Law. I got to keep looking, I forget. All right, 1125. Okay, we're in good shape. 412, the Rape Shield Law. Utah has adopted, has had some fairly significant 412 cases recently, and And in some of the cases, they actually worked through my treatise to get to the result that they had. And one of them, how many people know about the Railison case? So someone asked me about this subject matter. Maybe you don't know this case, but let me talk about the rape shield law. Okay, 412, the rape shield law says this. Under 404A2, the 804B1 subparagraph, the criminal defendant can put the victim's character at issue. But then it says, unless it's sexual crime under 412, unless it's covered by 412. So 412 is a rape shield law. It's one of the first early amendments to the federal rules. And the idea is that as prior to 412, if there was an accusation of rape, the response was consent. And then under what would be the equivalent of 404A2, you can get in the victim's sexual proclivities, how active this person is sexually. And so that provided a major deterrence to a lot of sexual molestation cases. So along comes the Crime Against Women, the Violence Against Women Act, federal act. As part of that, they adopted this, and there were a bunch of fights over this. But they adopted 413, 414, 415. And because this happened after Utah already had their rules and evidence, they didn't. So the Utahs were patterned after the federal rules initially, but that was before it was amended. These are amendments to the federal rules. And a lot of states have adopted the amendments because they make sense. In the area of sex, sex is a lot more, you don't have a propensity to rob banks that people have the same way as they have a propensity to rape. They're just different subject matter areas. And psychologically, it's different parts of your brains are affecting this. And so both sociologically and also psychologically, and a lot of jurisdictions have adopted 413 through 415. Before they did that, they got the rape shield law. Okay, the rape shield law protects the victim. The criminal defendant can put every victim's character at issue except a rape victim or a sexual assault victim. They can't put that person's victim as an issue. They have to go through 404B2 themselves. And then built right into 412 are the exceptions. And the first one is to show the source of injury or semen. The second one is to show prior sex between the people, the same people. So if there's a husband and wife or boyfriend and girlfriend, they've been having sex for 2 years, that says, look, the jury should know that they voluntarily had sex for a long period of time. Give it context to what's going on. It doesn't mean it wasn't rape, but at least it's information they ought to know. And the last one is just due process, in case you have a good fact pattern suggesting that. 412 excludes evidence offered to prove the victim engaged in other sexual behavior, evidence offered to prove victim's sexual predisposition. And so in this case, same-sex issues comes up. And anyway, 412, procedure to consider admissibility. You got to go through a motion, you have to have the hearings, you got to walk it through, and you have an opportunity to make an argument. The rape shield exceptions we've already talked about. Prior consensual acts with the accused, prior inconsistent anal sex to show that this was more likely. Let me go to, I'm going to jump ahead and then come back because I want to make sure I get this case, since someone asked me about this case. All right, so this case, the Railison case, a very interesting case. It was actually tried in, I think Farmington, and Brandon Maynard tried the case. It was one of my former trial students. But this case ends up citing my treatise for this very issue because it becomes very interesting analytically. So what happened in this particular case is that there's a manager of a restaurant, and he's physically aggressive with his waitresses. And he's touching them, they're touching each other, they're slapping each other's behind, they're teasing, they're doing a lot of physical stuff while they work. That's all the factual backdrop. She allegedly, one of the waitresses eventually alleges a sexual assault. That's why the factual scenario comes in this particular case. And what the case says, even sexual conduct and even imagination, one of the questions was, even if you imagine it. So what happened here, and I'll give you the factual scenario, and then I'll give you some of the rulings. The woman who later claimed she was raped, in text messages back and forth from their friend, says, I don't know, my man, he's pretty cute. He's always aggressive. I don't like that. Come to work when his wife's not here, because she kind of reins him in. But I don't know if I would have sex with him because he's my boss and I can get something out of it, or just because he's cute. All right, so this is imagination about having sex with the accused. That's part of what the case is about whether or not that comes in as one of the exceptions to the 412, the prior consensual sex together. While the 412 exception might permit discussion of statements in which the alleged victim expressed an intent to engage in sexual intercourse with the accused or voice fantasies involved in the specific accused. This is citing my treatise on this very issue. The state asserts that the statement at issue was merely a cynical anecdote from Tiffany, not expression of intent to engage in sex. If anything, the state argues this item is ambiguous about any sexual intent or fantasizing regarding Rallison. We too do not read item 9 as expressing its intent to have sex with Rallison. We acknowledge that the discussion of intercourse is entirely hypothetical. So that's what they're looking at, prior consensual sex between the people. They haven't had sex, but she's thinking about it. She's talking about it in her text messages. We acknowledge that a discussion of intercourse is entirely hypothetical and read the text as a whole as quite damning to Rallison. He's a jerk. He's excessively aggressive. But we believe the state applies this exception too narrowly. The text exchanges clearly discusses specific instances of hypothetical sexual behavior between Tiffany and Rallison, as well as Tiffany's thoughts, even if made in jest and even if negative, about prior sexual behavior with Rallison. Therefore, we find it persuasive the state's position that this item does not fall within 412, what they said it did. Prior consensual sexual activity would include a victim shared with the victim shared with her boss some nude selfies. That's not prior sex, but the court said that should come in. It was kept out. It got reversed on that. Should have come in, especially if within close proximity of alleged assault. For similar reasons, workplace reciprocal butt slapping may be admissible at some point in the work relationship, would be relevant to whether she continued to consent to that same action throughout her employment. We think the evidence that a person has shared pictures, even explicit ones, is here and is likely, as a rule, less intimate, embarrassing, and prone to causing an unfair prejudice than evidence of engaging in anal sex or sexual intercourse. The 412B exception for prior sexual experiences with the accused reasonably extends to victims' voiced hypothetical. Someone asked me a question about this earlier today, and this is the case. About the accused as admissible as specific instances of sexual behavior, even if the accused never knew about the victim's hypothetical fantasy. Never told him that she was thinking about him, but she's telling her girlfriends through text messages, other waitresses talking back and forth. The district court erred in ruling that 412B2's exception did not apply merely because Rallison was not aware of the textual fantasy messages at the time of the alleged assault. It all turns on whether she willingly was involved in this sexual relationship. And so they allowed in prior sexual fantasies, not prior sex, but prior sexual fantasies under 412B2. Evidence that comes within one of the exceptions of Rule 412 must still pass muster under 403. The court has explained that within the exclusionary purposes and policies of 412, evidence may also cause unfair prejudice when it reveals intimate and potentially embarrassing details about the victims. All right. Rallison is a useful case, I think an important case. It's a little bit unusual. So I would know that case because every time it's unusual, I would own the case. Rallison deals with fantasies and talking and referencing about prior sexual history or willingness to have sex with someone in the context of explaining what later happens, whether it was consensual or not. It is not general, it's specific about that very person. That very person was sexually assaulted and the person who allegedly later assaulted her. They're saying they reverse that case because of that reasoning. Okay, 412B2, prior sex has to be similar Due process is also a backdrop, so if it's due process requirements, then that's important. The most important case on due process is Oldham versus Kentucky. That's a U.S. Supreme Court case establishing an example where prior sexual things should come in as a matter of due process. Constitutional arguments are difficult, however. The State versus Ashby case affirmed the exclusion of the sexual awareness of evidence. The victim was 8 years old. Part of the allegations involved the defendant taking baths with the then 7-year-old victim, which included having him wash inside her vagina, her bum, her breasts, and while she washed his private parts. The defendant under 404B3 sought to introduce the victim's prior sexual behavior with other children, same thing, in part to rebut the juror's likely assumption that the child was too young to fabricate the allegations against her. The court held that based on the policies of 412 and the other application of 403, the relevancy was substantially outweighed by the goal of protecting victims of sexual crimes from embarrassment, humiliation, and encourage them to report crimes. I'm going to get off this. Here's a case just decided last month, Jolly. This is a useful case too. Rule 412B2 provides an exception to the real rape shield law for prior consensual relationship between accused and alleged victim, but does not permit the accused to call the witness. So here's the deal. This case, I think, is an important case for you. State versus, I don't know if anyone's seen, did anyone try this case, State versus Jolly? You know this case? This is a useful case, I think, as a matter of practice. Just decided last month. So the defendant says, yeah, we have prior sexual, I want to call her at the 412 hearing and cross-examine her about our prior consensual sex, to establish that we did have prior sex. And the court said, no. The criminal defendant cannot call the victim, the alleged victim, and cross-examine her either in an out-of-court statement or during the course of the trial in a kind of a motion in limine type setup to find out whether or not what she's going to say about prior sex. That's an important case, I think, because the idea is, look, if you're going to prove prior sex, you got to do it on your own evidence, on your own dime. You can't. The defendant's going to have to give testimony, or you're going to have something. You can't call the victim and put the victim in an awkward situation to talk about a prior sexual connection with them. They're saying that's part of the rape shield law. To me, that's an important case because it covers something that people may not. Maybe this is obvious to you all. Maybe you've seen this in the past, but I haven't seen this before decided by the Utah Supreme Court. It's important. So if they try to get to your victim and they want to take a deposition or they want to give testimony in the hearing, the 412 hearing or something like that, they can't use that person to establish their predicate acts to show that they have prior consensual sex. Have you had any experience with that? Anyone trying to do this? Right? I would keep that case in my pocket if I tried these cases because to me, I haven't seen any Utah cases talk about this issue. If they want to establish the prior acts, consensual sex, they can't do it through the victim, the alleged victim of the prior sex. They got to do it through their own testimony. That's State versus Jolly. Just decided. All right, last couple things. I already talked about 404C. And this is the version, basically the federal version of 414. They just stuck it in 404 and make it 404C. And you could use, if it's a child molestation case, then you can use evidence of prior acts if you go through the notice requirements of 404C. Now, jumping from 404B evidence and to 405B evidence. When a person's character or character trait is an essential element of a claim or charge, the character trait may be proved by relevant specific instances of the person's conduct. This applies primarily but not exclusively in civil cases. I've already mentioned this. Okay, so where people get confused about this. So under 404A1, the criminal defendant can put their character at issue and they can put the victim's character at issue. They can make that choice to do it. But what that isn't answered there clearly is the 404, the 405 material, and that is this. When they put the victim's character at issue or their own character at issue, they have to go through 405A, which means it's limited to reputation, opinion, no specifics. If they're going to go to specifics, they got to go through 404B2. General, not specifics. If they're using 404A1 or 2. That may not be self-evident on the face of it, but that's an important rule. So they cheat if they're using specifics, if they're trying to introduce their character or the character of the victim, and they're using specifics. They can't do that unless character is at issue, unless it's one of the elements of the prima facie case. What character is at issue? Child custody, defamation, negligent hiring. In the criminal, there aren't very many 405B cases in the criminal area. But to rebut an entrapment defense is one of them. There's a number of federal cases that deal with this. So if they are claiming entrapment, then you can introduce some prior bad acts to rebut the argument of entrapment. That's a very narrow area. You don't see 405B used very often in criminal cases. Habit. I just tell this on, habit is different than character. Right? Whenever you have habit, you have two things you have to answer. And then if you have that, you can work through habit. A habit deals with, there are probably more business routine habits than there are routines than there are 4 or 6 personal habits. But run out of time here. So 406, particular, invariable. If you're going to go through 406, it has to be particular and it has to be invariable. Every day. Like particular and invariable. Now, believe it or not, every morning I write a poem to my wife. I've been married 45 years, and I write a poem every day in the morning. First 20 minutes of my day, write particular and invariable, right? So I know every day I wrote a poem. I don't remember what the poem said. I don't know anything about the poem, but that's something particular and invariable. I have a miracle wife, and I did that. I'll tell you a short answer to that. I was married, fell in love when I was 15. I was married to my first wife. I loved her every moment. She died suddenly before I started teaching from brain aneurysm, pregnant with my 4th child. And the biggest shock to my system, I couldn't remember the last time I told her how much I loved her. And I said, not going to happen again. So I developed a habit. I get so involved with things, a habit. That's one of my habits. Every day, if I'm not home, it's on the internet, the computer. So I developed, because I get so involved in things, I don't forget. I want to make sure she. So every day I tell her I love her. Right? I wrote a poem. Okay, that's an example of a habit. Most of us have habits. That's one of my few habits. I shave every morning, even if I'm going fishing. That's another habit. My brothers get mad at me if I go fishing with them because you don't fish when you're shaving. I shave every morning. Right, just what I do. Right, so everyone has personal habits. That's this 406. Particular, invariable. If you have something that's particular and variable, it's habit. If it's habit, it's not character evidence under the 404. You don't have to worry about that. It's a separate. And you can use particular, opinion, reputation. You can use everything if it's a habit. This case was just decided, and I kind of stuck it in here because it's a very interesting case to me. It doesn't fit exactly, but it's in there. This case was State versus Lovell, was decided, seems like a month ago or something. So this comes up in closing, so it's really foreshadowing my ethics part. This is the closing thing. So what happened this is a death penalty case, got reversed. How many people know this case? Some of you probably tried the case, but so you know the case. So this particular case, so now we're in the punishment section of the trial. In a capital trial, the death penalty, the aggravating and mitigating circumstances are subject to the rules of evidence. And in this case, well, it got reversed, and it got reversed over the fact that some of the testimony involved the Mormon Church, which I happen to be associated with. I know a little bit about these processes. But the question, the guy got excommunicated and not reinstated. And part of the argument was that the idea was if he's not reinstated, he hasn't truly repented of his acts. And so it was all bound up with theology. And the idea that the jurors hear this testimony that the church hasn't given him a clean slate. They haven't forgiven him for those acts. He hasn't put the repentance behind him. And the inference is for the jury, they've already done your work for you, right? This guy's phony. He's not really true. He hasn't really repented of what he's doing. And when you're looking at mitigating circumstances, reversed. You got a death penalty reversed based on religious ideas coming in, not in this case, not closing, but in the actual case. So religion is the third rail. Especially in Utah, where religion is such a dominant issue, lots of things don't bring up religion unless there's very specific reasons that has a narrow 404B reason involved. All right. I'm going to have to fly through character evidence because at 4:15 we're stopping and we're doing character. All right. So on the other side of character evidence is Article 6. And Article 6 deals with credibility. Article 4, propensity. Article 6, witnesses, credibility. All right, so, but they're very parallel. The rules are very parallel. There's a lot of very similarities and with regard to those two different things. Here's the rule. Here's the primary rule. Common law voucher rule. The common law voucher rule is the thread through a lot of the rules of evidence. You cannot vouch for a person's testimony until they've been impeached. So voucher comes either in rebuttal or on redirect. Like a prior consistent statement, that's a good example of the voucher rule as applied. So on consistent statement, he says what happens. On direct, you can't say, have you ever told anyone that before? Let's say it's a sexual assault case. Have you ever told someone that you've sexually assaulted before? So it's a prior consistent statement. You can't do that on direct, right? Because that would violate the character evidence rules. Prior acts, right? So what you have to do is wait until redirect, and only if they're cross-examined on this point. And now we have, the Green case again. We made prior statements prior to motive of advocate. We have a timeline. Okay, so the voucher rule says this. We cannot vouch. We can't say the person is a truth teller. That's one of the 608A. 608A allows for testimony with regard to the credibility of a witness, but can only attack, and it's only reputation and opinion testimony like the 404 rule. So for credibility, everyone who testifies puts their credibility at issue. Their character for credibility is at issue. 608A says you can attack, this person is not a trustworthy person. That's character evidence with regard to attack. You can attack, but you cannot corroborate until the other side's attacked them. That's the voucher rule, the common law voucher rule. The prior consistent statement is just one of many examples of the voucher rule. That's why only in redirect. Can you bring this up? Yes.
But on direct examination, can you elicit just opinion evidence about a character for untruthfulness?
Well, no. Okay. Two things. The voucher rule, you cross to the other side.
Okay.
So you cannot call a witness to say this person is truthful, but you can call a witness to say they're untruthful. Right. That's not the voucher rule.
Okay. Yeah.
That's what you can do.
So that's what I was wondering.
Yes.
You can call
Any witness who testifies, civil or criminal case, you can call another witness to say that person does not have a good reputation for telling the truth.
So in a criminal case,
Civil or criminal, doesn't matter.
in our case in chief,
Yeah.
let's say we don't know yet if the defendant is going to testify. Can we still call a person to testify that the defendant has a character for untruthfulness?
Yeah, only if what? They open the door somehow, or doctrine-specific contradiction, or that's one of the substantive issues in the case, right? So, okay, so the voucher keeps you from, only if that witness's credibility is at issue, and that's only in credibility once he testifies, right? And he can testify, by the way, even by out-of-court statements. One of the things people don't realize all the time, hearsay declarants are subject to all the impeachment rules. So if someone is out of court and gives testimony inside utterance, that witness could be impeached, that witness could be impeached by a prior conviction. So every witness who testifies, even through hearsay, puts their character at issue. Once they put their character at issue, then you can attack. And you attack them a bunch of different ways. One is, under 608A, you can call a witness to say, I know that guy's a liar. So that's reputation or opinion testimony under 608A. You cannot call someone who says, I know that guy's telling the truth. He's a truth teller, right? Okay, so that's the voucher rule. You can't do the positive, you can only do the negative. Yes?
What about, we see this all the time in rape cases, like, they just say, when did you first tell someone about this? Okay, when did you see the next person?
Yeah, and this is, if that's the case, we have back to prior consistent statement. You can't do that. That would be prior consistent statement. Now, you can do that. That's kind of the green case. It's all the other case I just gave you that happened. But you can, if it comes in, when's it going to come in? And only if, that's it, right? So if you're doing it on direct, you're not doing it right, right? So if you get, unless you fit within a hearsay exception. So for example, if it were excited utterance or something like that, you have another hearsay exception, but if you're just talking about prior statement, you can't do a prior consistent statement on direct. And part of that is common law voucher rule. The common law voucher rule shows up in lots of different places. So do not corroborate until you've been impeached. That's basically what this rule establishes. Now, so what you can impeach with people on, which is separate from this, but it's just impeachment, is 609 convictions. So anyone who testifies, civil or criminal case, you got a 609. If they've been previously convicted, and they give testimony, even if it's through a hearsay statement, then their character is at issue, and you can use 609 to impeach. All right, so the general is the subject of Clyde 11's rule includes 608. So you can't get into the, and both 608 and 404 are subject to Clyde 11's rule. And so you can call a witness to say the other person's not trustworthy, but not trustworthy. If you do that on either side, so if they say he's not trustworthy, they can be crossed on specifics that would relate to their truthfulness. If they say they're untruthful or truthful, if they give the testimony as truthful, then you can do a Michelson cross showing the trustworthy and back and forth. No one, this is related to but separate from, no one can testify that another witness in the trial itself told the truth. That's not. So this comes up sometimes with little children on the stand, and you have a forensic expert, let's say it's a doctor, who's interviewed the person who knows these things and saying, I'm telling you that kid's telling the truth about the sexual assault. No, you can't do that. Right? So you can't have expert testimony about the truthfulness of another witness as applied to the facts of the case. This is a very common issue that comes up. Ramash, which is the standard for expert testimony in Utah, that's one of the issues that came in that case. All right. Opening door. In discussing the inappropriate police officer's opinion and vouching for the credibility of the witness statement denied the incident, the court commented, we emphasize again today the state's use of law enforcement officers' testimony for bolstering and vouching in this case is inappropriate. When you talk to her, how'd she seem? She seemed truthful, right? Can't do that. That would be vouching. We perceive no strategic reason ours as counsel would reasonably fail to object to that testimony. The defense clearly opened the door to experts' rebuttal testimony. The idea of opening door is the evidentiary principle that allows, this is a doctrine of specific contradiction. I don't want to spend too much time on this because it's kind of a little bit, it's not the main. 608B, untruthful acts. Okay. Now, anyone who testifies civil or criminal case, you can ask about prior bad acts that go to truthfulness, 608B. You've lied. You lied on your income tax. You lied here. You lied that. All that. Those are, as long as you have a good faith basis for doing that, you can ask specific, even if it has nothing to do with the facts of the case, you can ask a 608B question. And that's just core. Anytime someone testifies, they put their character at issue, you can ask them about prior lies that they've made, even if it has nothing to do with the facts of the case, because it fits within 608B. But you cannot introduce extrinsic evidence unless they're the ones who brought it up. That's the doctrine of specific contradiction. 609 is a very well-known rule. It has very specific rules about when you can, timelines and when you can do it, and the balancing if you use it against accused. If you try cases, you know 609. That's not something we have to spend a lot of time on. 608B allows prayer. 608B is subject to collateral evidence rule, 609 is not. So if you ask, you've lied in the past, and they say, no, I've never lied in the past, and you have proof that they've lied in the past, you can't get it in. You've been convicted of perjury in the past, 608B question, and 609 question. No, I haven't. You can introduce the extrinsic evidence of conviction because 609 trumps 608B. 609 is not subject to the collateral evidence rule, 608B is. Religion. You can't talk about religion. You can't use religion as bias. There's a the U.S. versus Abel is a very famous U.S. Supreme Court case to illustrate the point. So on the Abel case, you can't use religion. It used to be in English common law, if you weren't a member of the Church of England, you couldn't testify, right? If you would swear oath to God, you couldn't testify. You can't even bring that up now, except for, unless it goes biased. So in U.S. versus Abel, this is a Ninth Circuit case. I'm old enough to have practiced in front of Ritter, and I was in the courtroom one time, and well, he does this often. None of you are old enough probably to be in his courtroom when this happened. But someone would say, he didn't like the 10th Circuit, but alone the 9th Circuit. Someone would cite a 9th Circuit case, and he'd say, counsel, go look out the window. And he'd say, well, do you see any palm trees out there? He said, no, I don't see any palm trees out there. He said, I don't even like to follow the 10th Circuit. I'm never going to follow the 9th Circuit. They have no idea what they're doing, right? So this is a 9th Circuit case coming up to U.S. Supreme Court. The 9th Circuit, who doesn't like religion very much, characterized a Aryan Brotherhood, which is a prison gang, where they take a blood oath to lie, steal, cheat, for each other. They said that's religion, and so you can't impeach on that. And the Supreme Court said, well, I don't want to address whether it's religion, but you can impeach on it, because even if it were religion, it goes to bias, right? So these are, they already took an oath that they're going to lie for each other. Shouldn't the jury know that? It's not religion, it goes to bias. That's 610. Okay, I finished. I went through a whole bunch of stuff quickly, but I'm on time. So I'm supposed to quit at 11:15. We'll have a little bit of break, and then by ethics, I'm going to give you an hour, a closing argument ethics, and it has to be 1 hour. Otherwise, that wouldn't be ethical. So go ahead and take a break. Okay. Ethics. One of the things, especially for you all, you don't want to try the case right and then break it all down in closing. So there are, and the state, the prosecutors more than anybody else. I mean, these rules apply to everyone, but especially the prosecutors have a higher responsibility, and for lots of different reasons. You know, I think I tell my students how precious, how magnificent it is to be an attorney, and to, you know, religion is important to me, and one of my Savior's title is advocate, the advocate with the Father. And to be an advocate is an awesome responsibility because you're representing people. In your case, if you're state people, you're representing the people of the state of Utah, and you're generally and then specifically, particularly protecting victims. What an awesome responsibility! What a gift! And we, in our system, we have the best legal system in the world by far. And the reason why, you know, in Europe and civil law jurisdictions, it's controlled mostly by the magistrates, and you know, attorneys are not very important. You're important in our system, our common law system, adversarial system, and it filters through the rules of evidence. But the direct and cross, and putting evidence on, and working through the things is an important part of the most effective system getting at justice, other than having God with you to tell you what's right and wrong. So this is a very good system, and we ought to be honorable of it. Where your responsibility is the highest is in closing, right? So when you get to closing, make sure you do it right. And apart from whether you're going to get reversed because you've done something wrong, it's our moral responsibility to do it right. All right, we're fighting for truth and justice. And so part of that, doing it right, is have some sense when it's wrong and when things are doing things wrong. So our first rule, I don't know if I'll get through them all, but I have an hour that I'm going to present with you. Ethical closing arguments are a matter of your own professional responsibility and also raise issues of due process. I mentioned to you this case just decided. It kind of rang, it resonated in my mind a lot because the overlay of the church disciplinary council and bishops and stake presidents and even the prophet involved in the system goes through separate from, we have a separate thing. Actually, I'm the only person in the history of the church who's read all the church court records in the 19th century. I wrote a book on it. But it's amazing. We did amazing things. People in this, the members of the Church of Jesus Christ Latter-day Saints, 19th century, you have no idea, because most of you don't understand and appreciate what the church did. Water law, property law, everything. They didn't go to civil courts. In fact, if you went to a civil court, you could be excommunicated. They did it all in-house, involved in the thing. They did amazing work. They established water law, different than the common law here. They established different property law. We did things here unique that almost no one ever even has any idea of. And so all that's good. And so there's two worlds going on at the same time. And that's what this case, that one case about, I'm going to show you in a minute. But so the church does, if someone is a member of the church and they get excommunicated from a felony like murder, they can come back into church, but there's a process. And the process, anyone familiar on the jury may know the process by doing that. And that process is different than the secular law and world. And in that particular case, they got smooshed together. And they're saying, look, the church hasn't exonerated him, so that's evidence that he's not repentant. He hasn't been rehabilitated. Don't do that. You can't do that. Reverse. It should have been reversed. You can't commingle the church and state. That's an improper closing argument. In that case, that was not a closing argument. That was well, it wasn't a closing argument. Okay, number one, first prosecutors are held to a high standard regarding their conduct. Given the possibility, the jury will give special weight to the prosecutor's argument. You're representing the people of the state of Utah. You have a little bit different robe on than other people. And you should understand that. You have a little bit more, you carry a little bit more weight than someone on the other side. not only because of prestige, but because of the fact-finding facilities presumably available at your office. You have resources that oftentimes criminal defendants do not have. And he may prosecute with earnestness and vigor. Indeed, he should do so. And this is a quote out of Berger, and this is a quote that shows up in a lot of cases. But while he may strike hard blows, and you can, if you do it right, he is not at liberty to strike foul ones. It is as much his duty to refrain from improper method calculated to produce wrongful conviction as it is to use every legitimate means to bring about a just one. That's a truism, right? That's a moral responsibility as well as a legal responsibility. And prosecutors who represent the state and the people of Utah, and you fight day to day for truth and justice, make sure you're fighting for truth and justice, not to win a case without truth and justice. That's the first point. A prosecutor is a public officer acting in a quasi-judicial manner. His duty is to use all fair, honorable, reasonable ones to secure a conviction. Nothing should tempt him to appeal to prejudices, to pervert the testimony, misuse character evidence, for example, or make statements to the jury which, whether are true or not, have not been proved. The desire for success should never induce him to endeavor to obtain a verdict by arguments based on anything except the evidence in the case and the conclusions legitimately deduced from the law applicable to the same. Stay on task. Do it right. You go home, you can kiss your babies when you get home, and I've done something that's honorable. Don't be dishonorable. By the way, I tell my students, evidence class, big classes, I say the most important thing I'm giving you in this whole course, get out a piece of paper and put 2 letters on it, N-O, put that in your desk. And at some point in time, someone's going to come and ask you to do something, a senior partner or someone else is going to ask you to do something where you know is wrong, ethically, professionally. You pull out that piece of paper and tell them Professor Mangum said you had to say no. So don't cheat. I tell my students, I have 3 C's, I tell my trial students. I had some of my trial students are in this audience. I have, I think now, 31 judges across the country from my trial team. I tell them 3 things. First one, they're lexically ordered. Class, coherency, control, right? You've heard that before? And class is all attorneys, but especially prosecutors, you have to be classy. You have to do it right. You have to do it right even if you think that the defense attorney is doing it wrong, cheating. Now, they may open the door for you, but wait until they open the door, don't cheat. That's your responsibility. All attorneys are subject to ethical closing, whether you're a prosecutor or a defense attorney, you know, the worst time to do something improper, by the way, and this comes up in the case, in the case, what's the worst time to cheat? What do you think? The whole trial. Closing, what part of the closing? Rebuttal. Rebuttal's the biggest problem because they don't get us a rebuttal. You finish, you start, and you finish. So don't cheat, especially in rebuttal, because they're handcuffed. They can't get up. Most of the time, they're not allowed to get up again. All right, so second principle, object or face plain error. Whenever anyone sees improper closing, you should object during the closing itself. People say, well, I don't like to object, disrupt now it's a tactical question. At a minimum, at the end of the closing, may I approach, and then make sure you get on the record then. I tell my students, if you think something's, you're wrong, you know that it's a wrong closing, don't wait. All right, object right then. I think I have a slide I'll give you that, I'll tell you a little bit about that. But object right then, and then you can apologize. You want to apologize for, may we approach, and then have a sidebar and talk about what's improper. So if they do not object to the closing, then almost always it's going to be not going to get reversed. They have to, because the courts are not going to, was the close improper, did they object, and was it unfairly prejudicial? In the first place, second, object to improper closing. Counsel for the defense cannot, as a rule, remain silent, interpose no objections, and after a verdict has been returned, seize it for the first time on the point that the comments to the jury were improper and prejudicial. This is Saccone vacuum case is a large case about closing arguments. It's an important case. And they're saying object what's happening, don't object later. Standard of review for closings. If the opponent objected to the wrongful remark during closing, the court will review the court's ruling on abuse of discretion standard. If the opponent did not object, the issue will be reviewed under the plain error standard of review, requiring showing the trial judge and prosecutor were derelict in countenancing it, and even absent the defense mere timely objection, pretty difficult burden. Under plain error rule review, the court is unlikely to reverse unless the objecting party had been deprived of a due process argument. Okay, here's some factors. These are like factors, these are not controlling, but these are factors that are relevant to this. The U.S. versus Hales case, I like this case, outlined a 6-factor test for examining whether an improper remark by a prosecutor during closing prejudiced accused to the extent requiring reversal. Whether the prosecutor misstated evidence, don't misstate evidence. Number 2, whether the remarks implicated specific rights, like privilege against self-incrimination. Number 3, whether the defense invited the remarks. In fact, a lot of the error is erased because the defense is done in response and the defense has invited it. Whether the trial court remediated by instructions and the way the evidence against the defendant and the opportunity to rebut. That's why in rebuttal, they don't get a chance to get up again and explain it unless they give them a thorough rebuttal on that point. Then that's the wrong time to object. Do not misstate, misuse, or create evidence. A cardinal principle for closing is the counsel may neither misstate or misuse the evidence admitted at trial by spinning the evidence where there's no basis for the inference to be spun. The Suhel case. The prosecutor arguing closing 25 years isn't drug time, explaining a comment about during the course of the trial, well, you will still wait for me if I go away for 25, which is the argument was that he knew the sentences and what he was being prosecuted for, and he was saying, well, I said something about prison because I was worried about going away for drugs. And in closing, he says, 25 years isn't drug time, it's robbery. It's not even robbery, it's murder. Okay, now a couple things important about that. Does the jury know that? No, they don't know that. Who knows that? The state, perhaps the defense attorney. What has the attorney just done? They've just introduced, by testimony, even though they're not under oath, evidence in the case that's not subject to cross-examination. It's not proper. Right? And they're making an argument that he was basically admitting to the murder because he's aware that murder is 25 years. And that was basically a statement that would be circumstantial evidence of consciousness of guilt. Of course, they don't do that. In Hairston, this is an Idaho case. Tapes were admissible solely for impeachment. Now, this is not true in Nebraska or Utah, but it is true in a lot of places. So for a limited purpose. In closing, the prosecutor did not mention the tape to discredit Martin, but said the prosecutor improperly asked the jury to use the contents of the tape for the truth inferences drawn from them. And then he argued about stuff that the tape, the inconsistent statement is true, rather than in-court testimony. You can do that in your case. So you can't do that in most states. So in your state, if you have a domestic violence case and the woman comes in, which they often do, and either deny it or say, I don't remember, or say it was exaggerated, but they have a prior statement, let's say, for example, at the hospital. So you have a nurse or someone's a forensic person who works with them, and they're talking to them about what happened, and they give detail about who did it and what happened and the circumstances of it. Then they come in court and give different contrary testimony. Most jurisdictions, you cannot get that statement in unless it was under oath and prior. You can. And you can argue the truthfulness of the out-of-court statement. Why? Because your statement here is inconsistent under 801D1A, and because it's inconsistent and comes in as evidence, you can argue the out-of-court statement. That's a gift that very few states have, by the way. You may not realize that, but that's different than most states. This is an example where you can't do that in closing because you cannot argue the out-of-court statement that's inconsistent as if it were true. Okay, do not misuse evidence, especially in rebuttal. In Hodge versus Hurley, Mr. Nagy also said that Consuelo was being investigated by Children's Services. I didn't hear that testimony. I don't know where he got that. I don't know why he feels he has to unfairly damage the reputation now, but he apparently does. There is actually testimony in the record to the contrary, supporting the defense side. So what is that? Maybe that was just not paying attention to the trial, but you cannot argue impeachment testimony contrary to what was given in the trial, right? So you have to pay attention to what was said. I tell my students I don't like very many things on the council table, but one, yellow pad. And if you see something that came in a yellow pad that you think is important, you want to use in closing, write it down on your yellow pad. Now you make sure you know exactly what was said under the circumstances. Now when you want to use it in closing, you can get up and work from that yellow pad. So in this case, the guy said that testimony didn't come in. May not compromise constitutional rights. This is one of the most consistent ones. One is the easiest way to get reversed for improper closing is to compromise the exercise of constitutional rights. The most commonly violated rights are the Sixth Amendment right to jury trial, right to counsel, privilege against self-incrimination. Right, so it's a subtle point, but here's the point. In Cunningham, the court described the prosecutor's closing argument as outrageous, 11th Circuit, as outrageous, when he argued that he was offended that the Cunningham, clearly guilty, had exercised his Sixth Amendment right to jury trial. Right, what a waste of time. He's clearly guilty. Why is he playing not guilty and making us go through this whole thing? Right, so suggesting he doesn't have a right to jury trial, he's just wasting taxpayer money and everything else. On appeal, the court condemned this form of argument. By these comments and others, the prosecutor improperly appealed to the jury's passions and prejudices. He sought to inflame the jury and to misform them as to the role that certain fundamental rights guaranteed by the Sixth Amendment play in our legal system, and to suggest that Cunningham was somehow not entitled to those rights. A prosecutor may not make an appeal to the jury that is directed to passion or prejudice rather than to reason and understand law. Do not comment on Dee's failure to testify. This may be self-evident. Griffin, the Fifth Amendment, in its direct application of federal government, bearing on the states by reason of the 14th Amendment, forbids either comment by the prosecution on the accused's silence or instructions by the court that silence is relevant to guilt. Anything the prosecution argues in closing that is manifestly intended or is such a character that the jury would naturally and necessarily take it to be a comment on the failure of the accused to testify is improper. I skipped that one. Cannot comment even if the accused does not remain silent post-arrest. The Court of Appeals in the McCalley case held the prosecution closing argument referencing the accused's failure to discuss self-defense. The defense theory argued at trial violated Miranda. After receiving the Miranda warnings, rather than remaining silent, he said, "Why am I here? Why are you jerking me around? Nothing happened, you woke me up." He doesn't give his defense that he comes up with trial. You can't do that. You can't. Here's an even worse, same point, U.S. versus Pearson. The prosecution comments about the accused's non-testimonial demeanor constituted reversible error. I don't know, if you've tried enough cases, you're going to see the accused defense doing all kinds of crazy stuff in the courtroom. You know, in Nebraska, we had a couple of cases. One time, this is a real story. One time, the defense got annoyed as a prosecutor, and during the trial, jumped up, came across the thing, and started beating up the prosecutor, or the defense attorney. He beating up his own defense attorney during the thing, right, because he's mad at what's going on. So his own attorney, he's beating up. And you can't mention that, by the way, in your closing, right, because that's, the jury knows it, just don't tell them. It's clear that the behavior officer was standing and was not subject to comment. Right. The court held improper the prosecutor's comment on the accused's nonverbal, humorous, and angry responses to testimony. We had a double homicide. We had a kind of famous case about 4 or 5 years ago in Nebraska, in Douglas County, where I am. And the people who tried it are my good friends that are former students. But it was a double homicide. It was named Garcia. And Garcia was a medical student at Creighton. He was a resident student at Creighton and got kicked out of school. And so he was not very happy with the Creighton people. So he came back twice, 2 different years, trying to kill the doctors who kicked him out of school. He ended up killing a housekeeper, like a 60 or 70-year-old housekeeper, and then also killed a little kid. And then he's being tried double homicide in this particular case. They separated, he came back twice, looking for these people, separated. They had Chicago attorneys that were really jerks in the case. And they did all kinds of improper things during the case. And I won't tell you all of them. I have some talking to the attorneys. I talk to attorneys almost every day in that trial. The prosecutors, I was talking to them, working it through. But so let me go through it. This guy, Garcia, by the time the jury was over, even if you didn't even listen to any of the testimony, if you just watch Garcia, he's going to get convicted just by the way he acted and stuff. This is what this case is about. The court held improper the prosecutor's comment on the accused's nonverbal, humorous, and angry response to the testimony. That the jury witnesses the courtroom behavior and does not make it proper for the prosecutor to tell them about it. With the court's approval, that they may consider it as evidence of guilt. What the jury may infer, given no help from the court, is one thing. What it may infer when the court, in effect, tells it that the courtroom behavior of the accused constitutes evidence against him is something entirely different. You cannot infer by their body language that they're guilty. It's a violation of the Fifth Amendment. And it's not part of the evidence in the case. If anything, when requested by the defense, the proper course for the trial court, where a defendant has engaged in unruly conduct, is to instruct the jury to ignore the defense behavior in its deliberations. That's what happened in this. He turned around and beat up his own counsel right in the middle of the jury. Do not appeal to the juror's prejudice. This is maybe the most important. This comes up a lot in different contexts. A prosecutor may not make comments designed to inflame the passions or prejudice of the jury, condemning the following closing. He shouldn't be, this is a U.S. Supreme Court case, right? This is what they're arguing in closing. He shouldn't be out of his cell unless he has a leash on him and a prison guard on the other end of the leash. I wish Mr. Truman had a shotgun in his hand when he walked in the back door and he blown off Darden's face. I wish that I could see him sitting here with no face, blown away by a shotgun. I wish someone had walked in the back door and blown his head off. He fired in the boy's back, number 5, saving one, didn't give him a chance to use it. I wish he had used it on himself. I wish he had killed in the accident, but he wasn't. Again, we're unlucky that time. Pretty bad. Don't do that. All right, the golden rule. This is one of this is one of the rules that actually is a thread that shows up on a bunch of things. I was actually out at a CLE with one of the most famous criminal defense attorneys in the state of Nebraska. He got up and was talking about closings, and what he said was, in his closing, he always argues, I know you're a fair people, but just to emphasize the fairness, I want you to imagine that the defendant, while he was sitting at the counsel table and when he testified, was sitting there and someone had put a sheet over his head and you didn't know who he was. But before you deliberate, you pull the sheet off and it's actually your son, right? Now, if you imagine this is your son, go back and deliberate, then I feel like you'll come up with a just verdict. No. This is a violation of the golden rule. I told him afterwards, and he was a very famous guy, and I says, that's unethical and improper. He says, I do it every time, and until I get reversed by doing it, then I'm doing it every time. I don't care if it's ethical or not. It's what I do, right? You can't do that, by the way. And he did it, and he was successful, I guess, but it's unethical, right? So you can't violate the golden rule. This comes up in other things. So, for example, the variation on this. You can't say, if you're a prosecutor, say, in a rape case, look, if this person's not acquitted, not convicted in this rape case, he's been doing it for a period of time, you better lock up your daughter, you better make sure whenever your wife goes someplace that she has a bodyguard, because at some point in time, he's going to be in the same parking lot as your wife if he's not convicted. That's a violation of the golden rule because you're personalizing with the jury, suggesting that he's going to come back and do something wrong. The golden rule is a thread that you cannot, and there are lots and lots and lots of cases saying you cannot violate the golden rule. What is the golden rule? You can't ask the jury to personalize with the parties of the case or the witness of the case. Because the golden rule, it would be improper to discuss closings, victims' first days of school. By the way, these are out of real cases. So sometimes people want to personalize it. There was a murder of a Nebraska volleyball player, and a very, what a sweet young lady, and she gets murdered. And so during the course of the trial, they had all the volleyball players and other people came in the back with buttons and different things. And then in closing arguments, they used, photos of her playing volleyball and things like that. You can't do that, right? Because it has nothing to do with the case. It's intended to kind of generate an emotional response. So in this case, first day of school, favorite song, families, mothers, fathers, coffins, funerals, or used enlarged photos of the victim or a poem to memorialize the victim. Nor should the prosecutor contend the jury has a duty to protect the alleged victim to become her partisan, asking the jury to place themselves in plaintiff's position and to do unto them as they would have them do unto a form of the golden rule argument. So anytime you're arguing that this witness, here's another one closely related to it. Send a message to drug dealers, right? If you say, by your conviction, tell all the drug dealers in Provo that there's not a place for them. That's not a proper closing argument. Why? Because it's an appeal to social justice. It's arguing, let's say, utilitarian justice, even if he's guilty, even if he's innocent. In fact, a fortiori, if he's innocent and we still convict him, that's going to make people real nervous about getting involved with drugs. You cannot argue utilitarian arguments in criminal cases. Well, you can in any cases, but it comes up in criminal cases. So don't try to send messages. No dehumanizing the opponent. This case, actually, this is a case you want to look at an improper closing argument. Write this case down and look at it. State versus Barfield. Very good attorneys on both sides, by the way. But they got in a fight with each other during the course of the trial. This is a very serious murder case. And State versus Barfield, 272 Nebraska 502. It's a colorful example of the prosecution's improper dehumanizing the accused. And the prosecutor and defense attorney got in a shouting match back and forth during the course of the closings. And they got reversed, by the way, for this. In Barfield, the prosecution variously referred to the defendant. The guy was like 6'9", 350 pounds, huge defendant, and was pretty scary, and he had done some bad stuff. So they called him a vicious dictator, a two-headed hydra, a tower of terror. He was pretty creative in his a monster of mayhem, and a king of killers. Without deciding whether these hyperboles alone would justify the reversal, the court condemned such dehumanization of the accused. And by the way, in the Green case, you have some of this. They didn't look at it, they didn't comment on appeal, but you do have some statements, not that bad, but at least relevant to that. The United States Court of Appeals in Bates v. Bell reversed in part because the prosecutor repeatedly called the defendant a rabid dog. So identifying the defendant with animals, but with famous bad guys, don't do that. The prosecutor committed no stereotyping at the accused as evil. The prosecutor committed misconduct in U.S. v. Moore by comparing on the eve of the first anniversary of the events, the defendant to a 9/11 terrorist. This guy's just like one of those 9/11 terrorists. I don't know where you were. I remember seeing that second plane hit those towers. It had an emotional response. It's pretty hard to live through that and not have something, a visceral response to that. So they compared him to those group of people. The court condemned the prosecutors calling the defendant an executioner. Name calling is improper. Sometimes it's not going to get a reversal. Just don't do it. So U.S. v. Berry, name calling is not an admirable style of argument, and we do not condone it. But this court has been reluctant to find cause for reversal. The Ibrin case characterized the prosecutor's description of a video of the murder scene as nothing less than predators stalking someone who was about to be killed as colorful pejorative that were not so inflammatory to be reversible, but said don't do it. Banks versus Workman, calling the defendant a wild animal that stalks its prey, a predator who lurks in the shadows, a monster who selects the most helpless victims, a mafia-style killer, though highly questionable at best, did not justify reversal. Just because it doesn't get reversed for name slinging, don't do it. It's not worth it. Do it right. Use the right way. The State versus Green, by the way, juxtaposed here. The court in the appeal didn't comment on this, but I'm just giving you this backdrop. The court did not condemn the state for using adjectives of the victims as young, naive, innocent, to describe 6 alleged victims' defendants' sexual assaults while describing Mr. Green as, should be big, not big, old, fast linebacker, a wolf in sheep's clothing, and someone who took women back to his lair, and described Green as animalistic. There was no comment in the opinion with regard to that, but those to me are borderline issues. That probably shouldn't have been done. It's not necessary. Why foul up a good trial that you're doing by going over the top and doing things that the jury can get to that point if they want to, but why push them there? Why use those things? Be classy. Class, coherency, control. I tell them lexically ordered, class comes first. Always be classy in your presentation of case. The other side can't find an exhibit and you have it on your desk, go give it to them. Do everything in a classy way. Don't cheat, don't lie, don't falsify, don't argue improperly. So, and I don't know if any of you were the person making those statements. I wouldn't make those statements, right? Because they're pejorative references that try to evoke emotion that are not tied to factual issues. Counsel may not ask the jury to send a message. I already mentioned this, but let me give you some cases. In rebuttal, worst time to do anything, improper gave a send a message exhortation. Why don't we send a message to all drug traffickers? I've heard a lot of people do this. To all persons south of the border, Imperial County and in California. Why not our nation while we're at it? Send a memo to them and say, dear drug traffickers, when you hire someone to drive load and tell them they were forced to do it, and to tell them that they were forced to do it when someone asks them. I didn't know anything about what's in there. Because even if they don't say it was primary and secondary, they get away with it if they say that family was threatened. Because they don't trust Mexican police and they don't think the U.S. authorities can help them. Why don't we do that? Send a message to all these people, right? So why is that wrong? Because it's asking someone to be convicted, not because they did something, but because it will send a message to other people. You cannot use a closing to send a message to people who are not being tried. It's not right to do. It's just not the right. It's a sociological or utilitarian argument rather than, we have a retributive justice that's assigned to the person. So it's deontological rather than utilitarian. This is utilitarian. We are deontological. We're based on rights, not based on social justice as a broad thing. The court in Sanchez explained why send a message is improper. First, prosecutors may not urge jurors to convict a criminal defendant in order to protect community values, preserve civil order, or deter future lawbreaking. The evil lurking in such prosecutorial appeals is that the defendant will be convinced for some reasons wholly irrelevant to his guilt or innocence. Second, prosecutors may not point to a particular crisis in our society and ask the jury to make a statement with regard to their verdict. Now, for example, illegal immigration issue comes up, and how people who came here illegally are predators and do all kinds of bad stuff. You can't argue the social issues tied up to your case. The court concluded by his send a memo statement, prosecutor was encouraging the jury to come to a verdict based not on Sanchez's guilt or innocence, based on the potential social ramifications of the verdict. Stated differently, reference to the jury's societal obligation is inappropriate when it suggests the jury's decisions on the impact of the verdict on society and the criminal justice system rather than the facts of the case. State versus Thompson. The Court of Appeals, well, this case, you approved of the argument, your guilty verdict is vital because it sends a message to Thompson that what he did was wrong, that you know what we did wrong, that you're not going to stand for the people you tell won't stand for that type of crime. This is a closer one because it's the individual defendant rather than the community. Still, they disapproved of the comment. Get rid of send a message comments. It's about what happened there. It's not what it's going to say to other people. State versus Campos, another Utah case. Prosecution began his closing argument with the theory that the state was about civilized society versus the defendant, society versus the man who takes the law into his own hands, and society versus the self-appointed accuser and self-appointed judge. The prosecutor concluded his closing argument with an emotional appeal. When you commit a crime like this, when you gun down your fellow neighbor in the most tragic ways, stealing from him his ability to run, his ability to bike, his ability to walk his daughter down the aisle, when you do something like that in the streets of our community, then you should be held accountable. Hold Campos accountable for his actions, and do that, find him guilty on all counts. Reversing on appeal, the court held these comments crossed the line of permissible argument by asking for communal justice, right? So individualized justice, particular justice, not communal justice. It is improper for a prosecutor to invoke the juror's fears or sense of vengeance as part of a closing argument. Courts generally have held that the determination of guilt must not be a fear or vengeance, but rather intellectually compelled after a disinterested, impartial, and fair assessment of the testimony has been presented. The rationale for this prescription is that appeals to fear, vengeance, passions, and prejudice divert the jury from its duty to decide the case on the evidence. For example, in Bates versus Bell, the court reversed because the prosecutor appealed to the fears of the jury by suggesting that refusing to sentence the defendant to death would likely sentence future victims to death, maybe even your family members, right? This guy's going to kill again. You better convict him, because if you don't, you're going to be partially culpable for the next person he kills. You aided and abetted by not convicting him. Can't do that. Bates versus Bell. Throughout the summation, the Coffee County attorney prosecutors continually told the jury they would become an accomplice. Personalizing with the jury to this crime by permitting this man to live, and argued that the jury would be responsible for the future deaths of others if they opted to sentence Bates to life imprisonment rather than death. By permitting this man to live, we, in essence, become an accomplice. Wow. Pretty stinging comments. If you, based on law and facts, choose not to, you have passively issued a warrant of execution for someone else. We don't know who it is. We don't know when it will take place. But ladies and gentlemen, I think if you can see from the proof in this case that the only thing that will be left out of that warrant of execution, that someone else is to receive. If that man lives, is the name of the victim, all we're missing is the name of the victim and the date. We know someone else is going to die. This man's going to kill, again, if he's not first stopped, and I think it's obvious for each of you, even if his own psychiatrist hired by them and paid for us, by us, talking about the state paying for the defense's experts, even Dr. John Griffin tells you this man is going to kill again as he deems it necessary in his own framework of what he thinks is right. I've done enough on Bates versus Bell. Invoking fear of future harm by a defendant, improper. The prosecutor, that he has raped his victim once. If he's found not guilty, he will do it again. Same point. Do not argue social issues beyond the facts. Don't tell them to be the conscience of the community. Arguments which invite the jury to act on behalf of the litigant become improper conscience of the community. Don't represent the victim, represent the state. Counsel for American characterized Monaco as greedy insured, implied that P's witnesses that lied and stated that exaggerated insurance claims caused increased insurance premiums. If you give them that verdict, this came up a little bit in the State Farm case, and my firm tried the State Farm case and after I left. But the State Farm case, $145 million punitive damage case, that's the case that got reversed by the U.S. Supreme Court, and they refashioned in a legislative way the punitive damages. But that was a pretty bad case because State Farm was doing some pretty bad stuff. They were lying, falsifying, cheating to protect their insurance premiums. Anyway, in these cases here, the court condemned the conscience of the community and said, for example, if you give them too much money, your insurance premium is going to go up. That's a form of golden rule, trying to personalize them. Do not analogize to famous bad guys. The plaintiff improperly liked, this is kind of character evidence, the defendant to criminals widely known by the public, including Richard Nixon and Mr. Agnew. whom they argued that when they did not have as defense, they attacked the attacker. The plaintiff further argued, in many ways, this case has been tried a little bit like a rape case. You don't defend yourself against a crime, you attack the integrity of the people who are injured. You attack the witnesses. Do not argue the golden rule, we've already talked about that. Counsel should not threaten the jury in a criminal case that they will be branded as condoning crime, aiding and abetting, if they quit an accuser. Hodge versus Hurley, the prosecutor suggested that the jury trial to put themselves in the place of someone that might run in Hodge at night is a version of the impermissible golden rule. The prosecution cannot properly threaten the jury that an acquittal would jeopardize them personally. Such arguments ask the person to shed their objectivity and be part of the case. Do not argue iconic cases. So this Boyle versus Christian is one of my friends I started practicing law with. This is what the other side, this case got reversed on this, by the way. So the other side argued a bunch of things improperly, but this is one of them. This is Boyle versus Christensen. Ladies and gentlemen, they want a lot of money for this, a lot of money, civil case. What's been written on the board is called a per diem analysis. How many days since it's been the accident? How many days for the rest of his life? How much per day is that worth? That's what's been done here. That's how we got verdicts like McDonald's case with a cup of coffee. So now they're referring to the McDonald's case where they got a whole big verdict there. It was not, by the way, a per diem case. So they were using an iconic case to make the point, but they didn't get it right factually. They mischaracterized the case. Don't argue evidence that's not in the case, especially if you're misrepresenting what you're talking about. Reversing the court made first conversation. Few cases ever achieved as much notoriety among the general public as McDonald's coffee. Fueled by its wide-ranging repeated publicity in national and local news, it has been mocked in extremely popular television, including The Tonight Show, The Late Show, Seinfeld. It's been debated on talk shows, parodied in television, commercials mentioned in congressional debates, and firmly lodged in the public consciousness. What made the headlines and what is most commonly referred to by the general population about this case is the size of the verdict, $2.9 million for a cup of coffee. U.S. popular culture, the case has been to symbolize greedy plaintiffs, greedy lawyers who file frivolous lawsuits and win huge, excessive sums in a broken system. So don't argue iconic cases. Arguing falsely from iconic cases, I don't want to spend more time on Boyle, but that's an interesting case. Just go down and see what they're saying. They went out of their way to say how proper they were. You cannot, to appeal to the jurors, fears of jurors, which is their reference to appellant's propensity to shoot someone in the future borderline and threat to a jury that an acquittal would affect them personally. Do not refer to notorious cases. Do not refer to threats of future harm. We've already talked, these are all part of kind of a, do not express personal belief. This is the next step on this after the prejudice. Here's one of the things that, there are a lot of cases on this, by the way. You cannot express your personal belief in the outcome of the case. It's unethical for you to personally invest what you believe in the case. In fact, the rules of ethics prohibit that. So in this case, the lawyer asserting a personal belief in his client's innocence or the justice of the cause has ample authority to find the impermissible conduct as an expression of belief which indicates that the prosecutor is relying on information other than which has been presented in court. So it's kind of like, look, I know the real story. I know a lot of the stuff that didn't come in this case. I know really who's guilty or not. Trust me on this one. That's kind of what they're arguing. Prosecutor, attorney, law enforcement wear an invisible cloak of credibility by virtue of their position to make it explicit, too easily tip the scales. Personal beliefs are improper. Beyond the realm of professional niceties, arguments by the prosecutor indicating his personal belief or opinion that accuses guilty may be considered and adjudicated in terms of prejudicial effect rather than in terms of professional propriety. I don't believe this example. I don't believe Mr. Garcia's story. I don't believe what he said. Okay? The prosecutor cannot say that. What you can say is his testimony is not credible, But you can explain why it's not credible, but you can't express your personal belief. I don't believe, don't use I, for one thing. I don't believe Mr. Garcia's story, too many coincidences, too many slips and slides around the facts. We agree with Garcia to the extent that he asserts that he was there for the prosecutor to express a personal belief or opinion as to the truth or falsity of the Garcia statement. Statements of personal beliefs or opinions as to the credibility of witnesses are not only improper, they may also rise to the level of unprofessional conduct. Ouch. Don't be unprofessional. The Supreme Court has held, U.S. Supreme Court, that when a prosecutor expresses his or her personal belief of the defendant's guilt, he or she not only violates his ethical duties, but also such comments can convey the impression that the evidence not presented to the jury but known to the prosecutor supports the charges against the defendant and can thus jeopardize the defendant's right to be tried solely on the basis of the evidence presented to the jury. And the prosecutor's opinion carries with it the imprimatur of the government and may induce the jury to trust the government's judgment rather than its own view of the evidence. U.S. versus Young, U.S. Supreme Court case, directly on point. Don't express your own personal belief. Counsel cannot express a personal opinion about the facts of the case or the credibility of the witness statement. She told you the truth. One of the witnesses, she told you the truth. You know she told the truth. She has nothing to gain by lying, or you could see her just how she was forthright. All are all improper arguments because they implicitly the jury to make permissible inferences from the evidence. I looked into her eyes and say, he wants you to have it both ways. Believe the defendant's testimony, ladies and gentlemen. In order to buy defense counsel here, you have to believe the defendant. And you saw him, you heard from him. I look into each one of your eyes and I tell you, he lied. I look in your eyes, I'm telling you, he lied. Personal beliefs. The state tells you he lied. The state of Kansas tells you he lied. Objection, Your Honor, it's inappropriate for him. That's fair comment. Your Honor, overruled. Well, maybe, reversed. When couched in terms of the state or prosecutor, the assertion that Papps lied was improper. It was also improper for the prosecutor to claim, we didn't lie to you in our attempt to bolster the voucher rule. Well, they violated the voucher rule. We didn't lie to you. We told you the truth. The state's characterization of the prosecutor's statement that a defendant's lying as a comment of the evidence misses the mark. The point of not allowing prosecutors to comment on the credibility of a witness is that expressions of personal belief by the prosecutor are a form of unsworn, unchecked testimony, not commentary on the evidence. He's lying. Got a whole bunch of cases on this. So in the opening summation, the prosecutor said, don't be afraid to look at Roger James and say you're guilty, because he is. After the closing argument, the defense counsel, the prosecutor again told the jury, and don't be afraid to make that statement and tell Roger that because he is. Because he is, it's a personal belief of his guilt. Counsel also spoke of his meeting and talking to the justices of the case, talking to the Draper children, none of whom testified. Reference to facts not in evidence, where you're referencing things you know about that never came in, also are unconstitutional. Another federal circuit court, here's what the attorney argued. His attorney commenced his final argument by informing the jury that he was a sort of a 13th juror. I'm one of you guys, all right? I come sit down by you, I'm one of you guys, who applies his training. The only difference in you and me, I'm a lawyer. I get it, and I know a bunch of stuff. In the evaluation of evidence, analyzing the evidence, and tries to convey to the jury just what part of the evidence plays in the presentation of a case. You can't argue that you're a 13th juror. The counsel cannot express personal opinion. I've already hit that enough. Do not vouch for the witness. This is back to the 608. Vouching for the credible witness is also improper. Vouching constitutes an assurance by the prosecuting attorney of the credibility of a government witness through personal knowledge or other information outside the testimony before the jury. The courts discourage vouching because such conduct threatens to convey the impression that evidence not presented to the jury but known to the prosecutor supports the charges against the defendant, thereby jeopardizing the right to be tried solely on the basis of the evidence presented and inducing the jury to trust the government's judgment rather than its own view of the evidence. Okay, Such statements, I think, is improper. Such statements, I think he was credible. You heard from a specialist who I think came across quite reliable. I think the witness was very candid. I think another witness was candid. I think he was being dishonest with you, are all examples of expressions of personal belief. Take yourself out of it. Right? You can't put yourself into it. Body language. This is another violation of, this is a classic case, a Utah case, State versus Thompson. State versus Thompson held a prosecutor's expert's explanation to the jury on how to read the body language of the accused testimony constituted prosecutorial misconduct because it indicated belief in the witness's dishonesty. Also, potentially, if you're doing that when he hasn't testified, you watched him over there, how he's squirming, how he's, you're interpreting, that's a violation of the Fifth Amendment. I hope you observed him. I hope you observed his body language. It was very negative. Thompson had his hands out before him like blocking. I think it's a classic sign of someone who's hiding. If you notice, when I asked him a question of particular significance about the acts he performed, he would shut his eyes and shake his head no. Tell me that's not a classic sign of dishonesty. So he's a body language expert. Explain what's going on. He couldn't look me in the eyes and tell me the answer of the question. The court explained that by instructing juries that he's an expert on how to interpret his body language was improper. Do not misuse limited use evidence. This is especially important to what we talked about today. So when you get into 404 and you argue very forcefully under 404B2, this comes in to show absence of mistake. If that's what you have on your list, what you're giving it to the judge, in closing argument, all you can say is that evidence indicated it wasn't mistaken. The argument has to track the purpose for which it was being admitted under Rule 105. Do not misuse character evidence. In Robinson versus Taylor, Utah case, reversed a medical malpractice judgment because the plaintiff improperly argued in closing the facts of the 609 conviction that had been improperly admitted for credibility only. The prior conviction was for illegally distributing a controlled substance, an offense unrelated to the medical malpractice case. So it's a medical malpractice case, and they're trying to burn this guy because he sold drugs out of his unit. Sold like OxyContin, whatever the pain medication stuff. The prior conviction was for illegally distributing a controlled substance, an offense unrelated to the medical malpractice action. The plaintiffs exacerbated the unfair prejudice of the conviction by arguing that the patient had sold OxyContin from a parking lot, the subject matter of the prior conviction. In holding that the drug narrative was unfairly prejudicial, the court explained, the narrative is loaded with extraneous meaning that provokes imagery of a shady doctor abusing his authority to profit as a part-time drug dealer because of his description is so contrary to our view of the principled and professional physicians who thoroughly diagnose his patients in a traditional office. It immediately elicits an emotional response. The imagery it invokes entices the jury to reason that Dr. Taylor is a bad doctor because he's a bad person. So this is a 404 misuse, right? So you get in the fact he's convicted. If he gets in as a convicted, it goes to credibility. If he doesn't testify, it's not even relevant. If he testifies, you can say his testimony is not credible because he's been convicted. You can argue that. But you cannot argue in this case, he's a dirty drug dealer. And that's character evidence, misuse of the impeachment evidence. Do not misuse limited use evidence. Simpson. The court reversed and remanded a drug conviction because during closing, the prosecution argued that Simpson had conducted so many crack deals they couldn't remember the deal for which he stood trial. Do not argue artistic license. This case here, he made up in closing. The guy gets, in this case, the guy gets, they drowned the guy in a U-Haul, and they taped him up. And so he ends up telling a story, imaginary story. Scott drowning is bound with duct tape. It's pitch black in the back of the U-Haul. He does not know what's going to happen to him. He must wonder if he's going to live through the night. He's taken out of the U-Haul. He tries to talk, but he can't. All he can do is mumble. He feels the grass on his body. He feels the gravel of the road. A gun is placed in the back of his head, and 2 bullets are fired. Artistic license. None of that testimony came in. He's just imagining what was going on. In holding the argument improper, the court explained, in summarizing the evidence supporting a conviction, a prosecutor may not take artistic license with the trial evidence, construct a more dramatic version of the events, provide a conjecture about the victim's state of mind, and then defend against prosecutor's misconduct by maintaining the statements are fact-based. Sensationalization, loosely drawn from the facts, is still a statement of fact that jury not supported by proper evidence introduced in trial. This case is also a classic case. I'll just give you a summary. So the Wittenberg case is a case where the whole closing argument, he actually wrote this on he went to lunch and had a big napkin. He wrote all this out during lunch before the closing argument. But it's a fictitious letter that this guy wrote. The father supposedly wrote to his son, look, I'm going to go out, these companies, I'm going to die, it's their fault, and I hope you're okay, I love you, and all this stuff. That was 2/3 of the closing, was about a letter he wrote that never came into evidence, that didn't exist, just to get to the point. Do not attack opposing counsel. Class, coherency, control. So one of the things that comes up a lot is when prosecutors say their position's a smoke and mirror case. It's a red herring case. They use this as a red herring. And whenever you're suggesting that the attorney, the opposing counsel is cheating or doing something improper, class, coherency, control. It's not classy. Can't do it. Don't try to impugn the integrity of the opposing counsel. U.S. versus Young, U.S. Supreme Court. The defense against it has been presented unfairly by the prosecution. From the beginning, the prosecution statement made to poison your minds unfairly. The prosecution deliberately withheld exculpatory evidence and committed reprehensible conduct in attempting to cast a false light on response activities. Defense counsel pointed at the prosecutor's table and said, I submit to you that he's not a person in this courtroom, including the people at that table who think that he's intended to defraud. And then in rebuttal, the prosecution took the bait and said, oh, I'm sitting in the counsel. I think he did. So he expressed his personal opinion. In rebuttal, the prosecution properly answered, I think defense said that not anyone sitting at the table thinks that he intended to defraud. Well, I was there. I think he was. And I said, invited error. You're the one who picked the fight. And they, no, don't do that. U.S. Supreme Court, don't do that. No critical remarks about the opposing counsel. Comments about the prosecutor to the effect that his defense job is to mislead the jury, to denegate the property. This back to the Barfield case. We're running out of time. This is a good. So the guy looked up the definition of liar. He read it to the jury. And the guy in rebuttal says, in 20 years as a prosecutor, the hardest thing I've ever had to do is sit here with a straight face when a criminal defense lawyer had to look up the definition of lie in a dictionary. Why? I thought it was printed on the back of their business cards. Reversing, the Supreme Court said, we similarly condemn that to leave such conduct uncorrected would result in damage to integrity, reputation, fairness of the judicial process. That was not the only thing. There was a whole bunch of stuff other than that one. Because the disparaging remarks were made during the rebuttal, especially bad. Be classy, right? State, be classy, right? It's who you are. It's who you ought to be. And there's a whole bunch of red herring arguments and trying to suggest that what the other people do, smoke and mirrors. They're trying to trick you. They're being dishonest, the opposing counsel. You may think that. You can't say it. You can't argue that in closing. Do not argue the other side attempted to deceive you. This is back to Sue Hill. This is unprofessional. I can't believe this happened, but Sue Hill, there's no real question that prosecutor used a profane term. He called chicken, feed, bowl, as a pejorative description for one part of the defense's theory. We don't swear, by the way. My students swear in my class. I stop class, coherency, don't ever swear. Don't swear in court. That's what, and it's part of just being classy. Right? Do it right. Red herring arguments. Do not argue religious doctrine. I've already talked to you about that. I'm running out of time. So I already told you about the State versus Lovell case. And anyway, what happens a lot of times is that that people missed argument and then and then they don't get reversed because of invited error. But I like this last quote. I'll finish with this quote, and I'll try to finish exactly on time. This is a Florida court. I write because I'm disturbed by the increasing number of improper arguments that appear in the trial records that come before this court in both criminal and civil cases. See, he's trying to keep me. It's actually 2 minutes early.
I thought I could turn that off.
Yeah. However, the courtroom is not an arena for testing the relative strength of gladiators. It is a place where citizens of our state expect to settle disputes in a manner more civilized than hand-to-hand combat. In fairness, the conduct in this case was not nearly as egregious as has been observed in other records. In this case, the prosecutor offered his personal opinion of the evidence. He offered his personal opinion of the credibility of a witness. Lance Brown, he's probably dumb as a stump, but I respect him. At least he was honest. Trial attorneys must avoid, I don't know, that doesn't sound like a compliment, but the trial attorneys must avoid improper argument if the system is to work properly. If attorneys do not recognize improper argument, they should not be in the courtroom. If trial attorneys recognize improper arguments and persist in doing it, they should not be members of the bar. All right, so I'll just finish on that. So thanks. And I gave you 1 minute. I got by my phone, we're at 12:29. I'm supposed to go 12:30. All right, I didn't give you a chance to ask any questions.
Thank you so much. Appreciate Professor Mangrum being here with us and giving us so much time. It was an incredible presentation. So let me tell you what our schedule is for the next little bit. Lunch is outside. There's 2 tables. You can go, just like breakfast, go down either side. We'll come back in here and we'll give you some time to get settled and start eating a little bit. And then we will go into our presentation for Prosecutor of the Year. After we make that presentation, Attorney General Derek Brown and some of his staff, Stu Young, his criminal deputy, are here. They're going to talk to you for just a couple of minutes about what his vision is, Derek's vision is for the Attorney General's office. And then we will assess where we're at, and it could be that we will be able to start with Jamie's presentation on the civil legislation a little bit earlier than 2 o'clock. But, take a few minutes, hit the restroom, grab some food, come on back in, and we'll get started here in about 15, 20, 25 minutes. Hopefully you have enjoyed your delicious chicken fajitas. That's kind of a joke at UPC. If you want to know what the inside joke is, ask us. We are needing to alternate what we do. So instead of doing our Prosecutor of the Year award, we're going to invite Derek Young, our Attorney General, and Derek Brown, our Attorney General, and Stu Young, the criminal deputy, to come up. And they're just going to take just a couple of minutes, 10 or 15 minutes, and they're going to talk to you about Derek's vision for the office. He spent some time this morning with the county attorneys, had a great meeting with them, but we'll give Derek and Stu some time, and then we will do our Prosecutor of the Year award. So Derek and Stu, I'm just going to give you the handhelds as opposed to putting you on a lapel.
All right, great, thank you. All right, first of all, this is Stu Young. Stu is is now heading the criminal department of the Attorney General's office, and I appreciate you being here. Appreciate what you do. See a lot of friends, people that I've worked with through the years. What's interesting is I spent the last year during a campaign, which was fun. As I like to say, when I started the campaign, I was about 6'3". So this will teach you, for those of you who want to run for office. I was amazed at how many people had no idea, literally no idea, what the Attorney General does. I think most people view it as someone in the Capitol building who's got a team of 15 or 20 prosecutors, and that's it. Few people know that there are upwards of 300 attorneys in the office, close to 600 people total. In fact, I wasn't aware of the magnitude of what we do until even on the second day on the job. Interestingly, we had I'm on the Capitol Preservation Board, and we had a really interesting sort of politically heated meeting. I mean, like literally the day after I was sworn in, and there was an attorney there who did all the legal advice and gave some great insight for some tricky issues. And afterwards, I'm thinking, this guy's really good. Like, this is the kind of person I want to hire for my office. And so I went up and just said, hey, you did a great job, great counsel, great advice on some tricky issues. Like, who do you work for? And there's this weird pause. And he goes, sir, I work for you. I'm like, okay, got it. So it's been an interesting journey to sort of straddle both the law and politics. And politics comes from a Greek word, politicks. Poly meaning what? Many. Ticks meaning small blood-sucking creatures, right? And so we deal with a lot of that, but I'm enjoying being in the legal part of this. I've spent a lot of time in the past couple of decades of my career. I actually started, one of the things I really enjoyed, early on in my career, I clerked for the U.S. Court of Appeals for the Third Circuit. And we had a lot of criminal cases, for some reason, a lot of sentencing cases. And one of the most memorable cases I had was it was an appeal for a guy who was convicted in the bombing of the World Trade Center in '92. Do you remember World Trade Center was bombed in '92? Before September 11th. So this is the guy that was convicted in that, and there was an appeal on it was like some Sixth Amendment confrontation clause issues dealing with secret evidence, because that's one of the exemptions under the Sixth Amendment. And the hearing was set for September 11th. So it was a really memorable, interesting sort of opportunity. And so anyway, through the years, my background, I've worked with a number of you in this room. Most of you I haven't worked with. I've been legal counsel for Senator Bennett, worked with Senator Lee. Actually, Mike Lee and I practiced law together at the same firm in D.C. I spent some time in the legislature. I was on the law enforcement committee there and worked on a number of bills with county attorneys there. But what I've realized is that there's this it's kind of a cruel joke that you're sworn in as the AG, and then the following week, you have to go and defend yourself in front of the legislature. So we have a 45-day legislative period, and my team, we spent a lot of time working through the legislative issues that are part of that. Many of you, we did two things. First off is we defended or were on the receiving end of an audit. A lot of you probably saw that. Our office was audited. And I spent some time, I think we've addressed most of the issues in that audit, but we're still working on a lot of those issues. And so just to be totally frank with you as an organization, to the extent that we can do things better, please reach out. To the extent that there are things, one of the issues was, and Stu maybe can touch on this, but prosecutorial discretion, how we measure that, how we identify the cases we do take, the cases we don't take. So those are the kinds of things that we did as part of the audit. The other thing that we did is we spent a lot of time with the legislature. My team, some of the others are here. Let me just identify really quickly. We have my chief deputy, Dan Burden. For those of you who don't know Dan, he's over there in the bow tie. We have Aaron Wynn, who's in the back. And those two spend a phenomenal amount of time with our legislature really advocating, because there's a couple of things they did this session. One is there were a lot of bills, and I know that most of you sat through a lot of discussion about the bills that were passed. There were a lot of enhancement bills, right? And reasons for that, the most obvious is that you have 104 legislators, any one of which can introduce any bill on any topic at any time. And so there tends to be this piecemeal approach, which is why the governor, after signing most of these bills, created this task force. And so that's one of the things that was kind of an overarching theme in the legislative session. Literally, I think every time I met with a member of the Senate, they'd say, hey, this isn't one of those enhancement bills, is it? Boy, there's a lot of those. But there are reasons why we are doing that, and there are reasons why those bills were being advocated. The other thing that the legislature did that has been very helpful is I've been trying to identify the areas where there is bleeding, where there's places where we really, really need significant help in the office. One of those is in the area of criminal appeals. We have a bunch of phenomenal attorneys that do great work in the appeals sections, but we are way understaffed. In fact, our head of it, David, this is David Simpson. For those of you who don't know David does our criminal appeals, heads that division, and they do a phenomenal job. But we also had the Court of Appeals that said, look, you guys are, because of bandwidth issues, we understand that, but still because of bandwidth issues, we're not going to grant, an extension. And so I went to the legislature early on and I said, look, this is what we need. And they said, look, the reality is money's not there. Some years there's a lot of money in the legislature and they're just sort of throwing it out. This year there was nothing. And so they sort of set the ground by saying, look, you're probably not going to get anything for the office. In the end, they did. They gave us additional funding across the board, but they also gave us, importantly, a number of slots to hire in criminal appeals. And so just know, David's currently hiring. If you know great criminal appeals lawyers, talk to David. This is an area where we really do need help because for whatever reason, the number of appeals and the length of the briefs has dramatically increased over the years. And we could probably talk more about that. And someone like Jeff could probably give us an understanding of why it is that's the case. But this is a critical area for us as an office. And so just know that from my standpoint, that's something that I want to continue to address. So let me a couple of things that I want to look at during my time. First of all, two issues that I want to focus on, and there will be more. I'm working through, now that we've had the legislative session complete, now that we've done the work there, we are working with our team to identify specific areas that we want to focus on. One of the things we did, just so that a lot of you know, is we did restructure the office. We have 4 different departments. We have a criminal department that has literally all of our criminal stuff in it. We have civil, which includes things like state agency counsel with Amanda's over there, who heads that. We've got agency counsel. We have another department entitled consumer protection. So those are the cases that we're doing against places like TikTok or PBM, the social media cases, that sort of thing. And then the fourth is our appeals. Our Solicitor General, Stan, runs that. And so those are the 4 areas that we have in the office. I've also, because most of you probably don't know this, I needed someone really to help me get in and dig in and make the office. We're the largest law firm in the state. I wanted it administratively, technologically to be at the top as well. So I hired someone that you may recognize. His name is John Dougal. Dougal was our state auditor for 12 years. And his role was helping build efficiencies and find areas where we can improve. So all of the admin for the office is being conducted and overseen by John, who's doing a fantastic job. So there's two areas that I do want to focus on. One of them, and you may have seen some press on this, but one is really, when it comes to protecting kids, we have a phenomenal ICAC team, and we have affiliates, how many around the state, 60, 70? Is it 90 now? We've got 90 affiliates, and that team does a phenomenal job. Some of you may have worked with that team. In fact, earlier this week, we had what we call Chat Night, where we have people, affiliates from around the state that come, and Tuesday night we spent some time with them. We had legislators there just observing, so they get a sense of what it is that the ICAC team does. We started this on Monday. As of today, we have, what's the number? Is it 12? It's 15 arrests. Not all of them are like CSAM, some are possession of guns and drugs and that sort of thing. But it's a very successful group. But it matters, and it matters to me because this is an issue where we can make a huge impact, and it's an issue, I mean, you've probably seen, I mean, we care about it, and we've got, as you've probably seen on the press, a sitting judge we brought charges against, as well as a sitting fire chief, only to discover after the fact that there was stuff there. So as you know, I can't get into details, but it matters. And this matters to me, it matters to us as an office. And so I just want to highlight that this is something that I believe we can make a huge impact on it. And the problem is, like so many things, and I know that you all deal with this as well, we're just scratching the surface on so many of these things. I mean, the big issue that we continue to talk about is resources. How do we improve on the resources? Another area that you're all seeing as well is the influx of drugs and fentanyl and what that's doing. And so, in fact, I'll be at the border in a couple weeks, taking a look at kind of what things are happening there. And I know there's some interesting issues taking place at the federal arena, particularly the U.S. Attorney's Office. And Stu can talk a little more about that because he spent 20 years doing that. But the reality is this is also a huge area that we need to really tackle. And we're seeing more of it than we've ever seen before. So anyway, ultimately, let me just say a couple of things. First of all, our job is to be a resource for you. We have a lot of resources. We've helped in the past a lot of the smaller counties that only have 2, 3, or 4 people. To the extent that you need help that we can provide, we're here to be a resource. We're here to help you. And if there are resources that we can get for you or that we can then share statewide, we are willing to do that as well. Second thing I wanted to say is that you've chosen a hard line of a hard profession. I mean, we have hard days, but what we do matters. And please remember to always reframe what you do in a way to understand that you're making a difference. In fact, I have a very good friend of mine who reframed, it was probably 10 years ago, we were having lunch, and he does exclusively family law, which I think is like the worst area of law imaginable. I mean, like I've joked about it for years. I call them the knives and forks lawyers because they fight over knives and forks. And I was joking with him and I said, how do you stand doing this? I mean, this is like I can't imagine anything more just emotional and grinding. And he goes, Derek, you're missing it. I love this. I'm like, what? How do you love it? Like, it's awful. He goes, no. He goes, think about it this way. These people are going through, my clients are going through what is likely to be the hardest time of their life. Like when their life is at the end and someone says, what was the worst moment of your life? They're almost certainly going to point to the moment where I am there holding their hand, walking them through. He goes, it's an honor. And yes, it's hard. And some days just suck. And some days you go home and you go, I'm not making a difference. But he said, I love what I do. And for me, it completely reframed that area of the law. And I hope that you can have that mentality as well because you represent the people. You represent the individuals. You represent the people. The stats that we don't have are the stats of people who are protected or who are not victimized because you do your job. In fact, a couple of weeks ago, we had a retirement of Craig Barlow, who I know a lot of you probably remember Craig. And I was his intern, by the way, back in 1997. And we've joked that he looks the same as he did in 97. And we sort of gave him a bad time as he graduated, as he retired and went out the door. But I was thinking about it as I got in the car, and I thought, we will never know how many people were not victimized, abused, killed, etc., because he spent all those decades doing what he did. And you do that as well. And I appreciate that. I appreciate the service. And I just want you to know that from our standpoint, to the degree that we can be helpful, to the degree we can be a resource for you, that's our role. And I am still, admittedly, brand new at what we're doing, getting familiar with the ins and outs of the political dynamics and the fact that we have almost 600 people in the office, but they are busy, they're doing a lot of great work, and to the degree that we can mobilize those resources to help you wherever you are, please let me know. So on that note, let me introduce Stu Young, who comes to us from the U.S. Attorney's Office. One of the changes that I made is in that criminal department. We brought Stu on from the U.S. Attorney's Office, and he has, I couldn't even read all the different awards he's got, but he's been doing everything from Metro Gang Unit to drugs. And in fact, last year he spent a couple of months over in, was it Jordan? In Jordan, doing international terrorism prosecution. So this is someone who, part of the reason I hired him is to signal to everyone that we are serious about crime. We are serious about going after the people who commit crimes in our state. And I can't think of anyone better to lead that up. So with that, let me introduce Stu Young.
I'm Stu Young, and I love being at the Attorney General's office. One of the reasons I love being at the Attorney General's office, I get to work with some excellent people. I've really enjoyed getting to know Derek. Derek and I did not know each other until right before your election. I work with Dan. I have some excellent prosecutors here in the room. I've really enjoyed getting to know the Attorney General's office, the staff, the prosecutors, and the state stuff. The second reason I love being at the Attorney General's office is because I'm not at the U.S. Attorney's office anymore. And that is mostly because I have gotten numerous calls over the last 2-3 months of my friends calling me in tears. And right now, at least for a number of federal prosecutorial objectives, that is being left to the states. And you have such an important role right now, especially when the feds are kind of gearing towards other prosecutorial interests. And so I really want to stress the fact that I'm grateful to be part of the state. I'm grateful to be part of your ranks. I have been a lifelong prosecutor other than a 2-year failed stint as a tenure-track law professor. I don't recommend teaching full-time. It was awesome, but it's just not as fun as being a prosecutor. And I was in San Diego as a federal prosecutor for many years. I did Mexican mafia and cartel cases down there. And then I've been up here doing just a lot of various different things, running a gang unit. Some of you may know Steve Nelson in the 3rd District. Steve and I ran a gang unit together for a number of years. I've done a lot of white collar. I've even had the chance to go and do some international terrorism. But what I'm very excited about is being part of the state prosecutorial ranks. And one of the things that we want to stress is that we are here to help. Unlike the federal government who says we're the federal government and we're here to help, and you kind of laugh at that, I hope that you will call on the AG's office. We have such great experts, subject matter experts that may be useful to you. For instance, Heather does a lot of election cases. She's amazing at that. Carl is our ICAC superstar. We have Jessica and Mike over here who do an excellent job in our white collar unit. We're not able to help on everything. We do have kind of pockets that we have, and then we do have some subject matter experts that would be available to you. And so I hope, one of my hopes is that if there is something that you need, if there's something that you're not getting hopefully you're getting all the resources that you need. But if there is an area or is something that's, that's tricky, or you're not getting exactly what you need, and you've reached out to Bob at UPC, and Bob's like, well, I'm not sure about that. Maybe we can find somebody. I hope you'll also reach out to the AG's office. And that in those instances that we can provide either resources, as in, more prosecutorial resources, or we can at least provide kind of somebody who's done those things that you're looking to do. I hope that, that you will reach out to us, that we will be able to provide that to you. And that's about it. That's all I kind of wanted to say. I'm just very grateful. I can't stress how much I have loved being a prosecutor. I've done this 17 and a half, almost 18 years now, and how important this effort is. And I'm grateful to you for the work that you do day in and day out. I know the late hours. I know the late phone calls that you're getting from your agents at 2 in.the morning. I've gotten so many of those over my years. And frankly, over the last 3 months, I've kind of missed it. So I just want to express my gratitude to you for the public service that you do to keep this state safe, to keep the people of Utah safe. And I'm very proud to be part of that effort with you on the state side. Thank you.
So let me just say that is not lip service. They're not just spouting off words. We're housing the AG's office, and we have been watching them since they took over since January, and they truly mean everything that they say, that they want to be a resource. So please reach out to them. All right, let me pull up my slide and move to. Let's see. That's not what you want. This is what we want. So I am pleased to announce, and I'd like to invite up Chad Grunander, who is UPC's 2024 Prosecutor of the Year. So I should have reached out to Chad ahead of time to get a picture, but I forgot, so I had to Facebook stalk you. And that was, one of your press conferences. So let me read the nomination, and then I will turn it over to Jeff to say a couple of things, and then we'll present the award. So Chad Grunander is the gold standard for prosecutors. During 2024, Chad kept it extremely busy as the criminal division chief, where he runs the office like a fine-tuned machine, puts out fires with ease, and was assigned as the lead prosecutor in the death penalty case of fallen officer Sergeant Bill Hooser. On top of all of his many responsibilities in 2024, Chad led the prosecution team, which handled the case of Provo Police Master Officer Joseph W. Shenners, who was shot and killed in the line of duty. On January 5th, 2019, Officer Joseph Shenners was working with a confidential informant to locate a wanted fugitive in Orem. A team of officers located the fugitive sitting in his vehicle in a shopping center parking lot. Several police cars quickly surrounded the suspect's vehicle, but the suspect refused to comply with officers' commands. After the passenger door opened, an officer attempted to arrest the suspect inside the vehicle, at which time the suspect fought the officer and began to drive away with the officer still inside the vehicle. Officer Shenners, without hesitation, ran to the aid of the officer still inside the suspect's vehicle, entered the truck, fought for control of the suspect, covered the officer with his own body, and was shot by the suspect. Officer Shenners fired back and struck the suspect once. Officer Shenners was rushed to the hospital but died shortly thereafter. After more than 5 agonizing years for the Shenners family, the aggravated murder case finally went to trial in February 2024. Officer Shenners' family and fellow police officers faithfully came to trial for nearly 3 weeks as Chad led the trial team. The jurors heard from nearly 40 witnesses, reviewed approximately 200 exhibits, and Chad successfully fought back multiple attempts from competent defense attorneys to have the case dismissed. Yes, there's more. Sorry, it's just in big print. That's why there's so many pages. At one point during the trial, Chad conducted the direct examination of the suspect's girlfriend, who was transported to trial from the Utah State Prison, and who had previously informed Chad that she would not testify for the state. On the morning of her expected testimony, the witness had taken certain medication which caused her to be somewhat loopy, and she had to be assisted to the witness chair. In attempting to assess her willingness and ability to answer questions and outside the presence of the jury, the witness was sworn in, and after being asked whether she agreed to tell the truth, responded, "F yeah." After determining that the witness was willing to answer questions, Chad asked the court to appoint the witness an attorney and to let the witness sober up in the holding cell before moving forward with her testimony. After sobering up, the witness was once again called back on the stand, this time in front of the jury, where Chad, with the skill of a master surgeon, was able to secure multiple admissions the defendant made to the witness, which demonstrated his intent to get into a shootout with the police if they attempted to arrest him. These admissions were crucial to the state's case. After deliberating for a little more than 3 hours, the jury convicted the defendant of aggravated murder, possession of a weapon by a restricted person, failure to stop at the command of a peace officer, and possession of methamphetamine. Tears flowed freely from family and friends after the jury finally held the killer responsible for taking the life of a wonderful man, a loving husband, a father, and a son who was simply doing his job. Officer Joe Shinners was a 3-year veteran of the Provo Police Department and a member of the Patrol Division. He is survived by his wife and 2 sons. At sentencing, Chad successfully argued that the judge sentenced the defendant to life without the possibility of parole, and that all other charges run consecutively to each other. And in Jeff's comments, he's going to share the last part of the nomination, but I give to you our Prosecutor of the Year, Chad Grunander.
So the first decision I had to make as county attorney was who my chief deputy would be. Legal advisor. Prosecutor, and I'm so appreciative of him, and he's become a good friend, and I appreciate that. You know, as we've hired about, I think, close to 20 attorneys since I took office 2 years ago. And one of the things that we've talked about is we're looking for a prosecutor. A prosecutor is a rare breed, and not everybody is a prosecutor at heart, and that's what we're always looking for. And what we're looking for is someone in the mold of Chad. What makes a good prosecutor? Expert legal skills. Chad possesses that. From his understanding of the law, if he doesn't understand the law, he learns it. His trial skills are unmatched. I'm sure that many of you, well, some of you, those old enough to remember Perry Mason, who was he was the defense attorney that was able to extract confessions of others that committed the crime rather than the defendant. Well, Chad's got this, but it should be a new show called Chad Grunander. In that trial, the Officer Shinners case, we called an expert, Chad called an expert to discuss felony arrest, essentially. Ken Wallentine, many of you will know him. And because the defense was kind of attacking the nature of this arrest and how police went about it. So the defense thought it was a good idea to counter that expert with their own expert. And Chad was able to get him to admit that expert, that Ken Wallentine was the preeminent authority on felony arrests. So that's the ability of Chad. The other thing we look at, in addition to your legal skills, is a commitment to justice. And Chad has that commitment. That's always on his mind in every case that comes across his desk, in the cases that come across our desks. The third one is integrity. So important as prosecutors that we have integrity and that we act professionally. And Chad, again, is the quintessential example of that. And the fourth one, as I was reviewing this, is a big heart. Prosecutors care. And Chad cares about the cases, and he cares about everyone. It's not just the case, but he cares about the prosecutors in the office, the staff in the office. He cares about seeing that justice is done and that victims be heard. And I'm just going to close it with the last statement that I couldn't say it better. And I want you to know that the nomination came from Tim Taylor, who is another tremendous prosecutor in our ranks. And to have that kind of praise from somebody of that caliber is an added honor. So Chad's overarching contribution as a prosecutor is his undeviating integrity and the professional way he treats everyone with whom he associates. Colleagues, defense attorneys, and victims. Chad doesn't follow the rules of professional responsibility because it is mandated. Chad lives his life committed to the golden rule. If all attorneys were of the same caliber as Chad, the legal profession would truly be the respected envy of the world. Thank you.
I told Chad he could take 10 or 15 minutes, but I think he's just going to take a few.
Just really quickly, wow, I'm not sure how you follow that up. Thank you very much, Bob. Thank you very much, Jeff. The Officer Schinner's case was an important case for our office. The prosecution team, we had one primary goal, and that was to represent Joe and his family well. And we had a lot of support on that. So I want to recognize Tim Taylor. So Tim, stand up. Tim was co-counsel on the case. So awesome job. He's been the backbone of our office for many, many years. Chelsea, go ahead and stand up. She was our paralegal. Impossible to wade through, thousands and thousands of pages of discovery without a paralegal like Chelsea. So thank you for your work, Chelsea. But it's great to be recognized. Thanks for those that supported my nomination. But I know that there are so many of you that are equal or more deserving of this. So I appreciate it. And thank you very much.
Okay. Several of you have emailed or texted me asking if Professor Mangram's slides are going to be available. He declined to provide us a copy. He said that the slide deck that he uses has over 1,000 slides in it, and he just kind of picks and chooses. So we will not be able to provide you a copy of the slides. We will have the video of his presentation up within the next week or two. Bill Francis, our amazing videographer back here, will get it to us really quickly, and we'll get that up, and so you can go back and watch it and take notes as you would like. Okay, but he also gave you his email and phone number, and if you didn't get it written down, we will have that, and as he said, he truly will take your phone calls and emails for any questions that you have. So it is 1:30. Let's take a 10-minute break while we get Jamie's slides set up, and then we'll 1:40. I have to leave. I'm going over to Denver to a tri-state job fair. I'm representing many of the offices here in the state, and hopefully we can bring some folks back to the state of Utah to fill your offices. So back at 1:40.
this morning. I also have it on good authority that Jamie was entertainment on cruise ships for some time as well. No? Marilyn, did you make that up? Okay. But we'll turn the time over to Jamie. Jamie, thank you for being here. Appreciate you.
Thank you for letting me come once again. It's always flattering to be invited back. It's like the worst time slot though, right? You guys just ate lunch, you're ready to fall asleep. It's like, I'll try to keep it somewhat entertaining, but I won't be offended if y'all snooze on me. I may pick on you though. Once again, we're back with my ABCs of the legislative session. This focuses on the legislative bills that were passed that deal with civil issues in government. I am a civil attorney. I'm deputy city attorney now for the city of St. George, and he's right. I do not miss the snow. When I drove up last night and saw snow, I went, oh yeah, that. It was it's been really, really nice not to have to shovel anymore. But it was an interesting year. It was an interesting legislative year for anybody who tracked it. I was so motivated this year that I was going to be on top of every bill file as it came in. I was going to take notes. I was going to be prepared. Yeah. And then I saw how many bill files there were. This was like, I think, the most bill files we've had in a legislative session. There were over 2,000 bills to try to keep track of. And of those, 582 passed. Very interesting session. However, I think if I'm going to pick a letter of the year, it's going to be the letter R. Well, wait a minute, I'm going to go back. So last year, just to compare, was only 2,060, but we passed more bills, or the legislature did, not me. 2023, that gives you a comparison. And in the pre-COVID, the last pre-COVID session, you can see it was only 1,600 bills. So again, there were a lot of freshman legislators, lots and lots and lots of bills. There was rumor that they were going to limit, that leadership was going to limit how many bill files each legislator could open, but that didn't happen. So anyway, again, going back to the letter of the year, it's R. For revenge, retaliation, retribution, whatever you want to call it. It was really interesting to watch what happened because after last year's legislative session and some things going on, leadership in the House and the Senate really shook things up, and the people that went against leadership are no longer sitting as committee chairs. They got removed. There were committee shakeups, and so you had a lot of new faces and a lot of new makeups on some of the committees. There were a lot of bills aimed at the courts, and especially the Supreme Court, because they didn't like the rulings that the Supreme Court came out with. I don't know if you followed, Brady Brammer had several bills that were just like really aimed at the courts. And they were mad. They were mad that they got smacked down. I know the feeling. This one was also a Brammer bill, this one that removed the attorney privilege and the attorney work product protections for legislative audits. Very interesting, very interesting. We'll talk about that one a little bit later. But just out of curiosity, in terms of the civil stuff, when you deal with like water and elections and taxes and land use and housing and all that kind of stuff. Anybody want to guess what the number one category was this year for the most bills? Housing? Well, you're up there. So there were 13 water bills, 16 election bills. There were 24 tax bills and 25 housing and land use bills. That's a lot. We'll try to get through most of this, but we'll go on to the alphabet. All right, here we go. You awake with me still? So far, so good? Okay. A this year is for the attorney work product privilege, attorney privilege and attorney work product privilege. Again, there was an audit that the state legislative auditors did, and I think it was with regard to the former Attorney General, and there were some documents that weren't produced, and the legislature got mad, and so they passed a bill that says that privilege no longer exists, and attorneys have to turn over attorney work product, all your notes, all your drafts, if there's a legislative audit. Anybody like that one? I hate it. I think it's ridiculous. I don't know where this is going to go. I don't know what kind of challenges we're going to have. But, you know, they reiterated that the privilege exists for everybody else except the legislature and a legislative audit. Senate Bill 96 is not in your packet, but I wanted to, you know, we talked about this one last year about the Advanced Air Mobility Bill. That's really what this is about, but what they're talking about is these eVTOL vehicles. They're electric vehicles. They're basically drones on steroids, but they act as transportations, personal transportation. They take off and land or are based out of airports, small municipal airports, and they're like taxis that are electric vehicles, but they're drones, and they fly you everywhere. What this bill did is basically said that the Department of Transportation needs to come up with some model ordinances and model regulations for those jurisdictions that have airports that we can use, because these things are going to be a reality in a couple of years. And they're going to start flying. In fact, in St. George, we already have people producing these down where we are and testing them between St. George and Vegas. So it'll be interesting to see how quickly this develops, but hopefully we get some model order. How many of you guys have an airport that you deal with? A few of us, yeah. So we'll see what the model ordinances come up with. Okay, B is for bonding. Those of you that are elected know that when you get elected, you have to post a bond to make sure that if you engage in criminal conduct or, you know, misfeasance, malfeasance, that somebody can collect against the bond for that activity. This bill basically changes it because most of us actually don't have bonds. We have insurance through the trust or through USIP. And this bill allows that and basically says that's what you should have is the insurance, not necessarily the bonds. So the days of the bonds are gone. Woohoo! Because, you know, nobody even knows if there is one. C is for critical infrastructure. That's what Utah decided to call sand and gravel operations. They're critical infrastructure because we need them to build roads and subdivisions and everything else. Some of you may remember, I think it was, if memory serves, it was 2020. In the 2020 general session, right before COVID, there was a bill passed. They were trying to expand these sand and gravel operations. The fights were at like Point of the Mountain and some of these other locations. And the mining companies or the operators wanted to be able to expand without getting new permits. So if you had a permit for this parcel of land and you were mining this parcel of land for sand and gravel and you also owned the parcel next door, they could just automatically go in there. Well, the land use people, we fought back. We were able to come up with a stalemate. Logan Wild was in the legislature back then. We came up with a bill that sort of put everything on hold, status quo. Nobody expands, nobody can grow, everybody says the same, and then COVID hit and we never fixed it. The idea was, you know, we would come back the next year. This year they came back and they kind of sort of fixed it, at least the status quo is gone. And this does allow sand and gravel operations to expand into neighboring property if they own it before the bill takes effect on May 7th of this year. If they own the land, then they can automatically expand and grow their operation, and they do not have to come in for any kind of land use application. So yeah, that's a great one for local jurisdictions because you're going to have these huge mining operations that get bigger and bigger and bigger. But they can't go out and acquire more property now. They have to acquire it all before, you know, next week or 2 weeks from now. I can't say this is a great bill, and hopefully it does get amended, but that's where we are right now. Okay, I like this one. D is for disclosure. This requires the Lieutenant Governor's Office to amend their financial disclosure website so that you can search If I want to pick, let's see, Eric, I'm going to pick on you. If I want to search and see all of the people that Eric Clark gave campaign contributions to, I can look it up by his name. I can say, okay, who's Eric giving money to? And I can look that up and see all the organizations and people that he's contributed to. They don't have that ability now. This makes them have to do it. And we're on elections. And some of these are going to be, they're not just minor changes. As you know, some of them are big, like House Bill 300 changed the vote by mail system so that by 2029, it's an opt-in. It's not automatic vote by mail. You have to opt into that if you want to mail the ballot. But House Bill 27 allows counties to create non-contiguous voting districts. Okay, maybe that's helpful. House Bill 109, does anybody know who fired their manager and changed the rules? Because this is clearly one of those anecdote bills that says a city council in a lame duck session, meaning from the election day to when they take office, can't change the rules on how to fire a city manager. It's so specific. Anybody know the story behind that one? No? Grandma changes because, again, I think it was Phil Lyman's campaign kept making grandma requests of everybody to get all the voter records. And they were denied. There were some appeals to the State Records Committee. This clarifies that if there's a video of the counting process, that's a public record, but the actual ballots and the voter information is private. There's another bill that we'll talk about in the grandma section that goes with this one. The tie breaking. Last year there was a bill passed that said in the event of a tie between two people, here's how you break the tie. It's still a game of chance. But this year they added it to say, okay, well, that counts for three-way ties too, because apparently there was a three-way tie and nobody knew how to break the tie. House Bill 481. This is one of those retaliation bills I was talking about. This changes how a proposed constitutional amendment is published. You guys may remember in the League of Women Voters case, the legislature they drafted this constitutional amendment, but they didn't publish it in the newspaper like they were supposed to, and the Supreme Court smacked it down and said any votes cast for that in the last election, in the 2024 election, don't count because it wasn't properly noticed. So this bill says, okay, the noticing is now not through newspaper publication, the noticing is now on the Utah Public Notice website, but it only goes if the constitutional amendment, which is House Joint Resolution 10, passes, so that's going to be on the ballot. Conflict of interest disclosures have changed a little bit. If you're running for office, you must file one at the time you file for candidacy. It used to be you filed it later. Now you have to do it at the time. And what's required, the required information has changed a little bit. So if you're representing municipalities, we've got a campaign filing season coming up in June. Make sure that your forms are up to date so that when candidates come in to file for office, they're filling out the correct information under this bill. And this is another, House Bill 551 was another one, like, who did this? What's the story behind it? But apparently there was an official that used public funds to put their name or their face on a billboard. I don't know who it was, but this prohibits it. So you can't use public money to put your name or face on a billboard if you're an elected official. Anybody know what the story is? See, I don't get the dirt anymore now being down in St. George. Senate Bill 53 is just about removing names from petitions. This may come up in, I read in the Salt Lake Tribune today that apparently the folks protesting the anti-union bill filed enough signatures, or have submitted all their signatures. They were due Wednesday, and now they're going through to verify them. And this process in Senate Bill 53, if people want to remove their names from that, then this is a new process to do with it. Senate Bill 54 deals with people that go by nicknames or short names. If your name's Michael and you want to be Mike on the ballot, or if you want to be John Frugal Dougal and have a nickname, this tells you how to do it. Senate Bill 73 requires a statewide initiative to be published in the same manner as the constitutional amendments. So we'll see how that works and whether or not that amendment changes. And Senate Bill 18 requires state higher ed to allow the use of their facilities by political parties. So apparently there was a political party that wanted to use some place at a university and they wouldn't let them. So there you go, there's a bill. Last but not least, county clerks have to coordinate with the U.S. Post Office in receiving the bills on time. Again, this was I think it was an Iron County issue, if there's anybody from Iron County, about not counting ballots because in Iron County they go to Vegas first and then they have to come back and they weren't postmarked in time, so they didn't count. Again, I think it was a Phil Lyman challenge. Senate Bill 90, those of you running for an elected attorney position, county attorneys, district attorney, attorney general, at the time of filing, you must prove that you're qualified for the job, that you actually have a bar license. Have a certificate of good standing when you file for office. And then the Senate Joint Resolution 2 is another proposed constitutional amendment that says you have to have a 60% majority for statewide initiatives, not just a regular majority. And so, Joint Resolution 7, Senate Joint Resolution 7 says that only states can regulate state and local elections, not the feds. Now, that's the rule anyway. I don't know why they do this, but there you go. All right, F. F is for flags and fluoride. Most of you know that there was the controversial flag bill, so that now governmental entities are not permitted to fly, well, the rainbow flag, basically. That's what it was aimed at. And then House Bill 81 prohibited the addition of fluoride in a public water system. But what they did do is they said you can get a prescription for fluoride from your pharmacist. You don't have to go to a doctor. The pharmacist can now prescribe fluoride if you want to get fluoride. So, and we'll talk about that a little later as well. All right, here's the grandma bill. Again, House Bill 69 goes with the other one we talked about that classifies voter records as private. And the big one, Senate Bill 277, got rid of the State Records Committee. So Todd Sharon, he's probably not here. He just got fired from the State Records Committee. But the State Records Committee is still going to be in place until they have a new ALJ. So even though this bill takes effect, I think, May 7th, chances are good you still might have to go to the State Records Committee for a while until they get it all organized and hired. Anybody like this? Hate this? Anybody been to the State Records Committee? It's wonderful, huh? It will be nice. If you've been to the State Records Committee, you'll understand that it'll be nice to have somebody that actually understands the law, what grandma really says, and can apply it sort of uniformly. That will be a very nice thing for those of us that have been there. Senate Bill 169 on the governmental immunity. All this does is said if you have an entity that may get sued, which really is only the political subdivision, right? But for whatever reason, if you have a DBA for your organization, for example, if St. George City has a municipal building authority or a neighborhood redevelopment agency or whatever it is, we have to register those names too with the registered agent with the Division of Corporations. So as it stands already, all the political subdivisions have to register, but now our DBAs, even though they really can't be sued, we still have to register them. So there you go. I like this one. We now have official holy days in the state of Utah. These are not state holidays, but they are recognized holy days. There is a list of holy days, and I tried to practice how to pronounce some of them. But so you've got Easter Sunday is now also a state holiday under this bill. But it's not recognized on a Friday or Monday. It's only recognized on the Sunday. So if you've got, police officers or somebody that have to work on Sundays, that is now a state holiday. But that's the only one that was added. But these other holy days, Good Friday, Eid el-Fitr, Passover, Vesak Day, Rosh Hashanah, Yom Kippur, Diwali, some of these others are recognized as holy days, and state employees are allowed to take time off to celebrate those. I is for Ireland. We now have a Utah-Ireland Trade Commission. Woohoo! It's like, okay, maybe we'll have our own tariffs, who knows? J is for judiciary and judicial standing. So as I talked a little bit earlier about, there were a lot of bills aimed at the judiciary and the courts. The one that did pass, Senate Bill 296, did pass. It's the one that would allow the governor to name and appoint the Chief Justice of the Utah Supreme Court. That's why I have a picture of Justice Durant, Chief Justice Durant. But that was vetoed by the governor. So at this point, none of that effort was successful. I can't say that it won't be back, but it probably will. Senate Bill 203 addresses a weird series of cases. Some of you may have read last year, there were about three or four Supreme Court cases that came out last year that addressed standing. And it sort of knocked the traditional standing test on its head, and seemed to say that really, unless there's some sort of statutory standing, you can't bring a case. They were really weird. I mean, and they were just really weird, is all I can say. This statute seems to address that, this bill. And so it basically brings back the regular traditional standing test for federal court and for state court. And because now it's adopted as a law, it's statutory standing. So so we can comply with what the court's rulings are. But if anybody understands what that is, I mean, basically, I'm glad they did this. Let's just put it that way. I'm glad they did this because nobody really understood who could sue and be sued under those cases last year. Okay, K is for Kings. I couldn't really think of a good one to bring this one in on, but I needed something for K, so here you go. This is under the Constitutional Sovereignty Act. This is the act that was passed either last year or the year before, I think, that basically said the 10th Amendment rules and we are sovereign, and federal government, you can't tell us what to do, because, the Utah legislature in their schizophrenic way likes to say feds butt out, but then they like to also, they like the idea of federalism, they support federalism, federal government stay out, but oh, by the way, we're going to tell local governments what to do. They sort of don't see the hypocrisy there. But this one amends the Constitutional Sovereignty Act so that school employees are now also considered government officers, and what that act does is basically say government officers can't enforce federal law if it's contrary to the state, what the state wants, basically, in the state law. So, interesting, but has to do with some of the immigration stuff. We'll see how this one plays out. But now it involves the schools as well. All right, land use and housing, I sort of grouped those all together in those 25 bills. I'm not gonna hit all of them. Most of them are in your packets. I'm gonna sort of hit the highlights. I could spend 2 hours just on this stuff. We'll go through it really, really quickly. In the building permit, building world, there were three that were really, you probably want to take note of. HB 58 addressed building inspectors and building officials. It now has requirements. If you're going to name somebody as a building official for your city or for your county as the chief building official, they now have statutory requirements they have to meet that includes like 6 years of experience and qualifications and yada, yada, yada. So they have to do that. And so you want to make sure that, obviously your folks are compliant. House Bill 435 was a bill passed by Mike Kohler, who's out of Wasatch County. And this one basically says if you're building what's called a quote-unquote high tunnel, anybody know what that is? It's basically a hay barn. It's anything, it's a building that's used to cover agricultural materials, whether that's being stored or grown or whatever. They're called high tunnels. And these no longer require a building permit. And so they're exempted out from the building permit requirement. And then House Bill 550 basically says you cannot charge a water conservation district any building permit fees. So there you go. Eric, doesn't your office represent a water conservation district? They have their own attorneys, yeah. So in the signage world, there were a couple of sign bills. One was pretty minor, but this one is the billboard bill that basically, this is the fight about if you require a billboard to move because you're putting in a highway or relocating the highway or whatever, and you're triggering a move, the move has to be within the same city. You can't move a billboard into a different city if it's being moved. And then housing, there were three bills that I think are really important. House Bill 37 basically allows jurisdictions to give incentive density programs for affordable housing. That's a good one. Senate Bill 181, really pay attention to if you're in this world. This one focuses on affordable housing and things that jurisdictions need to do to make housing more affordable. One of the things that's in there, they define what affordable housing is finally. So when you use that term, it means housing that meets 80% of area median income or below. But it also defines how big your parking spaces can be for a house. So it says that if you have a covered parking space, it can only be 10 by 20, and you can't require that it be any bigger than that. That's for your garages. For your driveway spaces, the uncovered parking, you can only mandate 9 by 20 spaces. So St. George, our city council was really mad because big trucks with long beds and trailer hitches were hanging over into the sidewalks and it was interfering with people, so they passed an ordinance that said all driveways must be 25 feet. Well, guess what this bill does? Just wipes out that St. George ordinance. So driveways can only now have to be 20 feet. Senate Bill 262, again, recognizes that consent agreements are legitimate settlements of lawsuits and that you can do them and that they're legal and you don't have to go through the Planning Commission. They can just be settled by the legislative body. Okay, the big land use bill this year was House Bill 368. It covers a lot of stuff. I've sort of focused on some of those things. They came up with a ministerial land use regulation, which is a total oxymoron and I think is probably unconstitutional. I don't know that one's going to survive. They changed how annexations are done. They've changed how you change municipal boundaries. That addresses the identical plans. So if you come in, if you're a home builder, an Ivory Homes, and you've got Plan A, B, and C, and Plan A, B, and C have already been approved by that jurisdiction and other developments, you don't have to go through a plans review. And there's a very simplified plan review for those kind of plans if they're identical. Plan review, private maintenance of public assets. We can't require private HOAs or other folks to maintain our public assets. Prohibits public hearings for variances and appeals. I don't know who was doing that, but that's a good thing because public hearings for those are really bad ideas. And then on the last one, it modifies the fire code for the road standards. So it used to be that, subdivisions required that you had curb, gutter, sidewalk, pavement. That's part of the essential infrastructure for a subdivision before you can start selling off lots. This changes that so that as long as you meet fire code, and fire code requires an all-weather surface, it doesn't require paving. So now you can start building your subdivision with a graveled road, not a paved road, but eventually you have to do the paving. It's weird. And I don't know the story behind this one, but that changed. Some of the other stuff is, the good news is we can now enforce short-term rentals again by looking at the Airbnb websites and the VRBO websites. We can start doing that enforcement again. We got that ability back. There's a modification to how you subdivide ag lands and whether or not it's a subdivision in House Bill 255. Boundary adjustments. The surveyors of the world got together and passed this bill, Senate Bill 104, and it's really bad. But essentially what it says is you can change lot lines or change property boundaries by agreement. That's fine. And you do still have to get the local land use authority's approval, but you can do it without amending plats. Now that's the bad part, because that really screws up your county recorders and your county assessors. So most jurisdictions are still going to require a plat amendment. And the law says that if the local jurisdiction requires a plat amendment, you still have to do that. But this is a really weird, bill, and it does things that I think the county recorders are going to have a really hard time with, and the county assessors. And then Senate Bill 179 requires a land use regulation or a land use authority to review business license uses. And it requires that you set up this process why, okay, if there's a use for a business license, it gets reviewed by the planning department. Okay, M is for massage. I put that on there because I'm a firm believer in my every other week, hour-and-a-half massage. But this modifies the licensing requirements for massage therapists. It talks about what's unethical behavior, obviously. It requires some background checks. It beefs up basically the massage licensing so that it's more therapeutic, less fluffy, more therapeutic. Nonprofit, government nonprofits, there were a couple of tweaks. One of them was that they excluded the Utah Association of Special Districts as a governmental nonprofit corporation. I don't know why, but they did. And it does require a governmental nonprofit. UAC would be a governmental nonprofit. The League of Cities and Towns is a governmental nonprofit. And it requires them to post financial information, just like any other governmental entity, on the Utah Public Finance website. O is for OSHA violations. They upped the fine for each serious violation. There you go. Anybody like OSHA? They're so much fun. Privacy. So there was a privacy person, privacy czar, I don't know what we called them before, that worked for the state auditor that adopted all these privacy laws, right? That we have to now comply with in terms of when we have personal information, how we do that. We have to make sure we have training. We have to make sure that we keep that information private if we have utilities and there's account information, that kind of thing. It turns the privacy czar into the privacy auditor, grants that person more authority to do audits and to sort of enforce against agencies that aren't compliant with the new privacy rules. So make sure that you're compliant and working on getting compliant with the privacy rules. Okay. Q is for qualified jurors. There was this House Bill 49 passed this year that said convicted felons can't serve on juries. Now, some of you may say, well, that's logical, right? That seems fair. But remember, in Utah, felons can still vote, so they could still serve on juries, and this says now they can't. Unless it's been expunged, obviously. Okay, R is for roads. There were only 3 road bills. They're really housekeeping bills, removing and adding state roads or modifying the descriptions of state roads. House Bill 103 now requires that the Public Lands Office and CITLA both have to identify all the public roads that cross their property. And they have to take that and record that with the county, just like we would all our class A, B, C, D roads. And the other thing is they cannot close a road without the consent of the county legislative body. So This one's a good one, I think, probably just because it identifies what are going to be the public roads across those public lands. House Bill 345 just described the highway access for the new, for Lost Creek State Park and Utah Raptor State Park. I like this one. Spaceports. Senate Bill 62 created an exploratory committee for spaceports to look at the space launch services for satellites, scientific missions, defense missions, commercial space flights, space exploration, cargo transport, and space tourism. They appropriated $1 million for this. The picture on that looks like a horseshoe, that weird building, is actually a spaceport in Las Cruces, New Mexico. And of course, then I have Katy Perry and her recent space tourism flight. So we are looking at that for the state of Utah. All right, tax bills. Property tax was a big one. There were several bills on this. The school district mill levy now has some oversight by the State Tax Commission and the Governor's Office of Planning and Budget, which is a really interesting thing, because usually school districts can just levy a mill like everybody else. They do the truth in taxation and they do their mill levy just like the rest of the governmental entities, but they now have some oversight. Senate Bill 197 was vetoed. This is a bill that changed the way senior citizens get some tax relief. This is the bill that allows for some tax abatements if you have under a certain income, if you're over 65. They wanted to change that and take away the abatement and make it deferred. So the tax would remain, but it would just be deferred until you sell your house or die. And then it would still be charged against the house. That one was vetoed by the governor. So that status quo remains. Senate Bill 202 requires counties to report their assessments to the State Tax Commission and gives that commission authority over non-compliant counties. So again, counties now have to report their tax base, their tax assessments to the State Tax Commission. And it also removes the newspaper notification for tax increases or truth in taxation. But it requires that if you're going to have a truth in taxation hearing, you have to allow online participation. So if anybody's doing a truth in taxation hearing, just know you have to allow online participation at that public hearing. Senate Bill 295 reduces, this is a weird one and I hope I understand it correctly. If you reduce your budget to below what the previous year's budget is in order to increase revenues, it allows you to increase revenues without doing a truth in taxation hearing. Not exactly sure how that works, but if anybody understands this one better than me, please speak up. I'm hearing crickets. You're all asleep by now. Okay. Some other tax bills that came out in different categories. Sales and use tax. Senate Bill 40 is just housekeeping. It changes the grace period for certified sellers before they have to start reporting their sales tax. Senate Bill 47 removes the sales tax for personal property and electronic transfers of goods. Senate Bill 213 exempts energy storage manufacturers from sales tax. I don't know if this has an impact on anybody. It didn't necessarily affect me or my entity, so, I figure I'd throw it out there. How's that? The truth in taxation hearing requirements clarifies that you do have to have a quorum of your elected officials present during the truth in taxation hearing. I didn't even know you could do this, but apparently there were jurisdictions that were having the truth in taxation hearing and just sending staff to do the hearing and not attending. The elected officials were not attending. There wasn't a quorum of the legislative body attending. This clarifies that no, they have to show up. Income tax. Extends the income tax credit review cycle from 3 to 5 years, and then the Social Security tax, this is the one that increases the amount of money you can make, that you get that credit for your Social Security income. The transient room tax, there were a couple of bills. House Bill 456 clarifies and modifies what that money can be used for by counties. And it's similar, but they've sort of tweaked some of the definitions and clarified some of that. So if you're representing a county that's using those funds, make sure that you take a look at that you're compliant. And then Senate Bill 261 This is more reporting and oversight by the state, right? And that federalism, hypocrisy. So the counties now have to report their use of the transient room tax to legislative and fiscal analyst, who then reports it to the Rev and Tax Committee. Now, this is because of the Grand County issue, when they were found to be non-compliant with the way they were using their transient room tax. But now you've got some legislative oversight of that, but all counties have to comply. And last but not least, Senate Bill 91 imposes the 1% county tax for restaurant taxes on, gas station food, basically. Okay, here's the union bill. This was a picture out of the Salt Lake Tribune. I think it's the Unified Firefighters that showed up at the Capitol. But House Bill 267 is the one that prohibits a public employer from recognizing unions or engaging in collective bargaining. This goes in effect on May 7th. And I just read in the Tribune today that Salt Lake City just did a new collective bargaining deal with their unions. I think they have 3 unions in the city. And they just did it before this bill takes effect, and they're prohibited from collective bargaining. So they just inked new deals. The interesting thing for me on this bill was, you sort of had all these people lose their minds about the fact that they said no unions, but the reality is governmental entities have never had to recognize unions if we don't want to. It's always been optional. You could if you wanted to, but we don't have to, and that comes from a case way back in 1978. I put the case up there, the Wesley case versus Board of County Commissioners of Salt Lake. And the Supreme Court basically said, because we have merit systems and because we have legislative protections in place for public employees, that governmental entities do not have to recognize unions if you don't want to. And it doesn't matter how many members of your staff vote to unionize. It doesn't matter. You don't have to recognize them, and you don't have to collectively bargain. But if you wanted to recognize them, then you could, and Salt Lake City obviously has done that. This bill prohibits it flat out. But this is also the bill that is going to probably be subject to a referendum if the signatures that they submitted on Wednesday are sufficient and if they get enough votes. But it may be, because this is a statewide referendum, it may be that they need the 60%. Who knows? I don't know what the rules are going to be on this one, but it'll be interesting to watch. Senate Bill 327 reiterates again that private employees still retain the right to collectively bargain and unionize if they want to. Okay, we're almost done. V is for vaccine. They designated any kind of vaccine that's contained in a food product as a drug. All I could think about is when we used to get, for those of us that are really old, that the polio vaccines were given in sugar cubes. I don't know if that's what they were trying to address. That's what the picture's of, is when you got your polio vaccine, it was in a sugar cube. But this basically says if you're going to put a vaccine in a food product, then it's counted as a drug and has to be regulated like a drug. Okay, water bills, these, nothing really significant. Water has been a big deal, and we in the South still don't have enough water, but these are really just housekeeping bills. You've got water quality and dealing with water applications, what happens if you transfer water in probate, some grazing and watering on public lands bills. House Bill 274 deals with water rates and setting the water rates that may or may not apply. And Senate Bill 80, DEQ can establish some fees for water quality, but there are some exceptions for, again, water districts that probably don't have to pay those fees. Okay, X is for the RX, and again, this is the pharmacy bill that goes with the fluoride bill, because pharmacists now are allowed to prescribe fluoride. This bill then changes the way we treat pharmacists and allows them to be a healthcare provider that can prescribe things. So they sort of worked in tandem because we're allowing pharmacists to actually write prescriptions for fluoride. Okay, Y is for youth services. How many of you guys, your jurisdictions, operate any kind of Little League sports or youth programs? Raise your hands, anybody? Okay. This will apply to you most likely. What it basically does is says because you really should run anybody, if you've got employees or volunteers that are working with your youth, you need to run them through a criminal background check, including all the sex offender registries. Therefore, you can require that they give you their full name and ID so that we can run that information. Obviously, if you're an employee, we're going to have that. If you're a registered volunteer, we're going to have that. But this allows us to require that. And you probably should do it, is all I can say. Yeah? Correct. So if you heard that, running the background check is required. What this bill does is says we may ask for the full name and ID of the employees in order to run that background check. Makes no sense if the background check's required anyway. But he's right. If you fail to run the background checks on these people working with children, then you lose that presumption that you're not negligent. So it's really important to do that. Okay, last but not least, Z is for the bzz of bees. This one cracked me up, so I had to put it in there somewhere. It now creates a veterinary client-patient relationship with bees. Please, somebody tell me for the love of all that's holy, why? I don't know, but that's what the bill does. It establishes a veterinary client-patient relationship. So there you go. We will see what next year brings, but hopefully I'm even early a little bit, just a little bit. But thank you very much for inviting me back. Hopefully you weren't too bored, and we'll maybe see you again next year.
We're going to get started with our last session. We are privileged and honored to have Martha Knudsen here. Just a little bit of background about Martha. She is a lawyer, speaker, and consultant pioneering the integration of well-being science in the legal field. She implements evidence-based strategies to enhance professional success and has collaborated with clients like the Utah State Bar and the Utah Board of Pardons and Parole. She began her legal career after graduating magna cum laude from law school in 1999. She excelled in private practice and as general counsel for a national real estate management company. In 2015, she earned a master's in applied positive psychology from the University of Pennsylvania, later working as a member of the program's teaching team. She's a practicing lawyer and frequent speaker, serving on the board of the Institutes for Wellbeing and Law and other prestigious committees. She was honored with the Utah Legal Wellbeing Impact Award in 2023 as well. And no pressure, Martha, but this is the one I've been looking forward to for the last 2 days. So let's welcome Martha Knudsen, please.
Well, thank you for that nice introduction, and seriously, no pressure. Very nice. It's very nice for me to be here, and I know I'm the only thing standing between you and your weekend, so I will do my best to make this worthwhile for all of you and to send you off into your Friday evening on a high note. All right, so you heard a little bit of my bio, but let me tell you a little bit more about how it is that I went from law to mental health and well-being. By the time I was about my third year as an associate in a law firm, I was already on the burnout train. I was anxious all the time. I was disconnected from my friends. I was very cynical about life. And I just remember sitting at my desk and just thinking, I'm going to grow old behind this desk. Is this all there is? Is this seriously what I signed up for? I went on like that until I got to my 10th year in private practice. I was a litigation partner, and I was absolutely miserable. I would have to bargain with myself to get myself to bill like a half an hour. I know you guys don't bill in that same way, but it was that, okay, Martha, if you can just focus for half an hour, you can play solitaire on your computer for 10 minutes. Seriously, right? And so this is me flogging myself through my day. And, so I got to that point, and I had my first kid, and I'm like, oh, sweet. Nathan is the perfect exit strategy. And I took it. And honestly, when you are more excited about your maternity leave because you don't have to work for 3 months than you are about your kid arriving. But I was. So, I got talked back into the practice of law not too long after to go and work as a general counsel for this real estate management company. And as I did that, I thought how can I do this differently? How can I love what I'm doing and be good at it? And so I started looking. I started doing research. All good research is me search. And I realized that, my whole way along my 10 years in the law firm, I had just really taken the approach, which I think a lot of us have coming up, is that, if you want to do well, you can either do really well professionally or you can be well personally. And I put all my eggs in the do well professionally basket. And it worked great until it didn't, right? Till I'm at year 10 and I've just screeched to a halt. So I went out looking, doing my research to see what happy, productive, successful lawyers do differently. And this was 2010, there wasn't a whole lot out there. But what I did find after a lot of looking was the science of applied positive psychology, which is the science of human thriving and performance. And what I learned is that I had been making a false choice. I had been thinking it was either I could do well professionally or be well personally, and that's not it at all. Overwhelming amounts of scientific evidence tell us that if we are well in our lives, if we're taking care of our health, if we are engaging in the things that science tells us that keeps us healthy mentally, then everything else, like, we do better in our profession, especially in areas like the practice of law, where it is so cognitively focused. We deal with stressful things, stressful people, high stakes matters. We do better professionally if we are well personally. So that's what took me back to school, and what brings me to being so passionate about working with lawyers and other legal professionals in this area, because I wish that I would have had somebody talking to me about this kind of stuff when I was coming up. So that's what we're going to talk about today. We're going to talk about the relationship between mental health, well-being, and having a thriving, sustainable, successful, and enjoyable practice. We're going to discuss what well-being means, why it matters, and what science can tell us about how to make more of it for ourselves and our colleagues. And we'll also spend a little bit of time on some common roadblocks so you can spot it if and when it comes up for you and know what to do about it. And then to finish us off, I'm going to dive into some strategies that you can start doing today to start making some, tweaks to maintain or enhance your well-being. So, okay, I just am going to take a little bit of a poll here of the room to kind of just see where we are. All right, when I say the phrase physical health, what pops into your head? You can call it out. Exercise. What else was over here? Exercise? Diet. Okay. Sleep. Skinny. Okay, anything else? Okay, cool. What if I say mental health? What pops into your mind immediately? Therapist? Depression? Medication? Stress? Anything else? Come on, you guys are like criminal folks. The what? Mindfulness? Ooh, outlier. Okay. All right, so now I just want us to think about this. When I said physical health, nobody's calling out broken bones, cancer, diabetes, right? That's a part of physical health too. And it's the same thing with mental health. Okay, mental health is so much more than medication, depression, anxiety, the disease state, therapy. All those things are part of mental health, but that's mental ill health. Mental health encompasses all the best things about being a person. It is, meeting a challenge. It's the joy you feel when you're with people you love. It's positive relationships. It is positive emotion. It's fun. It's the things in life that really matter. So just like physical health, it's a spectrum, okay? We got physical health that you are, crushing it with all of your, your blood pressure is great, you're healthy, you're running, whatever, and then over here, you're like barely hanging on. Mental health is the same way. It goes everywhere from thriving to barely surviving and everywhere in between. So, newsflash, if you are a human being, you have mental health. You have mental health all of the time. You do not get to opt out, and arguably it's the best thing about being a human. So it looks kind of like this here. Right, so here's our spectrum. And we all sit on this spectrum all of the time. And, we'll move up and down, like more towards maybe thriving, or, the next day maybe we're having a harder day, we move, we're just kind of coping. And that's really normal, right? Stuff happens in life, we deal with it in certain ways, and we go up or down. And where we sit on this spectrum has a lot to do with the tiny little small habits of thought, habits of interaction, habits of coping, if we're coping with things in a healthy way or a maladaptive way, habits of relationships, right? It's the tiny little things that add up to make a life that can either help us maintain our well-being, or it can help us progress more towards thriving, or over time, we can find ourselves down in the red as to just barely surviving. I mean, most people don't jump all the way to barely surviving overnight, right? It's the little small things over time that happen. So that's what we're talking about today when we're talking about well-being. And it's really a continuous process towards thriving in all dimensions of life. So this is not just yoga and meditation. Both are great things. Both have an important place, but it's all the small things we do in all the areas of our life. And we'll talk more about that. So as we think about the things today and the strategies, I want you to really focus on small is all, right? We're talking about micro moves that over time support us or not. So, and along this here, okay, we're on the spectrum. We're trying to do things to keep ourselves healthy, but then we have stress coming at us, okay? And so how we handle the things coming at us with the practice of law and with life, what are those little habits of thought, of coping, of interaction that we just fall into? Are they healthy and help us maintain? Or are they, we all have a combo of adaptive and maladaptive coping mechanisms. But are we leaning too high on the maladaptive mechanisms? And how you do that is how you stay resilient. Okay, also I should mention, I'm really informal, so if you have questions or comments or, please shout it out or raise your hand or whatever's appropriate. Okay, so where we sit on this spectrum has a lot to do with our ability to practice law in a healthy, sustainable, and competent way. So here you can see your spectrum on the top, and these are all correlations, scientific correlations between where you sit with your well-being and how, and all these things we care about as people and as lawyers. So on the right-hand side here, we see when we're thriving, we see better physical, mental health. If you're an organization, you're going to see less turnover. Our brains work better. I mean, that's our moneymaker as a lawyer, right? Our cognitive functioning, our memory, our creativity is higher. We're able to handle stress better relationships, and here we see greater professional identity. And that's really a sciencey way of just saying civility and professionalism, right? So on the flip side, we see the opposite. When we're having a hard time, when we're not taking care of ourselves, when we're dealing with mental ill health, it can make all these things more likely. We are higher risk for these things here on the barely surviving side of the spectrum. Now, I just want to make it clear that none of this is to say if you, like me, deal with certain mental ill health diagnosis like anxiety, then that doesn't mean you can't be an awesome lawyer, right? What it means is that you need to get out ahead of it and do things to keep yourself healthy in that realm, okay? And if you don't, it's really so you can climb a mountain, okay, with a backpack of rocks, but it's a whole lot easier if you didn't have that backpack of rocks. That's the, taking care of any kind of mental ill health situation you might find yourself in. All right, so what does this look like in the practice of law? Betting that there's a lot of things that you could probably think of as we talk about it, but it can look like not answering client phone calls or not returning opposing counsel their messages back. It can look like not last minute continuances of a trial, not showing up for court, missing deadlines, being really aggressive, or low civility with your colleagues. That's how some of this stuff can show up in the practice of law. And because of this, our Supreme Court has added a comment to our duties of ethics and professionalism. Here, I'm trying to make this work up here. There we go. Okay. So I'm not going to read all of comment 9 for you. You can do that yourself. But basically what the court is saying is that caring for our mental, physical, and emotional health is a component of competency, of being competent to practice law. So, this is really emphasizing what the science says, that if we are healthy, if we are taking care of ourselves, then it really does help us to be competent attorneys. So you'll see here that it says mental, physical, and emotional health. Normally with lawyering, we think about our mental, like our cognitive health. But, our bodies are vessels to engage with the world, and our physical health along with that has such an impact on our cognitive health, and so does our emotional health. We don't get to put our bodies away and leave those, to the side. We carry this with us. It's how we experience the world, and if we're not taking care of ourselves, it's going to experience how we practice law. Okay. So this here is just in case we think that here in Utah we just live in a bubble of joy and happiness all the time. This is what the data looked like we gathered this in 2019. There's another tranche of data post-COVID that is being analyzed right now to see how we're doing, but this is what we looked like back in 2019. So, these numbers aren't great. Almost half of us have some level of burnout, which is the same or higher than other places in the country and definitely in the world. In the world, it sits at about 22% of working professionals have burnout. Here, we're almost half. 44% report symptoms of depression, and that's 4 times the rate of the general working population. Across the board, we don't show statistically higher alcohol use, which is not surprising given where we live and the population. However, we found buckets of the legal community where we did see it, and congratulations, that is, we're seeing higher levels of alcohol use or alcohol abuse in the criminal litigators, family law lawyers, and civil litigators. And this one here at the bottom is something that worries me and should, worry all of us. We found that Utah lawyers are 5 times more likely to report thoughts of being better off dead or hurting themselves as compared to the general working population. So that's suicidal ideation. And just so you know, the risk with that, so the risk of being a lawyer in Utah and developing suicidal ideation is greater than the risk of smoking and getting lung cancer. So, there's more of us than not that aren't experiencing these things, right? But what this is a canary in a coal mine that we need to be making some changes for us, how we deal with things as individuals, but also as a collective and as a system and in our organizations to turn this around. And if this isn't you, this is someone you know. And you probably don't know that this is going on, right? But these are our colleagues. This is our community. And there's always pain in the room, anywhere you go. So, this is just something to remember. Yes?
Criminal litigators, is it separated between prosecutors and defense attorneys, or is it across the board?
Just across the board. The questions asked didn't drill further down into, which side of the aisle. But that'd be interesting, definitely. Okay, so I don't want to dwell too long on these numbers. I want to talk about the positive stuff because well-being, like that spectrum, is far more than just the absence of things we don't want, right? It's really building the strengths and resources and connections that we know can help us thrive and help our abilities in the law really sing. So we are about to get there, and before we do, though, I just want to touch on two different things to think about that we're all at higher risk of in Utah, being lawyers, and one in particular that you folks, I'm sure you probably had training on it before, and you may have experienced it, so I just want to mention it. So the first one here is burnout. Okay. All right. And does this, anybody relate to this? This was me, okay? And burnout is not an individual failing of stress management. Burnout has as much to do with the organizational situation and your professional community that you're in. And it is characterized by emotional, physical, and mental exhaustion. So you walk around like being exhausted more often than you're not, which I'm sure some of you can relate to this. It also comes with a heaping helping of cynicism and depersonalization. So this could look like somebody that used to love working with. Now the very fact that they breathe next to you as they pass you in the hallway, or they just grates on you, and so you start to pull back because you don't want to be around any of these people, or you're depersonalizing your clients or witnesses or victims in a case. And then there's the third bucket, which is a complete loss of professional efficacy. This is me, my 10th year, when I'm like, oh my gosh, when I'm bargaining with myself, right, to bill a half an hour. And what happens with lawyers is that we are incredibly amazing at continuing to crush the efficacy box when we are really exhausted and we are really cynical and disengaged, okay? So, but those of you that might find yourself in that place, you're at the highest risk of complete burnout, because when you get to bucket 3, you'll fall off fast and hard like I did, and a lot of the times it takes medical and mental health professionals to help kind of pull you out of that. So what we want to do is we want to put strategies in place before we ever get to any of these stages of burnout. So it's part of your habit. Like, when you take on a new job and things are great, or you have a new project and you love it, you have all this energy and you put all this time into it, and you're like, this is awesome. I don't need to worry about this stuff. I feel great. That's exactly when you need to worry about putting healthy habits in place, because stress and time and pressure come for us all. So we want to put this stuff in place at the get-go. So that's burnout. And the other one, as I am confident you all know about, is secondary traumatic stress and compassion fatigue, which is a risk for all of you in your profession. And this is, you see a lot of hard things. It doesn't matter if you're a prosecutor, doesn't matter if you're on the defense side. You're dealing with some of the hardest things that can happen to people. And, could be is anybody here on the defense side? Yeah, okay. So, right, and I'm sure, no, and I'm sure it's the same thing, but with prosecutors, it's a lot of times when you have these cases, it's human wreckage on all sides, right? It's like your perpetrator oftentimes has their own victimization and different things that happen to them. I mean, you're hearing stories, listening to witnesses, looking at videos and photographs, and that kind of stuff can take a real toll on you emotionally, and it can take a toll on how you view the world, which then in turn can impact your well-being. So pay attention to these kinds of things. So if they come up and they start showing their head, you can get out ahead of it, get help, take care of yourself in a way that it does not derail you. So for all of those things, burnout, secondary trauma, and compassion fatigue, these are some of the symptoms of distress. that you might notice. And everybody kind of has their go-to that that just happen for us. For me, I notice that when I am struggling with something or I'm feeling more burnout or heading down that path, anxiety will pop up for me. I'll get down. I will want to isolate from my friends and family, and I get really irritable. So, I've been around the block enough times now, so if I start seeing these happen over a series of days, I'm like, what am I either not doing that keeps me healthy, or what do I need to stop doing that is hurting my health? All right, so let's unpack this a little bit further, and how do these things really happen, and what is it that we can do to kind of balance this out in a healthy way? Okay, so that means a discussion about stress. So when I say stress, what's everybody's overwhelming feeling about it? You get stressed about stress, right? Because, is it a negative feeling overwhelmingly? Yeah. But I think, if you're going to Google stress right now, you probably see articles that pop up that are like, 10 ways stress is going to kill you. And it's like, ah! So, we stress about stress because it can be challenging. Overall, though, stress is really just a biological function that's neutral, that is designed to help us meet the challenges of a situation, learn from it, and get better at it the next time. So the thing about stress, though, is not that stress itself is bad, because stress is associated with heart health, with better memory, with better relationships, with longevity, with better immune systems. The key, though, with stress is that how long it lasts, right? So, we want to pop up into stress at the appropriate time when it's actually useful, use it to fuel our brains, to fuel our bodies. And we've all had situations where you go into a situation or a hearing or something, and you're like, where did that come from in my brain? I just pulled that out, and that's the stress response doing its job. And then you want to recover from stress, and what stress does, it wires your brain so the next time you go into that, it doesn't freak you out in the same way. I'm sure everybody now thinks that stressed you out or freaked you out when you were a new attorney probably don't raise much of anything anymore, okay? That's the stress response at work for you. The problem with stress is that we bounce up into it and we live there. We don't ever recover, right? It's just one thing to the next, to the next, to the next, and so we're living up here instead of coming back down to baseline and really working to regulate our nervous system. And if we live in stress over time, that is where you start seeing, physical health problems, association with mental ill health. It's because we live there. And frankly, if you're up in stress all the time like that, studies show that you get dumber. Your body's trying so hard to get you back into equilibrium that it spends all this energy and time doing that instead of you being able to use your cognitive functions. So stress, that's just the primer on stress. And our stress levels are affected by a lot of things. And one of them is our own perception, okay? The way that we view the world and think about things impacts just how much will pop up into a stress response and how long we will stay there. Okay, and our perceptions are influenced by our background, our experience, right? So for you folks, you see a lot of hard things, read a lot of hard things, and where I might be like, oh cool, I'm gonna put my kid on Santa's lap. You guys might be like, no, Santa is a pedophile, I'm not doing it, right? So it's just, but that's your appraisal based on your experience, and so that's gonna freak you out where it may not freak somebody else out, but it's still gonna play with your nervous system. And it's also based on what's happening around us, how other people are acting towards us, the systems that we're in, and then what we think about all that. So the point of this is to say that when a situation happens to us, a challenge, then we do this really quick assessment. We don't even know we're doing it, okay? We are quickly assessing the circumstances of the challenge, okay, what the demands of the situation, and also doing a quick tally of what resources we have to meet it. And if we are resourced, we perceive that we have the resources to meet the challenge, okay, then we're not going to go into stress as hard and we are going to recover faster. But if you have the demands of a situation and your perception of your resources are low, you're going to be way more stressed and you're going to live there longer. Does that make sense? And this is a way oversimplification, but it kind of sets the groundwork for what we're going to focus on. So, okay, with burnout, compassion fatigue, secondary trauma, you know, some of the mental ill health, occupational hazards that we might face. This is kind of what's happening. So remember, like, we're assessing the demands and then we're also assessing our resources. So on this list here, you see some of the job demands that research tell us put us into stress higher and have a real negative impact on us. So just let you take a look at that. We have, we're going to dig into a few of these in detail. So we have lack of autonomy. It could be high workload or work pressure, you know, without resourcing. It could be just feeling like you're not supported, feeling like there's unfairness. This is all from lawyer research, by the way. Values disconnect. You're doing something that does not align with your values. You are not getting any kind of appreciation or thank yous. You are not recovering from stress. That's the nervous system piece. You're not giving yourself time to regulate your nervous system. Could be exposure to trauma and the rest. And now our resources are kind of the flip side. You know, it's like, do we have positive relationships and high quality relationships with our colleagues? Are we taking care of ourselves? How's our thinking? Like, are we minding our mind? Autonomy, do we have support? All of these, okay? So as we look at these, how many of these are a individual thing and how many of these are an organizational thing or a professional-wide thing? So I will tell you the answer. You know, there are more of these that are, there are more of these here that are organizationally related than they are individually related. So what that means is that we co-create the conditions that can help us be well and protect us from some of these occupational hazards, right? So as an individual, we have our responsibilities to try to recover from stress, to take care of ourselves, to cultivate meaningful relationships, right? To think about your thinking, mind your mind, those kinds of things. And we also have a responsibility to the others that we're working with to, you know, communicate in a way that is going to support their well-being, to give recognition, to have transparency and fairness in our organizations. So we're all the time, you know, bouncing off each other and how we create the conditions to thrive. So lawyer well-being really is an individual and an organizational matter, okay? It's the me and the we. We all have a responsibility together to create the conditions to help us thrive. And I'm going to back up once more to this. So what I see all the time when I talk to organizations, individuals, and different legal professionals is that there's so much on here where we're creating unnecessary stress for each other and for ourselves. I mean, seriously, how hard is it to go and tell somebody, like, well done with this, or to give some support or some feedback? Okay, we're creating unnecessary stress that if we would just pick our head up and maybe question the way we've always done things when it comes to our organizations and how we relate to one another, we would eliminate a lot of stress like that. I mean, the practice of law is stressful. That's not going to change. We're not going to change the way the courts operate or the criminal justice system operates or deadlines or those things anytime soon. But there are things that we can change that do make a huge difference over time. Yes?
So the third one down on the right-hand column, healthy thinking habits.
Yes.
That's a job resource. I'm trying to think, how does an organization create healthy thinking habits? What do those look like?
Okay, so healthy thinking habits, that is more of a individual resource that you can use for your job, right? That is a well-being booster. And it could be that, so everyone has ticker tape thoughts running through their head all the time, okay? You might be sitting here and just stop for a minute and think about what you're thinking. It could be, I'm so bored. It could be, I screwed that thing up at work. It could be, some comment about yourself or your body, positive or negative. It could, whatever it is, right? And some of those thoughts are healthy, some are neutral, some are very unhealthy. Like I could be up here with a ticker tape thought like, okay, I suck. I didn't do that, I didn't do this, I didn't do that. And if I get caught up in those thoughts, how does that make me feel? And how does that, so it's those kinds of things. It's our healthy thinking habits. And we'll dive into that just a little bit more in a minute. But a lot of this stuff is things that we have control over in our systems, in our organizations, and individually. All right, shall we talk some strategies? Okay, let's see. All right. There's 3 main strategies: cultivate awareness, meet our psychological needs, and care for your human. And Chris, you were right, you are like leading, it's like we planted you in the audience to move on to the first one. Okay, so there's a lot of different scientific-based strategies that we can all use. I picked these because these are things that I'm really paying attention to now. I recently took on some projects for an old client of mine, and so after not practicing law for a decent amount of time, I find myself dropped right back in at a high level in trying to quarterback some very high stakes litigation for this company. And so it's been really interesting for me because I've gone from spreading well-being and working with lawyers in what I feel is a positive way to suddenly I'm in it again. And so it's like, instead of being the frog in the slowly boiling water, I'm the frog that got dropped right back into the boiling water, and I'm like, wow, right? So this is the stuff that I am doing right now as I finish up these projects to keep me level and healthy and being able to do that slice of my work in a way that is competent and successful. All right, so the first thing is cultivate awareness. Okay, and there's 3 things we're going to talk about here. Number 1, being aware of what's happening at any given time in your thoughts, with your emotions, and in your physical body. Okay, this might sound, this is simple, but it's not easy, right? So but it is really foundational. If we can pay attention to our thoughts, we can cut off thoughts that are unhelpful or harmful or not true, okay? If we pay attention to our emotions, we can better regulate them. And if we pay attention to our physical body, we can better know what's going on with us and take care of what we need in that moment, okay? So we're gonna do a little exercise. All right, everyone just take a breath. Okay, put your feet on the floor. And I'm not going to take you through a meditation because I'm not trained for that. But meditation is a great way to become self-aware. Anyway, okay, so I just want you to think of what are the thoughts that are running through your head right now? These could be, I can't wait until this is over. It's the weekend, what am I going to do? You could maybe have your to-do list running through your head, or you could be worried about something that happened in the past. Who knows what your thoughts are, okay? So pay attention to your thoughts. Now think about your emotions. Do you know what emotion you're feeling right now? Can you name it? Are you connected to how you're feeling emotionally? We are really good as lawyers at cutting that piece off, but emotions help us actually reason. Okay, there's that. And then what's going on in your body? Anybody clenching their jaw? Are you tight around your face? Hunched shoulders? Anything like that? Or are you calm and relaxed? Okay? So knowing what's happening with all these things allows us to make adjustments. I'll give you an example of what's happening with me in my new foray into the practice right now. All right, thoughts. I have a recurring case of imposter syndrome, right? Which is a cognitive distortion. And it is something that comes up for me oftentimes in time of stress, okay? Does it mean that it's true? No, but I will have these thoughts come up during the day sometimes when it's something really challenging or new, which is like, they're gonna figure out you don't know what you're talking about. Today's the day, you know, even though I was like, been successful in my career, like all the things, but that still comes up. The jig is up. Oh no, based on that one last turn of that contract, they're gonna know. I mean, you know, and so I will notice when that comes up because it's tied to how my body feels. Like I'll be clenching my jaw, or my face will get really tight, or I'll get like all hunched on my shoulders. And so if I'm paying attention to that, I'm like, okay, what am I thinking about? Is that true? No. What's the evidence? Okay. What do I need right now? Okay, I need to get up, take a walk around the block, listen to some music, do something to help me reset. And that's one example. It could also be with emotions. You know, we have big spikes of emotions happen in our practices, especially I am imagining for you folks, you know, with the high stakes things that you're dealing with people. And sometimes those emotions can take us over and we can react rather than respond. Okay, so if we know what's happening with our emotions and we can actually name it, it's this thing called name it to tame it. You can say like, I'm really angry right now. Or like, I'm really anxious, or, you know, I feel disrespected, or whatever that is. Even just recognizing it and naming your emotion de-escalates how prickly it is. It switches the place where it is in your brain and allows you to better respond rather than react. So being able to have an idea of where you are in your body during the day can be so helpful. And we can cultivate this through mindfulness meditation. That's a real big part of why mindfulness is helpful. Okay, any questions about that? So awareness, okay. Now the next piece of awareness I want us to focus on would be this one. How round is your circle? In your materials, and you can use this right here, is this chart. And this is, hey, how am I paying attention to all of the dimensions of my well-being? Okay, am I well-rounded with that? Am I doing things to resource myself in the areas of well-being that we know, or, you know, the areas of life that we know lend itself to higher well-being? Or am I just, you know, focusing all my eggs in one bucket? So around this chart here, these are all scientific areas that tons of research has shown that if we are proactively paying attention to them, our well-being is higher. Okay, so this exercise is to go around that circle and pick a number in each circle about how well you think you are doing in that area. Like, how are your relationships? Paying attention to them? Are you connecting with people? And this is not just professionally, but personally. Okay, so you go around this whole circle, and then once you're done, you go from one number to the next, and you just kind of draw a circle. So the idea is that we want to raise the levels in each of these areas to try to make our circle more round. Okay, this is going to look a little bit different for everybody. And for some of us, like I find accomplishments, I can crank that up to a 5 all the time. And my relationships sometimes can drop down to like a 3 or a 2. And so what I need to do for me to be more well-rounded is I need to dial back the accomplishment piece and dial up some of the relationship piece, because the relationships help me stay healthy and well-rounded. Yes?
I'm willing to bet that if I went through and gave you my numbers,
Mm-hmm.
and then I asked somebody that was close to me and knew me
Mm-hmm.
for those numbers, they would be vastly different.
It's possible. Yeah.
Which one's more important, my sense of delusion or their accurate assessment?
I think both are, right? Because you create your inner world and your life through the stories that we tell ourselves, okay? We're just walking narratives, all of us are, all the time. We're telling ourselves stories based on our beliefs, our perceptions, and the rest. And I think it can be very helpful for us to take a hard self-aware look at what those stories are. That's our thoughts, emotions, and how we think we're doing. And it can be incredibly valuable to have somebody reflect back to you on their perceptions. So it's really not one's more accurate than the other. It's just a combination, and then being able to have the sense of self and sturdiness to take a critical eye and look at what those things are. Does that help? Okay. So I suggest, pay attention to how round your circle is. This could be something you do every week, every month, every so many months. And if there's an area where you really, or it's falling off, like maybe it's positive emotion, maybe all you're feeling are really challenging emotions. Okay, that doesn't mean to stuff your challenging emotions or ignore them. That just means like, hey, is there a way that I can like maybe move through them and find opportunities for me to build some, some good vibes, some good emotions in my life. Okay, let's pass through this one. The next self-awareness thing is, remember the check engine lights, like the stuff that the signals our body and brains tell us when, things are not quite right. Okay, we're incredibly smart as humans. Our bodies are so smart, our brains are so smart, our emotions are so smart. They're all things that give us an idea of how we're doing, okay? So these are very normal things that happen when you're under a great amount of stress and you don't have the resources to deal with it, or you're not taking care of yourself, okay? This is very human, very normal. We all have some of these things. And we all have our go-tos. I told you before that my go-tos are anxiety, I cave away, I start getting really ornery, and my family doesn't like being around me. So, now it's like really quick for me to be able to be like, okay, I haven't gone running, or I haven't been sleeping, or I haven't been doing this, or I haven't done anything fun for a while. And then I haven't talked to a therapist for a while, whatever it is to help me get back on track. These are just signs, if we're self-aware, can help us pull ourselves back to center and maintain our well-being or move towards thriving. Okay, strategy number 2. All right, this is meet our human psychological needs, okay? Humans all have 3 basic psychological needs, at least 3. And we know this because of thousands upon thousands of studies done across different domains in all different parts of the world that look at what do humans need for motivation, for well-being, for optimal health, okay? Has anybody ever heard the self-determination theory? Maybe read the book Drive? Okay, but that's what this is from. And the research shows that there are 3 basic ones: connection and belonging. And this is our need to feel cared for, connected, and a sense of belonging in groups that matter to us. Humans are incredible hivish creatures. We need each other, and if we perceive we don't belong, or if, it actually registers as physical pain in your brain. It's the same part of your brain, okay? Belonging and the satisfaction of that is incredibly important. The second one is the competence, or like that self-efficacy. It means we want to feel effective. It means that we want to be able to use our skills to effectuate change in the world and things that are important to us. We want to feel effective and capable. And this has also has a subjective component to it. And that's the self-efficacy. It's not just the subjective skills we have, it's what our belief is and what we can do with it, okay? So there's that piece, if that's fulfilled, that is something that lends to our well-being. And then the last one is autonomy. And this is our sense of volition, that we are acting in alignment with our values, what we value because we value it, not because an organization told you, anybody else told you what you value. It's because you value it. And living your life and doing your work with authenticity and having control over what you do. So those are the 3 ones. And this has been studied in lawyers and law students. So this here reflects some findings of all sorts of different lawyers across all sorts of different kinds of practices and vintages of practice. And they were looking at what makes lawyers happy, what makes lawyers engaged and like their job and motivated, and what makes lawyers have higher well-being. And so this is what they found. Now, in social science research, anything that is statistically correlated at a 0.1 or above is considered to be statistically significant, okay? So here we are seeing, I'm gonna have to walk over and look at this. All right, so here we're seeing make partner at a point, let's see, no, there's a 0 correlation in that one, right? And everybody will be happy to know also that law review and class ranking has a 0 correlation to all the things that make us motivated and happy. So we have attorney income. I mean, that's not nothing. I think, what is that, around a 0.1, 0.19? Okay, that's not nothing, but let's look and see autonomy, connection, competence, and autonomy support. Autonomy, I think, is at a 0.66. Those are monster numbers. You don't see that in scientific research. What that tells us is that having our need for autonomy fulfilled, feeling like we have autonomy and volition in our lives and our careers, is incredibly important to our health, our well-being, our happiness, our motivation, okay? And close behind that is connection and belonging, competence, and then something that's autonomy supportive. And we're gonna dig into this autonomy supportive a little bit, and that is, are you helping others in your work organization feel as if they satisfy their sense of volition, alignment with their values, giving them a sense of choice, okay? And that is a way that we can help each other raise our well-being. So what does that look like, okay, for us here? Well, this one here, you know, it's asking yourself, first of all, getting aware of, like, what are your values, you know? What matters to you? What matters to you about what you do as a lawyer? What matters to you as a person? And is your work and your expression of work, is it in alignment with that? Does it satisfy that need? So, you know, as lawyers, we have a bazillion different ways every single day that we can act out of alignment with our own values. You know, it could be that, you know, I have a deep value or a deep internal value that of honesty or of, I mean, we'll use that honesty, but yet sure could be easy for me to pad my billing, you know? And yeah, one time's not gonna be a thing, but over time, if that becomes something, I'm not acting volition with that, right? It could be being asked to do something that is outside of your own value system, and that can be a challenging thing in the law. It could be how you're treating other people is not in alignment with who you are as a person and what your values are. And, you know, those things over time really do take a toll in our ability to engage in the practice of law in a way where is meaningful to us and we feel like we're doing something that is an expression of who we are. So pay attention to that. Get clear on what your values are. And I'm not talking Sunday school values. It could be any kind of value you might have, right? Just as long as it's authentically yours. And just keep in mind, is your work in alignment with that? And do you have, do you have choice in what it is that you're doing? Do you have choice in where you work, when you work, how you're doing your job? Those kinds of things can be incredibly important. And that can be limited also based on your position or how long you've been out. But within that, do you have choice? And if you're a supervisor, are you giving choice where appropriate to your people, and helping them feel like they have that? And with respect to autonomy and values and being autonomy supportive, it could be that you know that one of your people has a real deep passion for protecting the rights of some population, or working with victims of a certain kind of crime or anything like that. When you're giving them work, you can connect into that. Like, hey, I know this is incredibly valuable to you, these people, and I think this is an opportunity for you, and you're so good at this, to connect in with that, right? That takes 30 seconds. That's a way to really build your people up with respect to all of those things. All right, so how does this really work in an organization? I'm guessing a lot of you people here supervise others or have. Okay, all right, so this is another study that was done, and it's the connection between lawyer well-being, our individual well-being, and how it's affected by our employer. What we perceive, again, there's that perception, what we perceive that our employer values, okay? That's, again, the me and the we and perception. So they looked at, they surveyed a ton of people, and this was in California and DC, actually, 2022. And there was one group who perceived they were valued for who they were as a lawyer and as a person, for them as their authentic self, and for their professionalism and their skills. The second bucket is people that thought that they were only valued for their productivity or maybe for the dollars in the door. And the third group was just like, I don't know, either they don't feel valued or they have no clue, okay? So these are the three main buckets, and this is what they found. So one of the things they measured was overall health. The best health are those who perceive that they were valued for their authenticity and who they are as a person and their professional skills as a lawyer. Okay, that's a lot higher if that's your perception. Okay, and keep in mind, these are people in the same organizations that are falling into all three of these buckets. Okay, the middle health, they're the second worst health, is lawyers who just thought they were valued because they got stuff done or brought money in the door, okay? And the worst health are those that were like, I don't know, okay? So that's health. All right, let's look at perceived stress scores, okay? Those who felt valued for their authenticity, like that autonomy, kind of supported feeling, their professionalism, they had the lowest perceptions of stress. Okay, think back to those categories, the stress demands, stress boosters, okay? This is all perception on how they perceive if they're being recognized, if they are valued, right? That's perception. Okay, the second one is the middle stress, productivity only, and the highest stress are people that are they have no idea if they're valued at all. So what are the takeaways with this? Does this mean that you either have to, pay total attention to the person and their authenticity and like that whole belonging and welcoming and your professional skills and all that versus, paying attention to get stuff done? No, it's not a mutually exclusive kind of a thing. The takeaway with this is really like, we need to think about what are all of the touch points during our days with our colleagues, with the people that we supervise, the people in our offices, where we can communicate value. And this is I'm not talking about the yearly review that you may or may not get, or that you may or may not give. This is on the daily, hey, thank you for, that memo. I really appreciated your perspective on that. Hey, good job over here. Hey, I really appreciated you staying and working on this. I mean, whatever it is that you can point out, like I noticed your strength with those witnesses. You're really good with those witnesses, you're perceptive, or however it is that we can communicate value to our colleagues, that's what makes the difference here with that perception. I mean, in the law, right, we have a really well-honed ability to issue spot all the things that go wrong. And we're awesome at it, okay? But it cuts us off from seeing all the things that go well and communicating them. Within ourselves, like celebrating our own wins, and with our colleagues. So, you know, instead of just pointing out when somebody's doing something wrong, catch people doing things right and doing things well. It can make a huge, huge difference in the well-being of yourself and others. Okay, and to bring us home, and this is probably actually the most foundational thing, the thing we should be doing every day, you can start doing it right now. Take care of your human, okay? This is not just a neck-up proposition, and the practice of law is not just a neck-up proposition. Our brains work better if we are taking care of ourselves. What are some of the things to focus on? Number one, rest and recovery, okay? Remember the stress response, the longer you're up in it and you live there, that's when you get sick, that's where you get dumb. So we want to bring ourselves back down to baseline. Let's really work on this competitive stress thing, like, oh, you think you only slept 3 hours tonight? Well, I haven't slept more than 1 hour in the last 2 nights. I don't know if that happens with you guys. I had a lot of that coming up in civil practice. Okay, sleep is important. Get your rest, take care of yourself, take breaks during the day, okay? We need to take care of our human. It makes us better at our job. It keeps us happier, more motivated, and healthier. All right, make sure you're moving. And this is, you know, not just exercising, because exercise is important, but get out of your chair during the day. Truly, sitting is the new smoking. I don't know if you've heard that or not, but being sedentary is associated with a lot of mental and physical ill health, stuff we don't want. And this scan just shows how your brain lights up after only 20 minutes of moving around. There's some really cool stuff in this, let's see. If anybody's interested, I have some books you can read on this, but experiments with high school kids where they got their heart rates up before they went into classes they were struggling with, and the kids that did these Tabata exercises, they closed the gap on their GPAs and everything so quickly compared to the kids that didn't do it. So movement makes us smarter. Our brains are built on movement, so get up and move. Okay, here's the sleep thing. If you're regularly getting less than 5 hours of sleep, it's like, I mean, basically you're shotgunning a 6-pack of beer before you go to the office. We're just more impaired. We need to sleep. Prioritize doing things that make you feel good. You know, have a hobby. Like, get your brain out of what you're doing. Do things that light you up, that make you laugh. Listen to music. Go and, you know, play games. Do whatever it is that lights you up in an authentic way. That is really important and it helps us weather the storm of when stress comes. And really, and we've touched on this a lot today, other people matter. If we want to be healthy and happy and thrive in the practice of law, we need each other to be able to do that. You can be the strongest little fish in the fishbowl, but if you're swimming in dirty water, you'll eventually go belly up and get sick. So, you know, think about well-being just for, not only for yourself, but for each other, because we are co-creating the conditions that allow us to thrive. Everybody should know this one. Makes you more anxious the next day, more depressed if you're drinking on the regular. It's not a great long-term strategy for stress because it creates more. If anybody has questions, come talk to me. I have some good resources. And then remember, we all have times where we're having a hard time. It's part of the human condition. Practice of law is hard, okay? So ask for help when you need it. Ask for help if you need help with work stuff. Ask for help if you want to talk to somebody about having a hard time. It's really important to do this. And the Utah Bar has made it possible for all Utah lawyers to talk to a therapist in a confidential, private way covered by the bar through Tava Health. You can use this QR code, and the bar pays for 6 no-cost sessions for you every single year, and then they reset the next year, and you can continue to see this therapist. You get to pick your therapist. You can do it online, like right in the privacy of wherever you want to be. It's incredibly effective. I have used therapy through my career. Even when I am doing well, I check in on a regular basis because it helps me stay well. Okay, it is a really important tool. And finally, we have Lawyers Helping Lawyers, where you can get connected with a peer. It's confidential, it doesn't get reported to OPC or anything like that, but it's a way to connect with somebody else in the law that's gone through what you might be going through right now. And this is not just like alcohol use as that's kind of what people think of, but it could be you're having a hard time with stress. Maybe you're really anxious, or you're depressed, or you're having a hard time with maybe disordered eating. Whatever it might be, you're going to find a lawyer that you can talk to, and it's really, really helpful. All right, well, I've gone a little bit over, or else maybe not. Maybe I'm right at the time. In any event, just in closing, you know, this stuff that we're talking about today, I threw a lot at you, and I just want you to remember, if you take one thing away from this, is that all these things are not things you do after, you know, you do everything you have to do with work. This kind of stuff is foundational. This is the stuff that helps you have a life you love, a career that you're proud of, and be able to do it in a way that's healthy and motivated and happy. So this is not an afterthought. This is part of your professional duties. Okay. If you have questions, hit me up. Here's my email. I'll be around here after if anybody wants to come and chat. And thank you very much for your time and for having me here.